The guy.
This is Ethan. Ethan had to go. Ethan shot me in the face.
Okay, so and then you go up and you punch Ethan?
Yeah, after he shot me in my face.
Okay, and then what happened? You guys grabbed each other? Was there a tussle?
He grabbed me. He literally grabbed me, and then I slammed him.
So you slammed him onto the ground?
Yeah.
And then what happened when he fell off?
He literally, we let him back up, because my brother was helping me work for, yeah, I hit him a couple times. We let him back up, and then he started following my brother because we was about to leave.
Okay, so you guys are walking away from the situation?
Yeah, we literally walked away, bro.
And he came back towards you?
He was following my brother. And
your brother, Tyler?
Yeah.
Okay.
And my brother had called my name. That's when I ran over to him, and I hit him, and he fell on the ground.
So you punched him and he fell down the ground.
So when you say he was following you, where were you at when you turned around when your brother called you?
I'm by the car confronting the other dudes. I was about to fight them too for shooting.
By the blue car?
The blue car.
Okay.
So I'm over there confronting them. I'm about to fight them too, whatever the fuck. But Ethan's still trying to fight my brother and shit. He's spraying over my brother.
Okay.
And so when he called me over there, I literally hit him. He went right to sleep and shit.
Okay, so when he fell.
One of the men on trial admits not only did he confront Ethan Liming, he also threw the punch that knocked the 17-year-old out. And you're about to see that interrogation video for yourself.
I'm by the car confronting the other dudes. I was about to fight them too for shooting.
By the blue car?
The blue car.
Okay.
So I'm over there confronting them. I'm about to fight them too. Ethan's still trying to fight my brother. He's spraying over my brother.
Okay.
And so when he called me over there, I literally hit him. He went right to sleep.
That's Deshaun Stafford admitting to throwing the punch that knocked Ethan Liming unconscious. The 17-year-old killed in the parking lot of the I Promise school in Akron. And this video just part of what happened in day 3 of testimony. Among the witnesses called by the prosecution, 3 of Ethan's friends who were there that night. However, the 3 told different stories about who confronted the 17-year-old after the splatter gun attack. The defense hoping to capitalize on this.
2 of the 3 state witnesses give testimony inconsistent with Sean's statement. Two of the 3 say Donovan was the one that walked out to the car, and Donovan's the one that got shot in the face.
One of Ethan's friends, who didn't want to be identified, says while they were trying to help him, the attack continued.
I get out the car and I grab Ethan's legs, and Lamarian has his arm, but we trying to lift him up, but we can't lift him up. And then one guy comes back. After we can't get him in, he comes back to us and like he's talking to us like he said he wants to fight us, and like we don't want to fight you.
And tomorrow the defense will start to call their witnesses to the stand. And remember, they say this was self-defense. They argue Ethan died after hitting his head from a fall during that fight. And we're going to bring you gavel-to-gavel coverage of this trial. We're following this on our digital platforms when court is in session, and we will keep bringing you live reports both here on air and online. And for now, in the newsroom, Caitlin McCarthy, 19 News.
guess take us through like what you see going on with the fight.
So it's just like, it's kind of like, from where I was standing, it's just like a ball of people, and then Ethan gets like knocked out, and then he's on the ground, and then they're like stomping and kicking.
So you say Ethan gets knocked out or to the ground?
Yes.
Did you see him fall to the ground?
Yes.
Did he move or get back up after that?
No.
And you said we're still talking 2 or 3 people?
3.
3. And as Ethan's passed out on the ground, describe what they're doing.
Like kicking him, stomping him.
Anybody punching him at that point?
I don't think so, no.
Okay. And obviously he's not getting back up and...
Yeah, no.
Okay. How does that kicking him when he's on the ground or stomping him when he's on the ground, how does that end?
I mean, like after, like, obviously you can tell like he's unconscious, so after a while they stop and then walk away.
Okay, where do they walk to?
Like back over towards the back half of like the parking lot near the basketball court.
Akron 911, what's the location of an emergency?
Oh, we're at King School, or no, we're at the I Promise School in Akron, Ohio.
Okay.
Our friend just got knocked out.
Okay.
We don't know what to do.
What is your name?
My name is Ephraim Stefanko.
Okay, is there a fight happening there now?
Hey, man. We're sorry, man. We didn't mean it. Sorry, what was that?
Is there a fight going on?
There was.
Okay, are the other people still there?
Yeah, it's all good. It's okay, though. It's cool now. It's cool now.
Okay, is your friend unconscious?
Yeah.
Is he breathing?
Is he breathing? Yeah. Yeah, he's breathing. He's breathing.
Okay. Are you with him now?
Yeah.
How old is he?
I'm not trying to fight, though.
How old is
What was
he?
that? I can't fight. I can't.
How old is he? Hello?
He's 15.
He's 17? Hello, are you still here?
At what point did you learn that Ethan had actually died?
Sorry. My dad called my mom and said that Ethan died, and I just knew from my mom's reaction what happened. I kind of just dropped to the floor and I didn't know what to do.
When you last saw Ethan, he was on the ground, right? Did you see what he looked like, what his face looked like, or anything like that?
No.
You never got that close to see that?
Yeah, no.
Okay.
Are you saying that you had no knowledge that he was selling marijuana that night?
I didn't know.
Okay.
I knew that we were going to go smoke with them, but it's not like the dealing part. I didn't know that.
How did you know you guys were going to go smoke?
He told me.
Okay. So he said, we're going to go smoke with these 2 guys.
Yeah.
And you know these guys, but they're not guys that you run with on a regular basis. Is that accurate?
I mean, yeah, not often, no.
Okay. Ethan picks you up and you're just going to ride sidekick for the night, basically?
Basically, yeah. You put gel balls in a gun and you shoot them.
Now there's a battery, right?
Yes.
Can you tell by looking whether this one's yours or somebody else's?
We had the same one.
Did you charge your battery up before you went out that night?
I think I just like had it on the charger before. Like I kind of just always did. Yeah, I guess so.
All right. Now, theoretically, this thing hasn't been fired in over a year, right?
Right.
Okay, but it's either yours or Ethan. Did you guys do a lot of shooting with it before that night?
Like we just shot each other with it.
Okay. And you jumped out and you shot the other 2 boys when you got there, right?
Yes.
All right. So, what's this thing do? You put this magazine in it?
Yeah.
And the magazine holds like 20,000 pellets?
Something, yeah.
Do you know if this battery's charged?
I don't know.
So is that the top of it?
Yes.
Okay. So this is what you guys have when you're going to go do this thing.
So there we saw the explanation from Ephraim, who was Ethan's friend, and then you saw the defense there talk about this idea that they, the two friends that they had picked up, Lamar and Mackay, it was the intention, Ethan was actually picking them up to sell them weed. They originally, and they testified that they wanted to buy the weed and stay at Lamar's house, but Ethan kind of encouraged them to get in the car so they could smoke up there in the car. And then that's when they started driving around. That's when they saw the three young men on the basketball court and chose to go over there and do this mock drive-by shooting with these splatterball guns. But again, you're seeing that is Deshaun right there. He has been talking with his brother. They've been hiding their mouths at times, not sure what they're talking about. There's a lot on the line here, obviously, for these two young men, and a lot at stake. Waiting for day 4 to begin. This will all be about the defense. This will be the defense trying to convince the jury of their argument. We see their attorney come back into court speaking with Deshaun. And we're just going to look in on here. That's client privilege with their attorney, but generally don't see that. I was trying to read body language there. There is the chance. Any defendant always has the chance to take the stand in their own defense. We heard from our legal analyst, Tara Coleman. She's a noted defense attorney in Cleveland. We will have her on again during the lunch break today. But when I brought up the question to Tara, would Deshaun ever take the stand in his own defense? It is obviously risky, because while he will get softball questions from his own attorney, walk me through, were you scared? Why did you go confront them? When you were standing at the car and Ethan shot you at a close range, what did you do? And of course, he would be able to help his side of the story and explain to the jury this was in self-defense. That when I took the gun from Ethan and threw a punch, I was trying to defend myself from being shot with this splatter gun. But while he gets those questions from his attorney, he would then have to be questioned by the prosecution. They would be able to cross-examine him. And there would be a number of opportunities to say, if this was in self-defense, why go confront him at all? The two young men had already run back to the car. You're still on the basketball court. Why go confront? Why run over to the car at all if you were worried about your safety? Then, okay, if you can get past that, then you would be able to ask the question, okay, once Ethan is knocked out and you go back to the basketball court with your brother and his girlfriend, why do you then go down to the car again where your cousin Donovan was fighting the three individuals? Why go down there and try and fight the young men again? Again, these are questions that would come from the prosecution to try and poke holes in this story of self-defense. But so the question of whether or not he would ever take the stand, Tara Coleman, our legal analyst, saying, how well do you know your client? Can your client stand up to the pressure? How are they going to handle the pressure of being cross-examined by the state, which the state is going to push and push to try and get him to break? And all the while, we have that the interrogation video of him explaining, I punched Ethan and he went right to sleep. That sort of knockout blow, and you would have to say to if you're the cross-examining prosecutor, you would have to say to Deshaun, you said it in the interrogation video when the police picked you up 9 days later. Is that exactly what happened? And he would have to say either yes or no. So were you lying in that video or were you telling the truth? We do know in that interrogation video that Deshaun did lie in the beginning of it. He's talking to investigators. They say there were 3 men on the basketball court. Who were they? And he says, my brother Tyler, and I don't know who the other guy was. And they said, you're sure you don't know who the other guy is? He said, no, just some random guy is how he described him. Well, that was a lie. It was clearly his cousin. They showed up to the basketball court together. Then they asked Deshaun, okay, there was a 4th person on that basketball court. It looked like a woman, a young lady. Who was that person? I don't know. I don't know who that person was. Well, he was lying there too. That was his brother's girlfriend. That was Tyler's girlfriend. So we get the all rise. So this will be the all rise to bring the jury in. I'm going to flip away from this for just a second. And you saw the attorney put his arm around Deshaun.
All right, so we are back on the record without the jury being present in the state of Ohio versus Deshaun Stafford and Tyler Stafford. When we concluded last evening, the state had rested its case with the exception of introduction of exhibits. So at this time, Ms. Schucke or Mr. Kuhn, go ahead with exhibits. Counsel for the defense, if you have objections to any of the exhibits, just jump in. We're not going to go one by one. Okay.
So just first off, I would read the numbers, but there are the different videos that we had, body cam, scene video, and defendant Deshaun Stafford's interview. They are all on a thumb drive, individually marked with their exhibit numbers on the icon, I guess. Okay. So the first, what says exhibit 1 is on the thumb drive. That is the body camera video of the first responding officer. That was Kyle Walter. Do you want me to read them? Are you going to object as I go, or?
Just jump in with an objection if you have one.
Fair enough. All right, then states 2 through 25 are all crime scene photos as introduced and authenticated by Sergeant Miller.
Dan DeRosa with 19 News. This is fairly routine. As the prosecution closed their case yesterday, everything that they pulled out as evidence, every file photo, every video that they played has to be marked, has to be given a number and put in on the record so that if the jury wants to view anything, they could say, we want to see evidence number, marker number, whatever. And so this will be fairly routine, and we'll see if the defense objects to anything officially going in on the record.
Photograph from the crime scene. 29 is also on the thumb drive. That's the I Promise School parking lot raw video footage. Exhibit 30 is the I Promise basketball court raw footage. States 31 is the McDonald's drive-through in the dumpster area raw video footage. States 32 is the McDonald's camera facing Market Street raw video footage. And States 33 is the compilation video that was about 7 minutes and 45 seconds in length. All of those videos are on the thumb drive. States 30.
And that's the end of the thumb drive, so 1 to 33 are on the thumb drive. Okay, let me know when we're done with the thumb drive.
Okay. 35 is the...
I'm sorry, I think, did you skip 34?
You're right, I'm sorry. That's a photo of Ethan Liming. So then 35 is the splat ball gun recovered from 515 Howard Street.
I want to see that.
It's right here. The one you guys...
Oh, I thought it was the photo. You're going the actual
Sorry,
gun.
the actual splat gun, yes.
Sorry.
And then 36 is the container of the gel Orbeez found in the car, Ethan's car. 37 is the 911 call from Stefanko. That is on the thumb drive. 38 is the Summit County Medical Examiner's report of investigation. 39 is the Summit County Medical Examiner's report of autopsy. 40 is the Summit County Medical Examiner's PowerPoint. That's on the thumb drive. 41 is a still from body camera by Officer Mobley. And, sorry.
Okay, that's
41.
fine. Yep. Thank you.
42 is another still from the body cam from Officer Mobley.
Object, is that the paintball gun? Yeah, we have to object to that one. Yeah, I would object to that one. That appears to be a photograph taken several days after this incident where the police officer went in to pick up an Orbeez gun that's in a bag, and it just so happens that there is a paint gun, a paintball gun, that has no relevance to this case, that is positioned directly in front of the Orbeez gun.
Jenny.
The Orbeez gun is in the bag, in a plastic bag.
So it doesn't really have any evidentiary value because no one's contesting there was an Orbeez gun, but there's no purpose in putting a paintball gun that apparently belongs to the defendant's girlfriend's brother, other than to imply somehow that these young men are dangerous.
That wasn't the point at all. That was to show where the black ball gun was located when picked up by the officer.
Which isn't an issue.
And Your Honor, it's not even visible. It's in a plastic bag. You can't even see entirely what it is. And it's up in the corner. It's just amazing that of all of the body camera footage, something's taking hundreds of photographs in a minute or an hour. This is the one that was pulled out and used, where you can't even see the splatter ball gun that's relevant. But there's a paintball gun that has nothing to do with this case. It's right in the center of the photograph. It's pretty obvious that it's...
It looks scary.
Your Honor, if I could briefly respond. Your Honor, one of the issues that was presented here throughout the trial by the defense through their line of questioning was to try to establish essentially that it was completely unfathomable that Ethan and his buddies would have toy guns essentially, and that you don't play like that in Akron, and that it's just completely preposterous to have a pretend gun or some sort of toy gun, and that it would be something that the Stafford brothers would be unfamiliar with. And I believe it does have relevance there, Judge, to demonstrate that, in fact, Deshaun did have a paintball gun, not only in this photograph here at his home, where he lives, but also I anticipate the defense will object later on to the image that they objected to yesterday regarding the image of a different paintball gun in Deshaun's car at the time that it was... I'm sorry?
We should pull that out and do it.
Okay. That's, looks like State's Exhibit 48, Judge, if I can approach and present that to the court.
Okay, and 48 is in Deshaun Stafford's car when it was taken and inventoried, et cetera.
I believe so, Judge, yes. I believe that was June 11th.
And Judge, I'm sorry to jump in. 48 is where it was shown to the detective, and he said, yes, this has no evidentiary value. And the prosecutor said, no, it has no evidentiary value. Well, we're marking it as an exhibit, but we know it has no probative value whatsoever.
And there's been no testimony that actually ties these boys to it. And we know the gun found at the girlfriend's house is her brother's. No one's testified that Deshaun or Tyler knew about it. And the one that's found in Deshaun's car is found in the back seat apparently a week later. There's no testimony that that's his paintball gun and the use of the paintball gun. Even if there was, that's not relevant to this.
Judge,
it's just jury's up the jury. Jury's up the questions to the jury.
Judge, Attorney Gallick's statement is not quite right. He mentioned this yesterday. The detective indicated that nothing of evidentiary value was taken from the car there. He did not comment on the relevance or evidentiary value of that photograph, Your Honor.
All right, so I think as to 42, there's no evidence that this paintball gun belongs to Mr. Stafford, et cetera, and the relevance of it is tenuous, to say the least. I think there's, as to Officer Mobley's testimony, he went there, he got a paintball gun, they gave it to him without incident, and he left. I'm not going to admit 42. 48, that was in Mr. Stafford's car, along with the basketball, along with some other miscellaneous items. I don't think there's been any dispute that that's a paintball gun, that no one has said or implied that that's a real weapon. That is the condition of the car when it was taken in. I will allow 48. So we'll go back to 43, I guess.
43, yes, Judge. That is the interview of Deshaun Stafford, and it's on the thumb drive. 44 is a photo of the I Promise School parking lot.
Dan DeRose with 19 News. Just to explain what was going on there were two pictures that were presented to the jury already. They've already seen these pictures, but as far as admitting them on the record as official evidence, there were two pictures. One, when an officer was sent to the home of Deshaun, he took Ethan's splatterball gun from the scene. Deshaun Stafford took the gun. 9 days later, when he's picked up, he told detectives in the interview, the gun is at my house. It's in a plastic bag. I believe he called it an Acme bag, and it's on the shelf. The officer goes to that home. An officer is sent to that home. The mother lets the officer in to go get the bag, and they submitted a picture of the room where that bag was in. Well, front and center in that picture was a barbecue grill in this room, and there was a sizable paintball gun right on top of that grill that has nothing to do with this case. It wasn't used. Nobody is saying that that gun was ever pulled out by either of the Stafford brothers. The bag, in fact, was on the back shelf in the upper right corner of that picture, and the judge said it was tenable at best, and so she threw that picture out. The other picture was when they took his car into evidence. There was another paintball gun in the back of Deshaun Stafford's vehicle. Again, had nothing to do with this case. That wasn't used. Deshaun never pulled it out, but the judge allowed that one. Curious.
We've got some real issues. The state has some real issues with causation. In order to find my client guilty, a jury would have to find beyond a reasonable doubt that he caused the death of Ethan Lyman. When we started out here, maybe that was just assumed, but that is no longer a safe assumption. There's been ample evidence that somebody else was involved in this, namely Donovan Jones, that Donovan Jones may have been the aggressor, at least as it relates to the boys involved in their response to Ethan and his friends. And when it comes to causation and when it comes to serious physical harm and the deadly force required, none of that's been proven. All the assumptions we had early on kind of fell apart with the state's case. At this time, Your Honor, I'm asking this court to take these portions of this case, specifically the felony 1 aggravated assault and the felony 1 involuntary manslaughter by way of aggravated assault, the felony 3 involuntary manslaughter by way of assault, and I'm asking to direct those out. There's not sufficient evidence to send those to a jury. At most, what you send to the jury is what Donovan walked away with, which is the misdemeanor assault charge. Thank you.
Mr. Gallagher.
Then I too would make a criminal rule 29 motion for a judgment of acquittal. It's a two-part motion. The broader concept is under the new law, the prosecution is required to show that there was any act that Tyler Stafford made was not self-defense. I don't feel that they have done that. If he was acting in self-defense, they haven't proven otherwise. That's the broader part of the motion. There's a more specific, tailored, the second part to the criminal rule 29 motion, and it goes to the third-degree felony involuntary manslaughter. Specifically, looking at the indictment and also looking at the bill of particulars that we were able to obtain. It's a rather lengthy bill of particulars, but I would say what we used to call the two-wit would be in paragraph 7 and 8. And in paragraph 7 and 8, they're talking about Deshaun Stafford, Tyler Stafford, and then in paragraph 6, Donovan Jones engaged in a fist fight with Ethan Lyman. Paragraph 8 says that Ethan fell backwards from the blow, hitting the back of his head on the pavement. He was knocked unconscious and died from his head injury. So the person who caused his head injury is the person who is potentially responsible for involuntary manslaughter if it's not a self-defense act. We heard from the medical examiner that the injury to the back of the head was the cause of death. Everything else, although horrible, is not relevant to the charge of involuntary manslaughter. There's been no testimony that Tyler Stafford did anything to cause Ethan to fall backwards, to hit his head. There's no testimony that Tyler Stafford slammed him to the ground. We heard testimony from one witness that Deshaun Stafford hit him and knocked him backwards. We heard testimony from two others saying it might have been Donovan Jones. We heard no testimony of any kind that Tyler Stafford did anything to cause the death of Ethan Lyman. And going on what our notice comes from the indictment and from the bill of particulars, specifically paragraph 7 and 8, that was not proven. There was no testimony to this. The only thing we had was from Detective Hornacek at the end. He said, well, there was a statement all three jumped him. Like all three are responsible for the manslaughter. Well, that's not in the indictment. That's not in the bill of particulars. So we're relying on this bill of particulars to tell us what the legal theory is, what the allegations are, how to defend ourselves from the facts and the law. There was no testimony backing up this bill of particulars. So we're making a broader Rule 29 motion on self-defense for both of Tyler's charges, but very specifically to the third-degree felony involuntary manslaughter. Causation and proximate cause, they're just not there.
Your Honor, and I'm sorry, I want to adopt Attorney Gallick's, the argument he made for Tyler. I would adopt that for Deshaun. I never got past cause and whether or not Deshaun even caused this in my argument. But really, for the state to prevail, they've got to prove, there had to be evidence that Deshaun did not act in self-defense. There had to be some evidence of that. They got to prove that to this jury. We never got that far. There's been no evidence that would establish that Deshaun was not acting in self-defense. We heard from no one that said anything contrary to that. There's no way that a jury can find that Deshaun didn't act in self-defense because no evidence was presented to that. And that's the effect of the new law, and that's the burden shifting. So I just said in my opening argument here, Attorney Gallick brought it up for Tyler, and I bring it up for Deshaun. I think that's a powerful point. Thank you.
On behalf of the state.
Thank you very much. Your Honor, just very briefly, may it please support. Your Honor, the state does believe that we have met our burden in terms of presenting our case to the jury for their consideration. Regarding Deshaun Stafford, he does have the involuntary manslaughter by way of aggravated assault. The state does believe that the evidence presented is enough for the factual determination to be made by the jury regarding causing serious physical harm to the deceased, Ethan Liming, and that his death did occur and was caused by that aggravated assault. Additionally, the state does believe that we have met our burden regarding the essentially the lesser count of involuntary manslaughter by way of misdemeanor assault in the event that the jury were to find that facts would play out that Deshaun did not cause serious physical harm and just find that he did assault Ethan Liming. The evidence was quite clear, Your Honor, that this was not a situation of self-defense, that this was in fact a brutal attack, initially by Deshaun, an older young man, and then ultimately with his brother and cousin joining in, ultimately creating a 3-on-1 fight situation. That did cause the death of Ethan Liming, Your Honor. Additionally, we did prove that was on June 2nd of last year here in Summit County, Ohio. Additionally, Your Honor, regarding Tyler Stafford, the state has met its burden there as well regarding the involuntary manslaughter by way of assault. Evidence presented by several witnesses and statements of the defendants themselves indicated that they were actively engaged in a fight with Ethan. Really, to call it a fight, Your Honor, is insulting. It was not a fight. It was just an attack. The evidence did show that Ethan was ill-prepared to fight anyone. He was playing with a toy, and the evidence did show that his shoes end up strewn about in the parking lot as he was pummeled and moved some distance away throughout that event by 3 individuals, primarily by the Stafford brothers. That did cause his death. Additionally, Your Honor, related to the points brought up by Attorney Gallick, the state does believe that there is evidence sufficient to show that there was a common scheme here and that the defendants were acting in concert with one another by engaging in a fight, at least 2-on-1 or 3-on-1, and the state has met its burden in proving those elements and putting this before the jury, Your Honor. That's all we have right now, Your Honor.
Okay, thank you. Mr. Gallick?
Judge, I just have to say, acting in concert, I didn't hear that in the opening statement. I didn't hear that this was some kind of conspiracy to commit a homicide. It's not the indictment. It's not the bill of particulars. It wasn't the testimony of any of the witnesses. So obviously I'm supporting both parts of my criminal Rule 29 motion, but as to the involuntary manslaughter for Tyler Stafford, we didn't have any testimony of anything like that. We didn't have any testimony that there was some common scheme that the prosecutor just brought up. There's some conspiracy, the three of them working together to try and commit a homicide. There's no testimony that Tyler Stafford did anything to cause the death of Ethan Lyman. So we would ask that the third-degree felony, the judgment of acquittal, be entered into that charge at a very minimum.
Okay, thank you. So I agree that there are numerous factual issues here. There is conflicting evidence related to some of those facts. However, taken in a light most favorable to the state, there is evidence that has been presented related to each of the elements of the case sufficient to send these charges to a jury. As to Mr. Gallick just referred to it as conspiracy. I don't think it's conspiracy. It's a complicity argument. And the complicity argument does not change the charges that have been presented through the indictment and the bill of particulars. It does change the theory somewhat. However, it is within the discretion of the court to allow that. So I will overrule and deny the Rule 29 motions. That takes us to the jury instructions. Counsel and I have spent considerable time last night and this morning discussing jury instructions. I believe the only one that is in dispute, the state has requested a complicity instruction related to Tyler Stafford and count 3. Counsel, did you want to address that?
Yes, please, Judge. And I do appreciate the court and your staff, as well as the defense, working with us to try to clarify the issues contained in the jury instructions that will hopefully be presented to the jury here shortly. Your Honor, the state does believe that a complicity instruction would be appropriate here, perhaps related to aiding or abetting, or in the alternative, I believe it's soliciting the aid of another. As it relates to Tyler Stafford and the felony 3 involuntary manslaughter count, the state does believe that that would be appropriate based on how the testimony and evidence did come out at trial here these last several days. Ultimately, Your Honor, it is within the court's discretion. However, the state does not believe that it has changed anything or significantly altered the theory of this case, Your Honor. The allegation all along was that there was an incident whereby the Stafford brothers and their cousin attacked Ethan Lyman, and that there was yelling going on. That is essentially what played out through testimony here this past week, Your Honor. The specifics of it in terms of calling a name may be slightly different. However, it is not a significant difference and it would not ultimately affect the way this case would have been defended from the state's vantage point. And the defense was on notice of these general allegations, Judge. Thank you.
I would object to that jury instruction. I was notified today that that was the theory. I did not know that Tyler Stafford was being accused of calling his brother's name and that caused the manslaughter. So we would object to any instruction as to Tyler Stafford on aiding and abetting or conspiracy or complicity or any of those other novel theories that were not really known to us until today. We object to any jury instructions on that.
As that relates to Sean, I joined in that argument.
Well, again, I think there is evidence that this was a 3-on-1 altercation, at least at some times during this incident, and that in and of itself could be an aiding and abetting situation. So I will give the complicity instruction as requested by the state. State has rested we may repeat this in front of the jury, but as to the defense's case.
I'm sorry, Your Honor, could you repeat that for me?
So I'm turning to you to ask if there is any evidence on behalf of the defense.
1 second, Your Honor.
While we have a quick second here, Dan DeRose with Channel 19, we are about to hit our 11 o'clock news, and so if you are watching maybe on our app through the Live Now, not through the story, but if you clicked Watch Live Now, we're going to switch to our news. This will be live on all of our other platforms. If you want to watch it on Facebook, if you want to go to Cleveland 19 and click into the story, it will be live. But we'll continue on Facebook and Roku and Apple TV.
Sean Stafford, Mr. Tyler Stafford, I just want to confirm that you have conferred with your counsel related to your right to remain silent, your ability to testify, and that it is your choice at this time not to take the witness stand and testify. Deshaun? Mr. Tyler? You need to, thank you. All right, and then I would also deny the renewed Rule 29 motions. When we reconvene in front of the jury, I will ask the defense to just rest on the record in front of the jury.
As I stated yesterday, then I'll follow your instructions, certainly. I do think that it's not necessary for the defense to rest in front of the jury. Requesting for the record, I think the jury should just be told they've heard all the evidence they're going to hear. I think it draws the inference that the defendants did not testify. That would be a violation of their rights not to permit the officers not to testify to their own case.
Good point, I concur.
All right, I have done this outside the presence of the jury just to get the Rule 29 motions done in an efficient manner and not have to move the jury in and out several times in the course of about 5 minutes. So I think I'm doing this for just time reasons. Generally, you would need to rest in front of the jury, and I will just ask that question. I don't think it makes any inference at all, and they will be instructed in the jury instructions related to the defendant's right to remain silent. Okay, can I see counsel briefly?
Dan DeRose with 19 News. Got a couple of big bombshells here. First of all, let's explain the procedure that just happened, Issue 29, Rule 29. This is what happens at the end of every prosecution's case. You're the attorney for Deshaun, you're the attorney for Tyler. You get up there in the middle of this case before you even have to present everything, and you say, Judge, we don't think the state did their job. We don't think they showed enough evidence to even send this to the jury. We want it thrown out. And here's why. They presented that. It never works. It is a shot in the dark. I shouldn't say never. Never is a big word, but it 99.999% of the time never works. Didn't work in this case either. The judge agreeing that there is cause to send this to a jury. The bombshell then became that the defense is not going to call any witnesses. They're not going to have an expert testify. They're not going to call any witnesses. You heard the judge inform Deshaun and Tyler that she needed to ask them on the record. You are afforded the right to testify in front of the jury. It is your right, your constitutional right. Do you want to testify? They both said no. But so the judge said, okay, when the jury comes back in, the defense will say that they rest their case. There will be closing arguments, and then this case will be, and then there'll be jury instructions. Jury instructions are very tedious. It is, here's exactly what involuntary manslaughter means, and the judge will read word for word what it means. Here is what causation means. Here is what aggravated assault means. And if you have causation, if you're convicted of aggravated assault and it's the cause of that assault that caused the death, then it connects to involuntary manslaughter. It's very dry, but we are getting close. I would say for sure by mid-afternoon, the jury will have this case. You see the attorney Gallick explaining to Tyler there what's about to happen. Deshaun is going to be, obviously his attorney has already explained, a little bit of a surprise. I'm a little shocked here. Normally in a case of this magnitude, you'll get some sort of testimony but from the defense, but we're not going to get a single witness called. In that conversation I had, that brief conversation I had with Tara Coleman this morning, I'm gonna read you a little bit of what our conversation was. I don't think I'm stepping out of turn here, but if I can find it here in this scramble, I may not have it. Her thought was that you're putting at risk by putting an expert on that stand talking about how dangerous that toy gun is, of really playing up the dangerousness of a toy gun, and that may not go in the favor of Deshaun or for Tyler. And in fact, when we closed yesterday, we keep talking about this confusion. And the judge admitted, yes, there does appear to be conflicting evidence, but it was not enough to throw out the entire case. This idea that 2 out of the 3 of Ethan's friends said it may have been Donovan who, and we see the actual gun that we've heard fired in court before being placed into evidence. That is the prosecutor sealing up their list of evidence. It's been numbered and being placed on the record. We're in a little bit of a delay. I think we will get the jury in here at some point. But again, kind of an interesting morning. I'm glad that we are covering this gavel to gavel so that you got to watch that play out in court to say that there will be no defense, there will be no witnesses called on behalf of the defense. Just taking a listen into court briefly to see if we can hear any instructions, but there is this idea of confusion. In fact, while we wait, I want to play some sound from yesterday afternoon, some testimony from yesterday afternoon. This is the lead detective for the city, or for the Akron Police Department on this case, Detective Michael Williams. He was on the stand. It was the conversation about why would 2 of Ethan's friends say it was Donovan that came over to confront, and 1 said it was Deshaun. So take a listen to the defense. I'm going to continue to monitor the courtroom. You won't miss anything. When the jury comes in, the defense will rest, and then more than likely they will proceed right to closing arguments. Closing arguments could be 20, 30 minutes on each side. Then there will be jury instructions. We'll have to see if, as we get closer to noon, will they break for lunch and then do the jury instructions and then give the case to the jury. So again, I think by mid-afternoon, this case will go to the jury, and depending on how much discussion there will need to be, we'll have to be on jury watch. We have seen there aren't a lot of charges. Sometimes in past cases where someone is charged with murder, aggravated murder, that's not the case here, but I'm just speaking in generalities here. When you have somebody that's charged with murder, aggravated murder, negligent homicide, involuntary homicide, assault, simple assault, felony assault, the jury then has to go through each one of those charges and talk about that charge and why it does or does not meet the definition and what was proven in court. So sometimes when there is a long list of charges, you know it's going to take that jury some time, simply almost from a paperwork standpoint. But in this case, there are not all that many charges. Deshaun is facing 2 counts of involuntary manslaughter. I believe one of them is a felony 1, an F1, that then ties into the aggravated assault. His brother Tyler is just facing 1 involuntary manslaughter charge and 1, I'm going to make sure I get this right here in my notes. His brother Tyler, 1 involuntary manslaughter and 1 assault. Because obviously to have involuntary manslaughter, there had to have been an assault that occurred. So they'll have to start at that assault. Was there an assault that occurred? Was that assault what led to the involuntary manslaughter? So with there not being a lot of charges, it may not be one of those 2, 3, 4 days that the jury has to deliberate. I would be shocked if this went multiple days in getting a decision from the jury. Do they think there's enough confusion to throw the whole thing out and come back with a not guilty? Or do they think that when Deshaun was sitting in that interrogation room saying, I punched him and he went right to sleep, is that the piece of evidence they need? It'll be interesting. But let's get back to this idea of confusion. You're going to hear from Detective Williams on the stand yesterday afternoon talk about how can it be that there are conflicting ideas of who confronted Ethan in the first place. Take a listen.
And who did you conclude was the first person to approach the boys at the key?
Through interviewing through interviewing.
And I actually want to stop right there. Did you see that? Did you see the detective through interviewing Don? He went to say Donovan. So yes, the names are similar, Donovan, Deshaun, but even and that's why the detective sort of did that grimace or that laugh, because even he is starting to get confused by the names and the identities, and perhaps will that play in the favor of these 2 young men. Let's watch it again.
And who did you conclude was the first person to approach the boys at the key?
Through interviewing through interviewing Deshaun Stafford, he stated that he was the first one to go up to the car.
And did that explanation match up with descriptions and video evidence that you had?
Yes, with the height of all 4 of the individuals that came out of the basketball court. Donovan Jones is noted as the tallest one of the 4 people, and he was not the first person out of the basketball court to approach the car.
Okay, do you know what number person he would have been to approach the car?
It's either second or third, I can't remember.
But today and yesterday, 2 of the 3 state's witnesses give testimony inconsistent with Sean's statement. 2 of the 3 say Donovan was the one that walked up to the car, and Donovan was the one that got shot in the face. Right?
That is what they said.
Now Donovan didn't get charged with Ethan's death. He's out of this thing, right?
I don't know the legal term for charged, and I don't know if I'm allowed to talk about what I did in the course of my investigation as far as who I charged.
Donovan's no longer facing charges. It's over for him, right?
That's correct.
And he certainly never was held responsible for anything to do with Ethan's death.
Correct.
And those are based on statements that you were given that night and the investigation you did at that time. It kind of makes sense, but would you agree with me that now it seems like Donovan's a whole lot more involved if we take the state's witnesses at their word?
As far as Ethan's death?
Yeah, as far as Donovan's involvement, it seems to have changed from what we initially thought to what the witnesses are saying now.
I can agree that there is definitely some kind of identity communication problem here.
People seem to be switching to Sean and Donovan to Sean, and they seem to have switched them up. And I'll withdraw that. Is there anybody other than Deshaun saying that Deshaun's the one that punched out Ethan?
through the course of our investigation, we interviewed 6 people, and that's how we got all of our information. The description of Deshaun was his braids and the coloring of his braids, and that's how we came to our conclusion.
But that's coming from those kids who are now kind of changing what they originally told you.
It's coming from the 3 kids as well as Deshaun himself.
Okay. So, the 3 kids originally told you one thing and now they told you something different. But would you agree with me that none of those 3 kids can say that Deshaun threw the punch?
They did tell us that night.
Okay. But they didn't say it here in court?
In court, it appears they were confused about something, yes.
Again, there appears that there was some confusion about something. Yes, that's because 3 of Ethan's friends testified. 2 of them said they think it was Donovan, the bigger of the 3, that came out and started the confrontation, because remember, that confrontation leads to the first 1-on-1, then it's 2-on-1, then it's 3-on-1. And we heard the prosecution there when the judge was talking about throwing the case out, just showing you the courtroom. We're not missing anything here. When the defense tried to get the whole case thrown out, you heard the prosecutor get up there and say, to call this a fight is insulting. It was an attack. Throwing out this idea of this was not self-defense, this was 3-on-1. I'm reading an exact quote from the prosecution as they tried to get this case thrown out. They said this was not self-defense, this was 3-on-1. To call it a fight is insulting, this was an attack. The judge agreed that this should be sent to the jury and ultimately let the jury decide. We're sort of in this holding pattern, listening in here, not a lot going on in court. We will need to get the jury back into the courtroom. It'll be said on the record in front of the jury that the defense rests their case without calling any witnesses, and then they will have to start with closing arguments. I really don't think closing arguments will last all that long, but you do have to hear from 3 individuals. You have the state, then you'll have Deshaun's attorney, and then you'll have Tyler's attorney. There was some interesting conversation the defense had with the detectives on the topic of cell phones. It's been very interesting to watch this case play out and all of the conversation about cell phones. Originally, in the defense's opening argument, they said this was a TikTok prank. They were filming it. They were going to put it on TikTok when they rolled up and shot him with the splatterball guns, and it was a TikTok prank gone wrong. Well, all 3 of Ethan's friends got up on the stand and they were asked, you were doing this for TikTok, right? And all 3 of them said, no, nobody was recording this at all. This had nothing to do with TikTok. We were just being dumb kids and pulling this prank. So that fell apart for the defense a little bit. But then, when we go back to the conversation of cell phones, we see Tyler, when he moves Ethan's car, he goes through the car and he's able to find at least 2, if not 3, of the cell phones that were in the car. The young men, in the midst of the fight, in the midst of the chaos, left their phones in Ethan's car. We see Tyler, as soon as he gets out of Ethan's car, you see this flash come across the surveillance video, and that is supposedly Ephraim. Ephraim's who called 911 from inside the car, that was Ephraim's phone that was smashed right there on the concrete. There were also phones that were smashed down by what we call round 2. When they pulled the car up to try and get Ethan's body, there were cell phones that were smashed there. The one cell phone that was never found was Ethan's. And we know Ethan had a phone because when they were in the car and they were about to go do this, the prank at the I Promise school, we've heard his friends testify that Ethan got another text message to go sell weed to another set of customers or another couple of individuals. And so they were going to ride along as Ethan went to that next house. But it was on the way to that next house that they saw the 3 individuals on the basketball court, and we know what happened then. So we know that Ethan had a cell phone at one point, but his was never recovered. And you get this conversation about how important are cell phones. And again, put yourself in the jury's position. You have Deshaun and Tyler and Donovan on the run for 9 days after this incident. How much conversation would they have had back and forth about, did you hear that kid died, blah, 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 what are you going to say? Don't say anything. You know, whatever kids are going to say back and forth. The prosecution, or at least the detectives, never went through the phones of the suspects. At that point, Donovan was a suspect. Remember, he pleaded no contest, and his part in this case is over, pleaded no contest to 2 assault charges, and his part of the case is over. But they never once, according to the detectives, went through the phones of Tyler and Deshaun. Could there have been some good evidence in that phone in the minutes after, in the 9 days after? And so the fact that the detectives never went through their phones, they never really went and looked for the phone of Ethan Liming. To this day, still missing. Did somebody take it? Did they throw it in the woods? Did they try and smash that one? We don't know. And that is brought up to the detective yesterday, the lead detective on this case for the city of Akron. And again, this is all to put doubt in the mind of the jury. Are they guilty beyond a reasonable doubt? Take a look and listen to this testimony yesterday about what happened and the conversation around cell phones.
So knowing that things change and people change, there are things we could have done to try and see whether, you know, we have scientific things we could have done, right?
Yes.
Like you had the phones from all the boys in the car, and that could have told us what happened leading up to this incident, right?
It's possible.
But according to Detective Mike Williams, he didn't see a need for it, you didn't see a need for it, which would have been simple as turning them on and seeing if you could read the last day of text messages, right?
No, it would not be as simple to do that, no.
We all have cell phones. We've all lost data. You have a whole crime lab up there on the second floor and they've got a machine that deals with phones, right?
That's correct.
In this case, no one even bothered to turn these things on to see if you could read them through the glass, the broken glass.
We did attempt to turn them on, but they were broken and they would not turn on.
And there's a next step you could have followed that we just chose not to. We didn't send it out to get looked at. We didn't send it to the crime lab. We just turned it back off.
We sent it to the crime lab for DNA processing.
Well, let's talk about DNA. Well, let's stick on phones for a minute. Ethan's phone's missing, right?
Yes.
That seems odd.
Yes.
It's an iPhone, right?
That I don't know.
Okay. Well, iPhone, Android. When you contact the phone company or talk to the parents and said, find my iPhone, find my Android. Where did it pop up at?
I did not do that. I believe Detective Mike Williams might have.
We didn't hear about that, right? I mean, that's a mystery where the phone went.
Yes.
We don't even know whether or not someone's still using that phone today. I mean, the phone company would have records, but somebody would have to go get them. And no one did that, right?
No.
And likewise, maybe even more importantly, these boys on the basketball court had 9 days to talk back and forth to each other. We could assume. They're all relatives, right?
Yes.
They all are reading the paper and watching the press conferences, and you can assume, you can guess they're probably talking about getting their story straight.
It's possible. I don't know.
You took each one of their cell phones into custody when you arrested them, did you not?
I don't recall. I'm not sure.
That would be pretty easy to do. You arrest them, you take them, you ask for their cell phone, and then you turn the cell phone on, you look back and you go, that's where you guys got your, that's where you did that. But we didn't even turn on the suspects' phones to see what kind of things they were saying before the incident, after the incident. That'd be good to know, wouldn't it? Especially now with Donovan's different involvement?
Yeah, through the course of our investigation, through our 6 interviews, I did not see the need to have the phones due to the cooperation of everyone.
I guess what I'm saying is we don't know these people, these kids, these other people.
And I'm going to jump out of this as we see the judge is back in the courtroom. I believe we'll get the all rise for the jury. Now it looks like I can admit I'm a little confused here as to where they're headed. It looked like they were headed back for another conference. So we will wait and see. Again, Deshaun and Tyler Stafford facing very serious charges here. And the wheels of justice are turning here, going to turn a little quicker than anticipated today, based on the fact that it does not appear the defense will be calling any witnesses. But from that testimony, and in fact there's the detective sitting right there, the lead detective on the case, just very interesting that at no point did they, you could have gotten a subpoena for the phone from the young men. You could have worked with the cell phone companies, especially the ones that were had the screens broken. You heard the detective say we tried to turn them on and they would not turn on. That doesn't mean they're useless. We all know that data can be recovered even from broken phones. They have technology, and that's what the defense was trying to say. You have a whole second floor up there in Akron that can work on issues like this. We've seen cases in the past where even though someone tried to destroy a phone, they were still able to pull information off of it. Maybe not full text messages, but perhaps something, maybe voicemails that are left. And at no point did they think it necessary to get that information, to open up those cell phones. The detectives say it's because everybody was cooperating. They interviewed all 6 subjects. That means 3 witnesses and the 3 men who were on the basketball court. They were all willing to participate. None of them wanted an attorney. So that's why the detectives said they didn't go after the cell phones. I find that odd personally, not even in regards to this case. I'm just saying in regards to the immense amount of court I've covered in my career, that cell phone ends up holding an immense amount of information, whether it's geodata locations, like where you were located, where you went, where did these young men go after the attack, where did everybody go, that would have shown that. But the detective didn't feel that necessary. It looked like they went back for another sidebar with the judge, so we will wait to see on that. But in the meantime, let's listen to more testimony. You're about to hear from Lamar Dancy. He is the one witness, the one friend of Ethan's who was in the car, who was able to not only identify in his testimony that he thinks it was Deshaun that was the aggressor. He's the only one of the 3 witnesses that the state said, can you point out where they are sitting, in the courtroom. So take a listen again to the testimony of Lamar Dancy. He would have testified, and maybe we won't get to it. In fact, we won't, as we see some of the attorneys, in fact, all of the attorneys heading back into the courtroom. We will wait on that and wait for the judge to come back in. The jury is obviously not seated. There was clearly one more issue that needed to be discussed by both the state and the defense. And so we will wait for the continuation of court. But again, what a fascinating trial to watch. It is unfortunate that this is where we are, but there have been so many twists and turns and surprises and confusion, and the defense apparently not going to call a single witness for either of the young men. We're not going to get any of that. No character witness, no expert witness, no testimony from parents. We know that Deshaun went home and at some point had a conversation because his mother knew where that splatterball gun was, Ethan's splatterball gun that Deshaun took from the scene. When he was interrogated, he said he took it because he wanted to have evidence that they were shot at by Ethan and his friends. So his mom knew something, and she was not called as a witness. Let's say Deshaun had, and we're doing a hypothetical here, but if you're asking why would you call Deshaun's mom, let's say Deshaun goes home and he says, "Mom, I can't believe it. We were shot at by these guns. And then to defend myself, I went over there, first of all, to confront them, and he started shooting me more, and I tried to defend myself, and so that's when I punched him." So we don't get any of that. We don't get that story from his mom or explanation as to what her son did or didn't do that day. So we will wait. And it looks like here's the all rise for the judge. And we'll get the all rise for the jury. And this is going to be an interesting next few minutes. So let's take a listen in.
Please be seated. Okay, good morning, ladies and gentlemen. I do apologize for the delay getting started this morning. As I discussed yesterday, the lawyers and I had some things we did need to accomplish, and hopefully now things will go a little bit more fluidly for the rest of the day. When we concluded yesterday, the state had rested its case, and therefore I'm going to turn to the defense for any evidence that the defense may wish to present. Mr. Sin?
Your Honor, on behalf of defendant Sean Stafford, we are going to rest on the state of the evidence. Thank you.
Thank you, Mr. Sin. Mr. Gallick?
Your Honor, at this time we would rest our case.
Okay. Would note for the record the renewal of the Rule 29 motions that we did discuss on the record previously. Okay, ladies and gentlemen, then I will tell you what the plan is here for the rest of the day. I am going to begin with some jury instructions for you. I'll give you part of them related to the charges, and then at that point we will break for lunch. I'm anticipating taking maybe a little shorter lunch than we have in the past. Then following lunch, we will proceed with the closing arguments of counsel, and then I will have some further jury instructions for you related to how to conduct your deliberations. So I do have the jury instructions related to the charges that I will give to you now. I will tell you that you are free to take notes through the reading of the jury instructions. However, you should know that you will have copies of these, written copies of these with you during your deliberations, just so you don't feel like you have to write down every word that I'm saying. You can refer to them later. Okay. You have now heard all of the evidence of counsel, and it is my duty to instruct you as to the law that applies in this case. The court and the jury have separate functions. You decide the disputed questions of fact, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and to apply the law to the facts as you determine those facts to be. You are not permitted to change the law or to apply your own ideas as to what you think the law should be. A criminal case begins with the filing of an indictment accusing or charging the defendant with committing a particular crime. It is important that you understand that the filing of the indictment or the indictment itself is in no way to be considered by you as evidence against the defendant. The filing of the indictment informs the defendant that he has been accused of the offense. The plea of not guilty is a denial by the defendants of the crimes that are charged and puts at issue all of the essential elements of the crimes charged. The defendants are presumed to be innocent until their guilt is established beyond a reasonable doubt. The defendants must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the crimes alleged. I am now going to define reasonable doubt for you. Reasonable doubt is present when the jurors, after they have carefully considered and compared all of the evidence, cannot say they are firmly convinced of the truth of the charges. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. I will now define evidence for you. Evidence may be direct or it may be circumstantial or a combination of the two. Direct evidence is testimony given by a witness who has seen or heard or felt certain acts or facts to which he or she testifies. Direct evidence includes exhibits admitted during the trial and any stipulations by the parties. Evidence may also be used to prove a fact by an inference. This type of evidence is called circumstantial evidence. It is the proof of facts by direct evidence from which you may infer other reasonably related facts or conclusions which naturally and logically follow according to the common experience of mankind. Whether an inference is made rests entirely with you. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all of the elements of the charged offenses beyond a reasonable doubt. The evidence, as I have said, does not include the indictment. It does not include the answers to questions you were instructed to disregard or the opening or closing statements of counsel. The opening statements and closing arguments of counsel are designed to assist you, but they are not evidence. You must not speculate as to the reason why the court sustained an objection to any question or what the answer to that question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. The different varieties of evidence you have heard throughout trial are as follows. The first type and the majority of the evidence you heard in this trial is what we call testimonial evidence. That was where a witness took the witness stand, testified to facts they had knowledge of or had observed. You as jurors have the sole and exclusive duty to decide the credibility to give the witnesses. In determining that question, you will apply the tests of truthfulness that you apply throughout your daily lives. These tests include the appearance of each witness on the stand, their manner of testifying, the reasonableness of their testimony, the opportunity each witness had to see, hear, and know the things to which they testified, their accuracy of memory, their frankness or lack of it, the intelligence, interest, or bias, if any, together with all the facts and circumstances surrounding that testimony. Apply these tests and you will assign to each witness the weight that you deem proper. You are not required to believe a witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. You should decide what testimony is worthy of belief and what testimony is not worthy of belief. Normally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. It is not necessary that a defendant take the witness stand in his own defense. The defendants have a constitutional right not to testify. The fact that the defendants, Deshaun Stafford and Tyler Stafford, did not testify must not be considered for any purpose. The second type of evidence admitted during the trial is real or demonstrative evidence. For example, this is a pen. If for some reason this was admitted in trial and had some relevance to the case, you'd be able to take it to the jury room, look at it and see what it is and see if it works and give it whatever weight you deem proper. Real evidence could be pictures, in other cases maybe drugs or a number of different things. It is any real object that was admitted during the trial. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects and in the same condition as originally taken by the police officers, and you will determine what weight, if any, the exhibits should receive in light of all of the evidence. The third type of stipulation is what we call the third type of evidence is what we call a stipulation. Stipulations are nothing more than facts that both sides have agreed are true. I'm now going to go through the various counts of the indictment. In count 1, the defendant, Deshaun Stafford, is charged with involuntary manslaughter. Before you can find that the defendant, Deshaun Stafford, guilty, you must find beyond a reasonable doubt that on or about the second day of June 2022 and in Summit County, Ohio, the defendant, Deshaun Stafford, caused the death of Ethan David Liming as the proximate result of committing or attempting to commit aggravated assault. The state charges that the act of Deshaun Stafford caused the death of Ethan David Liming. Cause is an essential element of the offense of involuntary manslaughter. Cause is defined as an act that in the natural and continuous sequence directly produces the death and without which it would not have occurred. Defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. There may be one or more causes of an event. However, if the defendant's action or failure to act was one cause, then the existence of other causes is not a defense. The defendant is responsible for the natural consequences of the defendant's unlawful act, even though the death was also caused by the intervening act of another person. If the defendant inflicted an injury not likely to produce death, and if the sole and only cause of death was fatal injury inflicted by another person, the defendant who inflicted the original injury is not responsible for the death. Before you can find that the defendant, Deshaun Stafford, was committing or attempting to commit the underlying offense of aggravated assault, you must find beyond a reasonable doubt that the defendant, Deshaun Stafford, knowingly caused serious physical harm to Ethan David Liming. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he was causing serious physical harm to Ethan David Liming. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. When an act is a crime, a good motive or purpose is not a defense. Cause is an essential element of the offense of aggravated assault. Cause in this context is an act which directly produces serious physical harm to persons and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. There may be one or more causes of an event. However, if the defendant's act or failure to act was one cause, then the existence of other causes is not a defense. The defendant is responsible for the natural consequences of the defendant's unlawful act, even though the physical harm to persons was also caused by the intervening act of another person. Serious physical harm means any of the following: any physical harm that carries a substantial risk of death, or any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, or any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement, or any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. Under Ohio law, a person is allowed to use force in self-defense or in defense of another. There are two standards for self-defense and two standards for defense of another. Self-defense may be by deadly force. Self-defense may be by non-deadly force. Defense of another may be by deadly force, and defense of another may be by non-deadly force. The standards that apply to each of those are distinguished based on the amount of force used and the level of danger presented. Deadly force means any force that carries a substantial risk that it will proximately result in the death of any person. Non-deadly force means any force that does not carry with it a substantial risk that it will proximately result in the death of a person. Substantial risk has already been defined previously for you, and you will see as I read these that there are numerous definitions that you can refer back to. I will tell you when I have already defined a term that is used again. To determine which standard of self-defense or defense of another to apply in this case, you must first determine the disputed questions of fact. Once you determine the disputed questions of fact, you must apply the appropriate self-defense or defense of another standard based upon your findings. I'll first talk about self-defense and the use of deadly force. A person is allowed to use deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using deadly force, did not act in self-defense. To prove that the defendant's use of deadly force was not in self-defense, the state must prove beyond a reasonable doubt at least one of the following. The defendant was at fault in creating the situation giving rise to the incident, or the defendant did not have reasonable grounds to believe that he was in immediate danger of death or great bodily harm, or the defendant did not have an honest belief, even if mistaken, that he was in immediate danger of death or great bodily harm, or that the defendant used unreasonable force. Caused, deadly force, and substantial risk have already been defined for you. The defendant did not act in self-defense if the state proved beyond a reasonable doubt that the defendant was at fault in creating the situation that resulted in the injury. The defendant was at fault if the defendant was the initial aggressor and Ethan Liming did not escalate the situation by being the first to use or attempt to use deadly force, or the defendant provoked Ethan Liming into using force, or the defendant did not withdraw from the situation, or the defendant withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant had reasonable grounds to believe and an honest belief that he was in immediate danger of death or great bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that the defendant was about to be killed or receive great bodily harm. In determining whether the defendant, in using force in self-defense, reasonably believed that the force was necessary to prevent injury, loss, or risk of life, or risk to life or safety, you may not consider the possibility of retreat by the defendant. Words alone do not justify the use of force. Resort to deadly force is not justified by abusive language, verbal threats, or other words, no matter how provocative. A person is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger. For you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant used more force than reasonably necessary and that the force used was greatly disproportionate to the apparent danger. In deciding whether the force used was greatly disproportionate to the apparent danger, you may consider whether the force used shows revenge or a criminal purpose. A person is also allowed to use deadly force in defense of another. The state must prove beyond a reasonable doubt that the defendant, when using deadly force, did not act in defense of another. To prove that the defendant's use of deadly force was not in defense of another, the state must prove beyond a reasonable doubt at least one of the following. The person being defended was at fault in creating the situation giving rise to the injury, or the defendant did not have reasonable grounds to believe that the person defended was in immediate danger of death or great bodily harm, or the defendant did not have an honest belief, even if mistaken, that the person defended was in immediate danger of death or great bodily harm, or the defendant used unreasonable force. Again, caused, deadly force, and substantial risk have already been defined for you. The defendant stands in the shoes of the person he defended. The defendant did not act in defense of another if the state proved beyond a reasonable doubt that the person defended was the one at fault in creating the situation resulting in the injury. The person defended was at fault if he was the initial aggressor, and the person defended did not escalate the situation by being the first to use or attempt to use deadly force, or the person defended provoked Ethan Liming into using force, or the person defended did not withdraw from the situation, or the person defended withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant had reasonable grounds to believe and an honest belief that the person defended was in immediate danger of death or great bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that the person defended was about to be killed or receive great bodily harm. In determining whether the defendant, in using force in defense of another, reasonably believed that the force was necessary to prevent injury, loss, or risk to life or safety, you may not consider the possibility of retreat by the person defended. When considering deadly force in defense of another, you must apply the concepts of words and unreasonable force as I have previously set forth and defined. A person is also allowed to use non-deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using non-deadly force, did not act in self-defense. To prove that the defendant's use of non-deadly force was not in self-defense, the state must prove beyond a reasonable doubt at least one of the following. The defendant was at fault in creating the situation giving rise to the incident. The defendant did not have reasonable grounds to believe that he was in immediate danger or danger of bodily harm, or the defendant did not have an honest belief, even if mistaken, that he was in immediate danger of bodily harm, or that the defendant used unreasonable force. Again, the concepts and the terms caused non-deadly force and substantial risk have already been defined. The defendant did not act in self-defense if the state proved beyond a reasonable doubt that the defendant was at fault in creating the situation that resulted in the injury. The defendant was at fault if the defendant was the initial aggressor and Ethan Liming did not escalate the situation by being the first to use or attempt to use non-deadly force, or provoked Ethan Liming into using force, or did not withdraw from the situation, or withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant has reasonable grounds to believe and an honest belief that he was in immediate danger of bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that the defendant was about to receive bodily harm. In determining whether the defendant, in using force in self-defense, reasonably believed that the force was necessary to prevent injury, loss, or risk to life or safety, you may not consider the possibility of retreat by the defendant. When considering self-defense by non-deadly force, you must also apply the concepts, their headed words, and unreasonable force, words as they are related to self-defense, as I have previously defined. A person is allowed to use non-deadly force in defense of another. The state must prove beyond a reasonable doubt that the defendant, when using non-deadly force, did not act in defense of another. To prove that the defendant's use of non-deadly force was not in defense of another, the state must prove beyond a reasonable doubt at least one of the following. The person defended was at fault in creating the situation giving rise to the incident, or the defendant did not have reasonable grounds to believe that the person defended was in immediate danger of bodily harm, or the defendant did not have an honest belief, even if mistaken, that the person defended was in immediate danger of bodily harm, or the defendant used reasonable force. The defendant stands in the shoes of the person he defended. The defendant did not act in defense of another if the state proved beyond a reasonable doubt that the person defended was the one at fault in creating the incident that resulted in the injury. The person defended was at fault if he was the initial aggressor, and the person defended did not escalate the situation by being the first to use or attempt to use non-deadly force, or the person defended provoked Ethan Liming into using force, or the person defended did not withdraw from the situation, or the person defended withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant had reasonable grounds to believe and an honest belief that the person defended was in immediate danger of bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that Ethan Liming was about to receive bodily harm. When considering self-defense by non-deadly force, you must also apply the concepts of words and unreasonable force as have been previously defined. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter, or if you find that the state failed to prove beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshaun Stafford, not guilty of count 1, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter, and you find that the state proved beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshaun Stafford, guilty of count 1, involuntary manslaughter. Now I'm going to move on to count 2. In count 2, the defendant, Deshaun Stafford, is charged with aggravated assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the second day of June 2022 and in Summit County, Ohio, the defendant, Deshaun Stafford, knowingly caused serious physical harm to Ethan David Liming. Knowingly caused and serious physical harm have already been defined. When considering count 2 aggravated assault, you must determine whether the state proved beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or defense of another, and all of those terms have been previously defined related to self-defense. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of aggravated assault, or if you find that the state failed to prove beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshaun Stafford, not guilty of count 2, aggravated assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of aggravated assault, and you find that the state proved beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshaun Stafford, guilty of count 2, aggravated assault. In count 3, defendant Deshaun Stafford is charged with involuntary manslaughter. Before you can find the defendant, Deshaun Stafford, guilty, you must find beyond a reasonable doubt that on or about the second day of June 2022 and in Summit County, Ohio, defendant Deshaun Stafford caused the death of Ethan David Liming as the proximate result of committing or attempting to commit assault. Also in count 3, the defendant Tyler Stafford is charged with involuntary manslaughter. Before you can find the defendant Tyler Stafford guilty of involuntary manslaughter, you must find beyond a reasonable doubt that on or about the second day of June 2022 and in Summit County, Ohio, the defendant, Tyler Stafford, caused the death of Ethan David Liming as the proximate result of committing or attempting to commit assault. And caused has already been defined. Before you can find the defendant, Deshaun Stafford, was committing or attempting to commit the underlying offense of assault, you must find beyond a reasonable doubt that the defendant, Deshaun Stafford, knowingly caused or attempted to cause physical harm to Ethan David Liming. Also, before you can find the defendant, Tyler Stafford, was committing or attempting to commit the underlying offense of assault, you must find beyond a reasonable doubt that the defendant, Tyler Stafford, knowingly caused or attempted to cause physical harm to Ethan David Liming. Again, those terms caused and knowingly have already been defined. Physical harm to persons means any injury, illness, or other physiological impairment, regardless of its gravity or its duration. As an alternative, the state has also presented the theory that the defendant, Tyler Stafford, acted in complicity with the principal offender, Deshaun Stafford, in the commission of the offense of involuntary manslaughter based upon the underlying offense of assault. A person who is complicit with another in the commission of a criminal offense is regarded as guilty as if he personally performed every act constituting the offense. This is true even if he did not personally perform every act constituting the offense or was not present when the offense was committed. Before you can find the defendant Tyler Stafford guilty of complicity in the commission of involuntary manslaughter, you must find beyond a reasonable doubt that on or about the second day of June 2022 and in Summit County, Ohio, the defendant knowingly solicited another to commit the offense of involuntary manslaughter or aided and abetted another in committing the offense of involuntary manslaughter. Knowingly has been defined for you. A few more terms. Solicit. Solicit means to seek, to ask, to influence, to invite, to tempt, to lead on, or to bring pressure to bear. Procured means to get, obtain, induce, bring about, motivate. Before you can find the defendant Tyler Stafford guilty of complicity by aiding and abetting, you must find beyond a reasonable doubt that the defendant Tyler Stafford supported, assisted, encouraged, cooperated with, advised, or incited the principal offender, Deshaun Stafford, in the commission of the offense, and that the defendant Tyler Stafford shared the criminal intent of the principal offender. Such intent may be inferred from the circumstances surrounding the offense, including but not limited to the presence, companionship, and conduct before and after the offense was committed. The mere presence of the defendant Tyler Stafford at the scene of the offense is not sufficient to prove in and of itself that the defendant was an aider and abetter. The principal offense of involuntary manslaughter based upon the underlying offense of assault has already been defined. The defendant Tyler Stafford cannot be found guilty unless the principal offense was actually committed. When considering this count 3 involuntary manslaughter, you must determine whether the state proved beyond a reasonable doubt that the defendant Deshaun Stafford did not act in self-defense or defense of another. Also, you must determine whether the state proved beyond a reasonable doubt that the defendant Tyler Stafford did not act in self-defense or defense of another when considering count 3 involuntary manslaughter. All of those terms relating to self-defense and deadly force and non-deadly force have already been defined for you. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshaun Stafford, and if you find that the state failed to prove beyond a reasonable doubt that Deshaun Stafford acted in self-defense or in defense of another, you must find the defendant Deshaun Stafford not guilty of count 3 involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshaun Stafford, and you find that the state proved beyond a reasonable doubt that Deshaun Stafford acted in self-defense, you must find the defendant Deshaun Stafford guilty of count 3 involuntary manslaughter. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant Tyler Stafford not guilty of count 3 involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford acted in self-defense, you must find the defendant Tyler Stafford guilty of count 3 involuntary manslaughter. Next, in count 4, the defendant Deshaun Stafford is charged with assault. Before you can find the defendant Deshaun Stafford guilty, you must find beyond a reasonable doubt that on or about the second day of June 2022 and in Summit County, Ohio, the defendant Deshaun Stafford knowingly caused or attempted to cause physical harm to Ethan David Liming. Also in count 4, the defendant Tyler Stafford is charged with assault. Before you can find the defendant Tyler Stafford guilty of assault, you must find beyond a reasonable doubt that on or about the second day of June 2022 and in Summit County, Ohio, the defendant Tyler Stafford knowingly caused or attempted to cause physical harm to Ethan David Liming. Those relevant terms, knowingly caused and physical harm, have already been defined for you. When considering count 4 assault, you must also determine whether the state proved beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or in defense of another. Also, you must determine whether the state proved beyond a reasonable doubt that the defendant, Tyler Stafford, did not act in self-defense or defense of another when considering count 4 assault. All of those terms and concepts related to self-defense have already been defined for you. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Deshaun Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Deshaun Stafford acted in self-defense or in defense of another, you must find the defendant, Deshaun Stafford, not guilty of count 4 assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Deshaun Stafford, and you find that the state proved beyond a reasonable doubt that Deshaun Stafford acted in self-defense, you must find the defendant guilty, Deshaun Stafford, guilty of count 4 assault. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant, Tyler Stafford, not guilty of count 4 assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford acted in self-defense, you must find the defendant, Tyler Stafford, guilty of count 4 assault. Counsel, can you approach, please?
Judge wants a quick word with both the defense and the prosecution to make sure that they have read all of the instructions. This is very mundane, but it has to be done. The jury needs to know what they're deciding and the particulars of each count. In order to be found guilty of involuntary manslaughter, you have to first have been found guilty of assault. So if you find him not guilty of assault, then you can't have guilty of manslaughter. You see both Deshaun and Tyler there with his hands on his head. This is their future at stake here. And from the judge's instructions, we will have a brief recess, maybe not as long of a lunch as they've taken in the past. In the past, it's been about an hour and 20 minutes. And when they come back from lunch, they would then start with closing arguments. I wouldn't anticipate closing arguments to take too long for each side, maybe 20, 30 minutes. You're not going to present the entire case all over again. So just the final things you want the jury to remember. And if you're the defense attorneys for Deshaun and Tyler, you want the jury to head into that jury room with as much confusion as possible, as much doubt in their mind as possible. And you are going to play up who was it? Was it Donovan Jones or was it Deshaun that went and confronted Ethan Liming? And there was an instruction in several of the instructions given the phrase initial aggressor. And I'm looking forward to having our Tara Coleman join us when we take this lunch break, because we will discuss who, if you are the jury, And this may be mixed. This may be part of the problem that the prosecution is going to have. Who should be given the label initial aggressor? You will have some people that say that, oh, absolutely, when Ethan Liming and his buddies decided to show up to the I Promise school and use their splatter guns to scare, or if they were able to hit the three young men who were on the basketball court. We never determined officially if anybody on the basketball court actually got hit with those first splatterball guns, but we know it was Tyler who yelled out, "It's not a real gun." And that's when Donovan claims in his interrogation video that he went to then confront Ethan Liming at the car. And Deshaun himself thought it was Ethan Liming that ran up and shot with the splatterball guns into the basketball court. We know that's not the case. It was Ephraim and Mackay, his two buddies, that went up there to shoot the splatterball guns. But so was that the aggressor? The initial aggressor, does it go all the way back to the splatterball guns, or do you look at this idea of self-defense? Was there reasonable harm or imminent death coming towards you when Deshaun decides to go confront the car full of teens? It's your guess at home. It's your decision. Put yourself in the shoes of the jury. Who was the initial aggressor? Again, you're going to have two sides. I'm guaranteeing everybody watching right now says that Ethan Liming and his buddies were the initial aggressor when they showed up with their splatterball guns. You're going to have the other side, the other half of the people potentially watching, who say no. As soon as the firing was over, the blaster guns was over, Deshaun went and confronted Ethan Liming. He's the initial aggressor.
I'm going to go back to count 3 and reread to you kind of my conclusory paragraphs related to count 3. I did misspeak. There were a few incorrect words. They will be changed and corrected in the physical copy that you will receive, okay? But when we were talking about count 3, involuntary manslaughter, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshaun Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Deshaun Stafford acted in self-defense or in defense of another, you must find the defendant Deshaun Stafford not guilty of count 3, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshaun Stafford, and you find that the state proved beyond a reasonable doubt that Deshaun Stafford did not act in self-defense, you must find the defendant Deshaun Stafford guilty of count 3, involuntary manslaughter. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant Tyler Stafford not guilty of count 3, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford did not act in self-defense, you must find the defendant Tyler Stafford guilty of count 3, involuntary manslaughter. And then we discussed the beginnings of the count 4 assault, which requires that the state prove beyond a reasonable doubt that on or about the second day of June 2022 and in Summit County, Ohio, the defendant Deshaun Stafford in the first instance, and the defendant Tyler Stafford. In the second, knowingly caused or attempted to cause physical harm to Ethan David Liming. Self-defense, we talked about, does also potentially apply to this count, and you must consider those concepts and definitions as they have already been given to you. As to count 4, assault. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Deshaun Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Deshaun Stafford acted in self-defense or in defense of another, you must find the defendant, Deshaun Stafford, not guilty of count 4, assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Deshaun Stafford, and you find that the state proved beyond a reasonable doubt that Deshaun Stafford did not act in self-defense, you must find the defendant, Deshaun Stafford, guilty of count 4, assault. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant, Tyler Stafford, not guilty of count 4, assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford did not act in self-defense, you must find the defendant, Tyler Stafford, guilty as to count 4, assault. Testimony has also been admitted indicating that the defendants fled the scene. You are instructed that defendants' actions in fleeing alone do not raise a presumption of guilt, but it may tend to indicate the defendant's consciousness of guilt. If you find that the facts do not support that the defendants fled the scene, or if you find that some other motive prompted the defendant's conduct, or if you are unable to decide what the defendant's motivation was, then you should not consider this evidence for any purpose. However, if you find that the facts support that the defendants engaged in such conduct, and if you decide that the defendant was motivated by a consciousness of guilt, you may, but are not required, to consider that evidence in deciding whether the defendant is guilty of the crimes charged. You alone will determine what weight, if any, to give to this evidence. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdicts as to any other count. The defendants may be found guilty or not guilty of any one or all of the offenses charged. You must also separately decide the question of guilty or not guilty relative to each of the 2 defendants. If you cannot agree upon a verdict as to both the defendants, but do agree as to one, you must render a verdict as to the one upon whose guilt or innocence you do agree. You must separately consider the evidence applicable to each defendant as though he were being separately tried, and you must state your findings as to each defendant uninfluenced by your verdict as to the other defendant. Counsel, are there any other additions or corrections to the jury instructions so far?
No, Judge. I would renew my objection.
Yeah, that objection will be renewed. And then at this time, ladies and gentlemen, as we discussed, I will take a somewhat shorter lunch break. Why don't we okay.
Again, the defense wanting a few more words with the judge about the instructions that were given. They are trying to be very particular. If your client's future is on the line, you want to make sure that...
All right, so let's take about a 45-minute break for lunch. Let's reconvene about 1 o'clock. At that time, we will continue with the closing arguments of counsel, and then I will finish the instructions related to how you should conduct your deliberations. We still have, obviously, some things to present in these proceedings. You are not to begin discussing amongst yourselves the case at all until we have finally concluded. And once again, do not discuss the matter with anyone else. And I will see you after lunch.
Dan DeRose with 19 News as we get a look at Deshaun, and I believe some of the jury members are going to walk through here, so we're going to jump off of that picture until the jury is out of the room. A little bit of a surprise this morning, and we're going to go through all of it. We're not going to leave our gavel-to-gavel coverage. We will get our legal analyst, Tara Coleman, to join us here shortly to discuss the really, really big surprise move. And I believe the jury is out of the room now. We can see Deshaun there and his brother Tyler, knowing that the end of this trial is in sight and that their futures will be in the hands of that jury. The surprise move was that the defense decided to call no witnesses to the stand, and that is their right. They will talk with Tara Coleman when she joins us about who potentially they could have called, whether they could have called character witnesses, whether they could have called family members, experts, to talk about that. So as we move to the shot of our clock, that tells us that we are going to be, and I see Tara jumping in just right now, so we will have her join our conversation here about the surprise move of the day, that we get no witnesses whatsoever, no experts, no family members joining us or testifying for the jury. Going to welcome in now Tara Coleman. She's our legal analyst. She's been helping us all through the trial. She has witnessed probably just as much of this trial, if not all of it, throughout the whole way to make sure she's informed on it. Tara, how are you today?
Wild. This is wild, right? Yeah.
A little bit of a surprise move.
Yeah, a bit of a surprise move there. But you know, as I was saying yesterday, it was hard to think who the defense could call today. And I think the reason we didn't see any witnesses called today is because I'm not so sure the defense realized how this was going to go. And I think given the inconsistency in the testimony that is creating what I am calling the Donovan Deshaun confusion, I think the defense made a game time decision to double down on that and go that approach of, you know, there's not beyond a reasonable doubt, you know, if Deshaun was the first to approach the car, or if Deshaun is the one to have given that fatal blow to knock Ethan Liming to the ground. And
even
so
though
because of that, yeah, I think they just went with it.
Even though he says it in the interrogation video. I mean, that's the biggest piece of evidence that the prosecution has, is Deshaun, in his own words, 9 days after the fact, saying, I punched him, he went right to sleep.
But Dan, look at all the doubt around it. He lies at first in that interview clearly to protect Donovan Jones and Tyler Stafford's girlfriend. And you saw the defense hit on that a little bit in their questioning. I think he got objected to, but basically said, he's clearly covering for Donovan. And the fact that it came out in this trial that Donovan Jones had way more involvement than what was first brought out almost gives reason to make you doubt that video of Deshaun Stafford admitting to being the first to approach the car.
Why did we not hear from Donovan Jones? We speculated a couple of days ago, wouldn't he be an interesting witness for the prosecution? He gets this deal where he gets a suspended sentence. He's not charged with involuntary manslaughter, even though the three individuals, the three friends of Ethan say, yeah, at one point it was 3-on-1, meaning it was Donovan, it was Deshaun, and it was Tyler, all going after Ethan Liming. Why do we not hear from Deshaun?
I mean, it depends on what he would have said, right? And we just don't know. I mean, the prosecution would not want to call him if he would get up there and say, I was the first to approach the car, I knocked him out. You would think the defense would want to call him in that instance, but maybe the defense isn't entirely sure what the statement is. That to me is a big kind of hole there, because depending on what his statement would have been, it does seem as if one side or the other could have benefited from calling him. So I'm just not sure there.
I mean, you take the chance if you're the prosecution. We know he's the cousin of Deshaun and Tyler. What is he going to say on the stand? He obviously is read his rights. He needs to tell the truth. But it is a wild card, and that maybe is why the prosecution doesn't call him.
Yeah, and he could be maybe not a great witness, right? And you don't know, is he going to be someone that's going to present on the stand to the jury? Was he the troublemaker in all this and the one most involved, even if he's going to say the opposite, you know? So it really just depends on the type of witness and what they're going to say. And it clearly both sides did not see it in their interest to call him. So I don't think we'll know on that one without having inside baseball.
Yeah, big piece hanging out there. Let's talk about the last person who was there, the last witness to this. There were 4 people in the group of Deshaun and Tyler and Donovan Jones, Tyler's girlfriend. And I thought this was a really interesting moment in court yesterday. I'd never quite seen anything like this. They started asking about Tyler's girlfriend, and they asked the lead detective, did you ever reach out to her? And he said, we tried to, that she lived in the Cleveland area, he thought, and that when they noticed that at the start of the trial, they apparently didn't bother coming up here to talk to her. But when they saw her show up for the trial, the detective said to her, we would love to talk to you if you have anything to say. If you have anything to shed light on, we would love to hear from you. And she decided that she didn't want to talk. And in fact, they go as far, the prosecution said, do you see that woman in court today? And the detective said, yes, she's sitting right there in the sweater. So here you have the last person who witnessed this. They only interviewed 6 people in connection with this. They interviewed Ethan Liming's 3 friends, and then they interviewed Deshaun, Tyler, and Donovan Jones. She was the last missing piece. What do you make of the fact that they pointed her out in court? They made it a point to say, is she here today? Can you point to her? And he said, yes, she's right over there in the sweater. What does that do?
And that was the prosecution that pointed her out, or the defense?
It was the prosecution. When the prosecution had the lead detective on the stand, they were asking about everybody he interviewed. They asked about Tyler's girlfriend. He indicated that she did not want to talk. She had nothing to say to them. And he asked, is she here? And he said, yes, she's right over there in the sweater. What does that do?
I see that just getting out of the way. You're doing it first so that the defense cannot use her as a sticking point to say they did not do a thorough enough investigation. So you're getting it out that she wasn't comfortable talking to police. She didn't want to talk to us. And they clearly didn't feel it was necessary to subpoena her and force her to testify. So the prosecution most likely did that so that it's out of the way and the defense can't then come up and use that as a point of not doing a thorough investigation, because we did see the defense do that with the cell phone collection and text message review, which is just such a standard and common thing you would do in an investigation that was not done here. So that could have been just another point to say, You got Deshaun Stafford to say it was him, and you just stopped there. You just took his word for it, and you did not want to get to the truth.
And Tara, we're going to play that. It's just a 4-minute clip here. We've got another half an hour to go here, so we're not going to miss anything. This interesting, you just sort of scratched on the surface. I was baffled by this conversation about cell phones. We know in this day and age, cell phones, whether they're cracked or supposedly dead, they're not ever completely dead. There's always information that can be taken from a cell phone that looks like it's broken. You're about to see the defense question the lead detective, how many cell phones they looked through, they investigated, and what kind of information did they get. Take a look.
So knowing that things change and people change, there are things we could have done to try and see whether, we have scientific things we could have done, right?
Yes.
Like you had the phones from all the boys in the car, and that could have told us what happened leading up to this incident, right?
It's possible.
But according to Detective Mike Williams, he didn't see a need for it, you didn't see a need for it, which would have been simple as turning them on and seeing if you could read the last day text messages, right?
No, it would not be as simple to do that, no.
We all have cell phones. We've all lost data. You have a whole crime lab up there on the second floor and they've got a machine that deals with phones, right?
That's correct.
In this case, we don't even bother to turn these things on to see if you can read them through the glass, the broken glass.
We did attempt to turn them on, but they were broken and they would not turn on.
And there's a next step you could have followed that we just chose not to. We didn't send it out to get looked at. We didn't send it to the crime lab. We just turned it back off.
We sent it to the crime lab for DNA processing.
Well, let's talk about DNA. Well, let's stick on phones for a minute. Ethan's phone's missing, right?
Yes.
That seems odd.
Yes.
It's an iPhone, right?
That I don't know.
Okay. Well, iPhone, Android. When you contact the phone company or talk to the parents and said, find my iPhone, find my Android. Where did it pop up at?
I did not do that. I believe Detective Mike Williams might have.
We didn't hear about that, right? I mean, that's a mystery where the phone went.
Yes.
We don't even know whether or not someone's still using that phone today. I mean, the phone company would have records, but somebody would have to go get them. And no one did that, right?
No.
And likewise, maybe even more importantly, these boys on the basketball court had 9 days to talk back and forth to each other. We could assume. They're all relatives, right?
Yes.
They all are reading the paper and watching the press conferences, and you can assume, you can guess they're probably talking about getting their story straight.
It's possible. I don't know.
You took each one of their cell phones into custody when you arrested them, did you not?
I don't recall. I'm not sure.
That would be pretty easy to do. You arrest them, you take them, you ask for their cell phone, and then you turn the cell phone on, you look back and you go, that's where you guys got your, that's where you did that. But we didn't even turn on the suspects' phones to see what kind of things they were saying before the incident, after the incident. That'd be good to know, wouldn't it? Especially now with Donovan's different involvement.
Yeah. Through the course of our investigation, through our 6 interviews, I did not see the need to have the phones due to the cooperation of everyone.
I guess what I'm saying is we don't know these people, these kids, these other people.
I would object. That's not a question.
We got to take this 19-year-old at his statement, and that's what we're doing.
Yeah.
Sustained.
You know damn well that Deshaun was covering for Donovan that night when he said a random person. Right?
I have no idea. I
He knows who
don't know
Donovan
his
is.
character.
He knows who Donovan is.
I would object.
Sustained.
You know he knows who Donovan is, right? They're cousins.
Correct.
kept Donovan out of it, covered for him.
Correct.
How do we know he's still not covering for him?
I wouldn't know.
Based on what these boys said about Donovan's involvement, based on Donovan no longer being part of this, wouldn't it be good to at least have looked at the cell phones or asked somebody? We just took that interview, case closed. No further investigation. Is that what happened?
There was more than just that in our investigation. There was a lot of evidence and a lot of different other things as well.
You just heard some really good cross-examination by the defense. Again, put yourself in the shoes of the jurors. The defense has to send you to that jury room with enough doubt that maybe they just didn't do a good enough job here. We've got Tara Coleman, noted defense attorney here. She's our legal analyst for this case. Tara, that was some kind of cross-examination. We all know the power that cell phones have, and they didn't look into anybody's cell phone, let alone find Ethan's phone. Let's start with, you didn't look through Deshaun's phone. You didn't look through his brother's phone. You didn't look through the cousin's phone to try and find text messages that say, hey, man, this is what you're going to say. And if they ask you this, you're going to say this. And I can't believe this. I can't believe the punch I threw killed that kid. There had to have been a conversation between those three individuals.
That's huge. And even if there aren't texts, even the phone records, is there heightened back and forth during that time. And remember, this defense attorney is a former prosecutor. So he knows the capabilities. He knows how commonplace it is to image cell phones. And it does not matter if those cell phones were cracked. They didn't take images. And that's just very commonplace. We even do that in civil cases, right? Let alone where you have people's livelihood and life on the line, right? To be possibly put away to prison. Of course you do that thorough investigation. I thought that was very, very to their advantage to point that out. And it's beyond me why that didn't occur. And what it is probably leading the jury to believe is once they heard Deshaun Stafford's interview, they kind of just wrapped up their investigation and went with that narrative. And the big issue there is, as the defense pointed out, it is clear Deshaun Stafford may be covering for Donovan Jones.
Because, and we know that, because in the beginning of that interrogation video, he says there were three of you on the basketball court. Who was there? And he says, it was me, it was my brother. And they said, okay, who's the third guy? And he said, some random guy. Claimed he didn't know him. Well, at that point when they're interrogated, they know who it was. They knew that it was Donovan Jones. Donovan Jones had already been arrested. He was arrested the same time that Deshaun was picked up and that his brother was picked up. So they knew they were lying. He was lying there. They go on to say there was a fourth person on the court. Who was the woman that was on the basketball court? He says, we didn't know her either. Well, he's lying there too because we know that was the girlfriend of his brother. So
yep,
you
and
send.
If I'm on the jury, I'm like, isn't that a lead you might want to follow up on? Does that kind of cause some doubt into how that interrogation went? Especially you have him in there. He didn't ask for an attorney. He, was read his Miranda rights and wanted to get that story out. So it is, it does lead you to believe or think that could be a possibility that he was covering.
And let's say this, in that interrogation video, we do see at the very beginning, they do read his Miranda rights. In fact, the detective says, he doesn't read through the whole thing. He says, you have the right to remain silent. Do you understand that? And he says, yes. You have the right to have an attorney present when we question you. Do you understand that? He said, yes. He read the whole thing to make sure that he wasn't confused by the whole paragraph. He read it line by line, and he still spoke. Tara, as a defense attorney, should you ever talk in that situation, seeing as how that's the big key piece of evidence that the prosecution has right now? Really, the really big smoking gun here is him saying, yeah, I walked up, I punched him, and he went right to sleep. Should you ever answer questions from a detective without an attorney?
No, don't.
You're just going to leave it right there and just say, don't. You can see where in this case, it got Deshaun where he is. Because if you have the other three take the stand and say, well, I think it was Donovan, one says, I think it was Deshaun, there you have a lot of doubt to send the jury. Think about how much doubt the jury has going in without the video of Deshaun in the interrogation room.
Right. Exactly. And what's great here for the defense is even with that interrogation, there's even some doubt there. So again, that's truly, I do believe that's why they rested today, just because of how this has played out.
Let's talk about, and we discussed this during yesterday's break, what happens in every trial when you have the prosecution, you have the defense. When the prosecution goes first and they get done with their case, there's always this point in the middle where the defense comes to the judge and says, look, Judge, I don't think the prosecution did their job. I don't think they proved beyond a reasonable doubt, so I want you to throw this whole thing out. Let's stop right now and throw it all the way out. We're about to play you the clip of the defense asking for this to be thrown out. I want you to be very clear if you're watching. I want to be very clear. The jury is not in the room for this. That is a major point. This is a conversation between the prosecution, the defense, and the judge. The jury is not in the room for what you're about to hear. This played out this morning when the defense, before they were about to present their case, they have the ability to ask the judge to throw the whole thing out. Take a listen. This is 7 minutes. They lay the groundwork, and then the prosecution gets to come back and say, well, this is why we think we did do our job. And then you get to hear the judge's response. Take a listen.
At this time, on behalf of Defendant Deshaun Stafford, I will move for a directed verdict of judgment of acquittal on all charges. I recognize that it's unusual, to say the least, for a court to take this decision away from a jury when we are this close. It would be that unusual, exceptional case. This might be that circumstance. This might be that circumstance, especially as it relates to count one, the involuntary manslaughter by way of aggravated assault. We've got some real issues. The state has some real issues with causation. In order to find my client guilty, a jury would have to find beyond a reasonable doubt that he caused the death of Ethan Lyman. When we started out here, maybe that was just assumed, but that is no longer a safe assumption. There's been ample evidence that somebody else was involved in this, namely Donovan Jones, that Donovan Jones may have been the aggressor, at least as it relates to the boys involved in their response to Ethan and his friends. And when it comes to causation and when it comes to serious physical harm and the deadly force required, none of that's been proven. All the assumptions we had early on kind of fell apart with the state's case. At this time, Your Honor, I'm asking this court to take this, at least portions of this case, specifically the felony 1 aggravated assault and the felony 1 involuntary manslaughter by way of aggravated assault, the felony 3 involuntary manslaughter by way of assault, and I'm asking to direct those out. There's not sufficient evidence to send those to a jury. At most, what you send to the jury is what Donovan walked away with, which is the misdemeanor assault charge. Thank you.
Mr. Gallagher.
Then I too would make a criminal rule 29 motion for a judgment of acquittal. It's a two-part motion. The broader concept is under the new law, the prosecution is required to show that there was any act that Tyler Stafford made was not self-defense. I don't feel that they've done that. If he was acting in self-defense, they haven't proven otherwise. That's the broader part of the motion. There's a more specific, tailored, the second part to the criminal rule 29 motion, and it goes to the third-degree felony and involuntary manslaughter. Specifically, looking at the indictment and also looking at the bill of particulars that we were able to obtain. It's a rather lengthy bill of particulars, but I would say what we used to call the two-wit would be in paragraphs 7 and 8. And in paragraph 7 and 8, they're talking about Deshaun Stafford, Tyler Stafford, and then in paragraph 6, Donovan Jones engaged in a fist fight with Ethan Lyman. Paragraph 8 says that Ethan fell backwards from the blow, hitting the back of his head on the pavement. He was knocked unconscious and died from his head injury. So the person who caused his head injury is the person who is potentially responsible for involuntary manslaughter if it's not a self-defense act. We heard from the medical examiner that testimony that Tyler Stafford did anything to cause Ethan to fall backwards and hit his head. There's no testimony that Tyler Stafford slammed into the ground. We heard testimony from one witness that Deshaun Stafford hit him and knocked him backwards. We heard testimony from two others saying they think it might have been Donovan Jones. We heard no testimony of any time that Tyler Stafford did anything to cause the death of Ethan Lyman. And going on what our notice comes from the indictment and from the bill of particulars, specifically paragraph 7 and 8, that was not proven. There was no testimony to this. The only thing we had was from Detective Hornacek at the end. He said, well, there was a statement all three jumped him. Like all three are responsible for the manslaughter. Well, that's not in the indictment. That's not in the bill of particulars. So we're relying on this bill of particulars to tell us what the legal theory is, what the allegations are, how to defend ourselves from the facts of the law. There was no testimony backing up this bill of particulars. So you're making a broader Rule 29 motion on self-defense for both of Tyler's charges, but very specifically to the third-degree felony involuntary manslaughter. Causation and proximate cause, they're just not there.
Your Honor, and I'm sorry, I want to adopt Attorney Gallick's, the argument made for Tyler. I want to adopt that from Deshaun. I never got past cause and whether or not Deshaun even caused this in my argument. But really, for the state to prevail, they've got to prove, there had to be evidence that Deshaun did not act in self-defense. There had to be some evidence of that. They got to prove that to this jury. We never got that far. There's been no evidence that would establish that Deshaun was not acting in self-defense. We heard from no one that said anything contrary to that. There's no way that a jury can find that Deshaun didn't act in self-defense because no evidence was presented to that. And that's the effect of the new law, and that's the burden shifting. So I just said in my opening argument here, Attorney Gallick brought it up for Tyler, and I'm bringing it up for Deshaun. I think that's the powerful point. Thank you.
On behalf of the state.
Thank you very much, Your Honor. Just very briefly, may it please support. Your Honor, the state does believe that we have met our burden in terms of presenting our case to the jury for their consideration. Regarding Deshaun Stafford, he does have the involuntary manslaughter by way of aggravated assault. The state does believe that the evidence presented is enough for the factual determination to be made by the jury regarding causing serious physical harm to the deceased, Ethan Liming, and that his death did occur and was caused by that aggravated assault. Additionally, the state does believe that we have met our burden regarding the essentially the lesser count of involuntary manslaughter by way of misdemeanor assault in the event that the jury were to find that facts would play out that Deshaun did not cause serious physical harm and just find that he did assault Ethan Liming. The evidence was quite clear, Your Honor, that this was not a situation of self-defense, that this was in fact a brutal attack, initially by Deshaun, an older young man, and then ultimately with his brother and cousin joining in, ultimately creating a 3-on-1 fight situation. That did cause the death of Ethan Liming, Your Honor. Additionally, we did prove that was on June 2nd of last year here in Summit County, Ohio. Additionally, Your Honor, regarding Tyler Stafford, the state has met its burden there as well regarding the involuntary manslaughter by way of assault. Evidence presented by several witnesses and statements of the defendants themselves indicated that they were actively engaged in a fight with Ethan. Really, to call it a fight, Your Honor, is insulting. It was not a fight. It was just an attack.
Strong words there by the prosecution in the attempt by the defense to implement Rule 29. That's essentially saying, Judge, we want you to throw this whole thing out because we don't think they met their burden of proof. The judge ultimately disagreed with the defense and will proceed, obviously, to let the jury make the ultimate decision. Tara, that was not a surprise. We know this happens, and 99.999% of the time, the judge doesn't agree and lets it go to the jury.
That's right, Dan. I would agree with that. It's such a high bar to get a directed verdict. Well, we call it directed verdict in civil cases. Here, a motion for judgment acquittal. And it's just such a high bar, but you have to do it. I will say, in this instance, if there was a strong motion, Rule 29 motion, this was one of them. I will say that.
Yeah.
Even
So
though
you're
it's no
telling me there's a
surprise-
chance kind of situation.
Yeah, but it's no surprise that this was not granted because, giving the case over to the jury is such a core tenet to our justice system that it's very rare where we take that opportunity away from a jury. So it's not surprising, but I will say of the Rule 29 motions you'll see, this is one of the strongest ones you'll ever see.
Yeah, talking about the confusion. We're not going to play for you the jury instructions because we want you to stay awake. You may have had a lunch and you don't want to be put to sleep right now. But there are a couple of terms, Tara, that I want you as a defense attorney to help us understand. This phrase, initial aggressor, when it comes to the assault charges and the involuntary manslaughter charge. And from my position sitting through this entire trial, I'm not going to take a position, but from what I see, you could make the argument, and there could be this argument in the jury room, that there's going to be a disagreement on what it means to be the initial aggressor in this case. As I said earlier, you're going to have half the people or some percent of the people who say, well, it was Ethan and the three young men who show up with the splatterball guns. They initiated this whole thing. They're responsible. They started it. You're going to have some people on the other side of that coin that say, well, wait a second. That's not the initial aggressor. Once they shot those paint pellets or the splatterball pellets, they went back to the car. You're going to have some people who say Deshaun was the aggressor when he came over to the car and wanted to confront Ethan. You can say that, oh, this was basically over. If they would have stayed on the basketball court, if they were worried about their safety and self-defense, they could have said, and I'm surprised we didn't hear this from anybody. Why didn't they just stay? And maybe we will hear this in closing. If they were so worried about their safety and self-defense, why not stay on the basketball court? But then you have Deshaun, who comes over to the car, confronts Ethan. We know Ethan does shoot him again at close range. And so there may be the instance for initial aggressor. But that's going to be tough for the jury to decide on exactly who is the initial aggressor.
It is. That's going to be very tough for them. And I noticed that there was not necessarily an instruction to guide the jury as to what point in time they should be considering when it comes to who is the initial aggressor. So everything you just laid out there is most certainly going to be a conversation that's going to play out in that jury deliberation room. But you have to remember, before you even, get to the self-defense question, you have that causation question, right? And it's, did the act of Deshaun Watson, is that what led to and caused the death? And if that's the case, you have to ask, okay, well, was that act in self-defense? So if you think of it that way, you would tend to analyze the initial aggressor after the actual fight starts. But again, they were not directly instructed on that. So that could be something we see cleared up a bit in closing arguments, or they'll kind of just leave that up for the jury to decide. But everything you laid out is certainly going to be discussed in that deliberation room.
I think you've got a little football on the brain. It's something I've had to you said Deshaun Watson. We're, of course, talking about Deshaun Stafford. Don't worry about it. It is... it is.
I apologize.
No. It has been obviously we're dealing with Deshaun here and Deshaun Stafford. It is an easy mistake to make, but I can definitely see. I'm sure, and I'm going to be honest, I haven't been watching our Facebook comments. We've been obviously streaming gavel to gavel coverage here. I bet there is sort of an argument happening on social media during the coverage as to who should be considered the initial aggressor. You can absolutely see the side of the people who say, oh, clearly a car full of 4 young men with splatterballs showing up to shoot towards 3 young men who were just playing basketball. They are the initial aggressor. But then again, you can see on the other side of that coin, no, the shooting was done. They went back to the car. This whole thing should have been over. It was Deshaun running up to the car to confront them. Now, is he the initial aggressor? And then you have the third one. Well, no, wait. Ethan Liming is then given the splatter gun, and he shoots Deshaun at close range. Isn't he the initial aggressor? Going to be something that can tie up a jury in this? How big of a sticking point is that for the jury?
I think that's a big sticking point. And I just want to point out, Dan, that's why coverage like this is so important, because this very discussion we had, so I'm home and having birthday dinner with my family, and we were actually discussing this, and a lot of views came out. Well, it's so unfortunate, but they went with these splatterball guns and set all this emotion. And if you don't hear all of the facts that come out, how we've heard this play by play, it really doesn't give you the context to consider all of this. And so the jury is going to be the most knowledgeable people at this point to have that discussion in that deliberation room. And it just points out to me how important this coverage is, because just from the outside, just knowing the basic facts, everything you laid out is going to be the argument, but you need to have the context around it all to sift through it.
And we haven't even touched the stomping, the kicking, and you got that from the defense, and you even heard that from Attorney Gallick when he tried to get the entire case to try and get an acquittal for his client, Tyler. He said, look, all the extra stuff was unfortunate, but it wasn't what caused his death. What caused his death was when he fell back, hit his head, the brain injury, it jarred his brain. That's what caused the death. We haven't even discussed the whole how that weighs with a jury, and I'm going to ask you that. That's not what caused his death, but the fact that it was 1-on-3 at some point, whatever point you think when Ethan went back and hit his head, and I've thought about that too. Of course, Deshaun is going to say in his interrogation video that he went to square off with my brother. My brother called out my name, so I went and hit him. That's when he went right to sleep. Well, then where does Deshaun come in? Again, he was protecting Deshaun like he didn't even know him. So you have three witnesses who get on the stand who say at one point it was, in fact, 3-on-1. It was stomping, it was kicking. In the words of one of the witnesses, it was ground and pound once Ethan was on the ground. Where will that weigh with the jury, or does the jury need to, and I'm not saying it's not a factor, it is unfortunate, it is terrible if that happened, but does the jury need to put that out of their mind?
So where that's going to play in is when the jury has to determine whether or not the state has proved beyond a reasonable doubt that the defendants did not act in self-defense or in defense of another. And when you have these kind of what we'll call, I guess, extracurricular actions, right? That tends to undercut that they were acting in self-defense. If you go through each of those four elements, if you have revenge on if it looks like a revenge type action, it's going to undercut if they were really acting in self-defense. So I think that's where it's going to play in the jury's mind. If I'm the defense in closing arguments, I'm hitting home. Here, you consider up to this point.
And that's what matters. And I'm not about to demean anything, but if you're truly in this idea of I was worried for my brother, I was worried for myself, that's why I punched him, he was going after my brother, I think we can all agree, okay, on the surface that looks like self-defense. Then he makes the comment that he went to sleep, and so that means he's knocked out. Well, the threat is ostensibly over at that point. I can't be threatened anymore by somebody who's knocked out. The detective then asked him, what'd you do after that? He said, I hit him twice. He said, after he was knocked out, you hit him 2 more times? And he said, yes, I hit him 2 more times. So again, this is going to be tough for the defense to get away from or to clarify this explanation of self-defense.
Right.
As a defense attorney, what do you, let's say you are the defense attorney for Sean Stafford, How do you craft this message? What needs to be in your final message to the jury before they head into that room?
You're going to have to break down very clearly causation and the importance of causation here.
Explain causation. I know that's...
Yeah, you don't even get the underlying charge, right, without that. And so here, and let's go to the jury instructions, right, how they were instructed. Okay, so you're going to have to show that Deshaun Stafford caused the death of Ethan Liming as a proximate result of committing assault. Okay, now the cause action is going to be whatever action you set in play. The assault has to be a natural and continuous sequence that directly results in the death. That means this is all going to come down to who threw the punch to knock Ethan to the ground. Now, because we have the medical examiner saying the cause of death was when Ethan Liming hit the concrete, okay? Everything that happens after that point, you just hit home, no causation there. Anything that happened after Ethan hit the ground did not cause his death, okay? So those actions are not what lead you to finding either Deshaun Stafford or Tyler Stafford guilty of involuntary manslaughter. And I think that's how it's causation. And you just have to explain that clearly to where after the point of death, you know, that's what my client is charged with up to that point. There are no, you know, the charges aren't based on the actions that occurred after that.
Now let's get to the prosecution's side of things. And if you're just joining our coverage, I'm watching the courtroom while the judge said we'd be back around 1 o'clock. We've been a little late before, but this was going to be a shortened lunch. When we come back from lunch, it will be closing arguments. Both the prosecution, the defense will be given time to go right up to the jury. This is generally when we see some of our most dramatic moments in court. I suspect we will see the gun come out again. I suspect when the defense goes to make their argument, he will rattle off that splatter gun and say, my client thought he was being shot at. That creates this level of fear. That creates this level of I need to protect myself. And that leads into defense, so self-defense. So now let's flip the coin. Let's go into the prosecution side of things. What does the prosecution need to hammer home to get a guilty verdict before that, or to get a guilty verdict as that jury heads into the room?
Yeah, so I'm not as good at this side, but if I'm the prosecution, I think you are going to be highlighting all of the actions that took place along the way that will lead one to believe that this was not self-defense, that these were revenge actions, right? So all the extra, what we call the extracurricular actions, you're going to hit on that. You're going to hit on the fact that the prank was over. Why come back to the car? So anything you can plant in the jury's mind to undermine that they truly acted in self-defense is that what they're going to have to hit home as the prosecution.
We're looking live inside the courtroom. We have seen Tyler Stafford make his way. Now here's his brother, Deshaun Stafford, making in his way. Before we let Tara go, Tara, explain to our viewers how important the next, let's say, closing arguments, and maybe you can help us there. You don't want to belabor the point here. If you're either side, if you're the defense or the prosecution, you don't want to take an hour. You don't want to make this seem like you're grandstanding. How long do closing arguments take, and how important are they?
Yeah, so judges usually have standing orders on how long you get, or it will be decided ahead of time how long each side gets. But you're right, you do not want to bore the jury here. And it's hard to be boring in closing arguments because they're so crucial, but you just want to be spot on and get into their minds what they need to be thinking about. But I will say, in my opinion, closing arguments, this is where the game is lost or won. I mean, this is so important because this is, you're going to lay the context and how the jury should be thinking about all of the evidence they've seen across what we're on day 4, these 4 days. So highly important, but you're right, Dan, you want to be as succinct as possible and as powerful as possible in your closing arguments.
No stuttering, no stammering. I think it was this, or you remember we kind of had that day.
And not rehashing a lot of things. You're not going to rehash a lot. You're going to highlight the key basics that you want to make sure they remember.
And then let's talk about, because I don't know that we'll see you again until we get a verdict. Let's talk about the jury in a case like this. Let's assume, and we're just going to make a little bit of an assumption. Again, we're looking live in the courtroom. We're not missing anything. We're going to make sure you see every single second of this. Let's assume closing arguments are 10, 20 minutes, maybe from each side. The judge will then have to give the final, here's what you're going to do. You're going to go back and elect a jury 4-person. Then you're going to start a conversation, and she'll give those final instructions. So let's say the jury has this case by 2 or 2:30. Any predictions for how long a jury could deliberate in a case like this?
If we end by 2 o'clock, I'm not so certain we'll get wrapped up today, because I don't think this will take long at all. Don't get me wrong. However, jury instructions are just so dense. It's just a lot you have to get through. And remember, we have self-defense and defense of another. So for each count, for each defendant, you have to go through 2 different analyses, and they've got to do that step by step. So aside from the back and forth, just, oh my gosh, what's going to happen when they get in there, just the part of going through, okay, now that we've discussed and applying the law, that itself is going to take them at least, an hour, hour and a half or so. So I would imagine if we could get a verdict today, but I would think they might take the rest of the day to deliberate, and we should hear something Friday.
And that's the difficult part here, is we know that this particular courtroom in Akron, this judge does not hold court on Thursdays. So there is this idea of, and we've seen this in the past, the bailiff will go to the jury and say, do you need more time, or are you close? Do you want to work through dinner? Do you want to break for the day? Do you want to come back Friday? If you're the jury, you kind of want your life back. You've been wrapped up in this. They did jury selection late last week. Now you've been sitting in 4 days worth of testimony. You kind of want your life back. So the jury could decide, well, we think we're close. Maybe we'll work through dinner. But again, these are all things that play out. Tara Coleman, I want you to answer for us. What will the jury have to decide, or what can they decide? Guilty across the board? Can it be not guilty on involuntary manslaughter, but guilty of assault? What can we see here?
Oh, Dan, don't make me do that. It's going to come down to self-defense, though. It really is. Mm-hmm. And if they can get it self-defense on 1, I imagine everything's going to be knocked out. So I don't see because that applies even to the assault charge, right? So that's what this is going to come down to. And you bring up a good point. If the judge does not mind them sticking around late and working through dinner, we could get a verdict today. But if the judge kind of encourages them 5 o'clock to wrap up, if they don't feel ready, we'll see them continue on. But that's a good point. If we want to go late, they have that option. We could see it wrap up today.
And I'm glad I kept you on the line, because as we just saw, all the attorneys have gone back to meet with the judge again. Tara, you've been in these situations. You've been called into the judge's chambers before we get to closing arguments. What is the conversation happening right now? Is she laying out, this is how much time? Is she laying out the rules? I don't want to see this. I don't want to see this. What is she doing?
Right now, I am assuming something's going on with jury instructions, because I believe the court actually had to reprint It sounded like there were some misreads, so they actually had to reprint the jury instructions. So she's gonna want to make sure that everybody signed off on those final copies that actually go to the jurors. And yes, she's going to be going over the ground rules of, as you know, you have 30 minutes or X amount of minutes for closing arguments. I don't want to see any XYZ. So yeah, they're going over that, but I bet they are doing a final sign off on the instructions. And then there are going to be another set of kind of administrative instructions as well. And the judge might be giving counsel a heads up on what she does there. Those aren't usually as negotiated as the ones we have previously heard.
And the reason those are so negotiated is because there are little nuances in each one of the charges. If you find A, then B, then C. And if you're a defense attorney, you want that, maybe I don't want that last part. I don't want that then C part in there. That's what's being negotiated.
Exactly. And this is something that's happening in real time. I mean, you'll have starter sets that you're starting off at before trial, but as trial goes on, I mean, they very well could have been up, till midnight, wee hours in the morning, still going over jury instructions. And I think the judge even mentioned that. She's like, counsel and I have, been working really hard on this. So yes, that is something that before close of trial, you are spending a lot of time on, and it is crucial. It's so important.
Explain to us, obviously the attorneys are now back in the courtroom. As soon as we see the judge, we will wrap this up. But explain to me and the rest of our viewers a hung jury. Let's say they hear closing arguments, they are given the instruction, the administrative instructions, they go back, they start to deliberate. They just can't come to a conclusion. It has to be unanimous, or Tara, walk us through that.
So in criminal cases in Ohio, juries do have to be unanimous. So if they cannot get there, that's going to be a hung jury. And sometimes the judge might have some leeway to counsel and see what goes on there. But ultimately, if you do get a hung jury, it could, just result in a mistrial and we're back at the board. So we'll have to see. But yes, we for criminal cases in Ohio, it does have to be unanimous.
We've gone back to our clock shot, which tells us there's some administrative work being done, waiting for the judge to come in here. Tara, you mentioned you don't expect this to take long at all. First of all, we've seen in other cases, and our shot is now frozen. The clock did not stop. We'll work on that. But Tara, you said you don't expect this to take long. First of all, because we've seen other cases where, there is murder, it's aggravated murder down the line, it's aggravated assault, everything. This is a fairly small list of actual charges.
Yes, and it's a small list of charges. I think they've got 4 counts they've got to go through. And the reason it's going to go so quickly is because once you get the initial analysis done as to whether they think the defendants were acting in self-defense or in defense of another, once they get that ironed out, it's kind of going to apply like dominoes, right? And apply to each of the additional counts. So it's really going to be, once you do the analysis, once you've done it the 4 times,
Yeah, that makes sense. And it looks like, I just wanted to see some moving around in the courtroom. I know I'm reluctant to let you go, but it's how much time do I want to try and fill if we have another sidebar here? Like you said, it may be just the printing off of jury instructions has to be redone. The judge would want those done before we head into closing arguments. The prosecutor there looks like he's getting ready. The judge is back into the courtroom. So Tara, this is where I'm going to thank you immensely for your incredible knowledge. You have been so helpful for all of us to understand the legal side of things. So thank you so much. Tara Coleman, noted defense attorney in the Cleveland area. We certainly appreciate the time. Thanks for joining us again. All right, take care. Back into the courtroom now as we wait for what is going to be, as you heard from Tara, this is where ball games are won and lost in court cases. When it comes to both the prosecution and the defense, Closing arguments are vital. It is the last thing the jury is going to hear, other than you have to elect a foreperson and this is what you're going to do. Other than that, this is the last impression you get with the jury to say, this is how I made my case, or this is how the state did not make their case. We will definitely be hearing a lot about the name game, the confusion of who came over to the car first. You had 2 of the 3 witnesses say that it was Donovan Jones, but that they could be mistaken. And you only had 1 of those star witnesses say it was Deshaun Stafford. Taking you live back into the courtroom for closing arguments in the I Promise School beating death of June of 2022.
Okay, please be seated. Ladies and gentlemen, at this time, counsel is prepared to present their closing arguments. As we have discussed in the past, closing arguments are not evidence, but they are counsel's opportunity now to review for you what they believe the evidence has shown over the last few days. So on behalf of the state, Mr. Kuhn.
Thank you very much, Your Honor. Judge, may it please the court. Good afternoon, opposing counsel. Good afternoon, ladies and gentlemen of the jury. As I introduced myself previously, my name is Matt Kuhn. I'm one of the assistant prosecutors here for Sumter County. I'll be doing the first portion of our closing argument today. It'll be split up into 2 parts. I get a chance to try to direct your attention to some of the evidence that we've seen and heard throughout the last week. And then the defense gets a chance to submit for your consideration what they think are important pieces of evidence or things to focus on. And then my coworker, Prosecutor Shook, will get a chance to do a rebuttal. And so I know you folks have done a great job thus far paying attention, and we all listened to the judge's instructions regarding the law, and those were kind of tedious. It took a long time to read through that. It's not an easy process. When you folks agreed at voir dire to become part of this jury, you knew that this was your civic duty. It's not called civic fun time. It's a duty. It's a very solemn event. And in certain cases that are maybe less serious, we'll say, of less magnitude, there might be a little bit of joking around throughout the trial process. And there were maybe a couple lighter moments throughout the trial here. I think there was a comment about the Browns game Monday night, and a few folks sort of chuckled or something. But in a case like this, it's very difficult to joke around much. And part of that reason is because I want to appear as a serious person, a serious professional. And I believe I do. But part of it is that I do not want to insult any of the spectators on either side here, because this is a very serious process that we're engaged in here. This is very serious. It's not a joke for these 2 young men right here. It's not a joke for us. I'm sure it's not a joke for you. It's not a joke for these folks. And part of it is it's not a joke for Ethan. Okay? And I'm going to put my PowerPoint up here on the screen in a minute. And so I probably will just be sort of holding up some of the state's exhibits that we've used throughout the course of the trial. I won't be putting them up on the screen, but you'll have all these things back in the back. Okay? And I want you to take your time, and I'm sure you will, and go through them and give them that same due respect that they deserve. folks have heard these names, heard this case number. State of Ohio versus Deshaun and Tyler Stafford. You know that's what we've been hearing all week. And by now, I hope it's been made clear to you, we are talking about an event that was on June 2nd of last year. So last summer, a little bit over a year ago. And that was at about 10:45 at night, maybe a little bit before that. Over at the I Promise School, 400 West Market, obviously here, Akron, Summit County, Ohio. Those are things that we had to prove. We couldn't just say, oh, this was at I Promise, and sort of hope or assume that everybody knows what that means. Proving where it occurred is part of the process, and so that's why we would oftentimes ask witnesses where it is. Oh, hey, is Akron in Summit County? Obviously it is, but we have to prove that so that can be demonstrated on the record. Okay? And we got witness testimony, I think undisputed testimony, that the Stafford brothers and their cousin Donovan were hanging out at the school, minding their own business. That's the tough part of this case. These guys were minding their own business and were sort of involved in a prank that Ethan and his friends decided to pull. They approached the school in a car at night in the dark, rolled up on it quick, hopped out, ran up shooting these splatterball guns. Not a bright idea. However, most pranks are not bright ideas. It was a joke. It was a goof. They shot the splatterball guns, and presumably it had the desired effect that the folks on the basketball court ran to the far end of it. They believed something was going on that they did not want to be a part of. Whatever it was, didn't have the marks of something good. They ran. At some point, however, it became clear to them. And we got testimony and reports that Tyler yelled out, "It's a fake gun. It's a toy. It's a prank. It's a joke." Okay? Perhaps rightly so. The young men on the basketball court were not happy campers about that. Okay? And we saw the video. You'll have that back there for your consideration as well. You will have all the videos that we've watched. If we went through them too quickly, or if there was a part you didn't quite catch what happened, you can watch it to your heart's content until you are satisfied that you've reviewed that evidence to your satisfaction. But the video shows that Ephraim and Mackay hop out. Ephraim hops out of the front driver, Mackay's in the back seat, Ephraim's front passenger, Mackay's back passenger seat. They run up, shoot the splatterball guns. We got to hear that. It was a fairly loud, annoying sound. We are in a room with enclosed walls and ceiling. I would submit to you that it may sound differently outdoors in the wide open. Additionally, I would submit to you, and we have testimony, it doesn't sound like a gun. It might sound like something annoying or weird. It does not sound like a gun. It does not sound like a machine gun. Okay, when Ephraim and Mackay run back to the car, I think everybody's pleased that the prank has gone as expected. They caused the guys on the court to run, and that's how a prank goes. However, the gentlemen on the basketball court were not as pleased about it, and we see video of Deshaun approaching the car. And he's walking from the court, he has a basketball, and at a certain point, the basketball goes to the ground. I would submit to you that that's in the video. It may not have been clear when we're watching it on the screen here, but I would submit to you that you can see that happen as Deshaun walks past the passenger side of the car. He drops the ball and walks around the back side of the car to approach the driver, Ethan, who has now stepped out of the driver's seat of the car. I would submit to you that the purpose for dropping the basketball is because he is no longer playing basketball. Something else is about to happen. When Deshaun approaches Ethan, according to the testimony of the witnesses, and according to Deshaun's statement, Ethan shoots Deshaun with the splatterball gun. We had testimony that it was in the upper torso. We got some testimony that it was possibly in the face. Again, not a great idea. However, we also had testimony that at that point, the kids in the car still believe that this is a funny prank, and they testified that they saw Deshaun's face, and he did not seem upset. He was grinning, or smirking, or laughing. And we heard testimony that he said, are you serious? Is this serious? Something to that effect. If I recall correctly, that was Lamardi who supplied that information. And it was not clear that Deshaun was upset until Deshaun went for the gun, went for the splatterball gun. Understandable. At that point, the testimony that we heard was that Deshaun punches Ethan and the fight is on. Okay? And the reason why I just did air quotes right there is because perhaps initially, maybe right at the very start, maybe that is a fight, a mano type of a deal. Ethan versus Deshaun. Now we heard a lot of chatter early on, perhaps in opening statements from the defense about the hulking giant that was Ethan. And we heard testimony that he's a good-sized young man, good-sized kid, but he's not the Incredible Hulk. He's 5'9", 172 pounds. That was verified by the medical examiner who personally measured his dead body and weighed his dead body with a scale that is calibrated on a yearly basis. There was this physical altercation. It didn't last long as a one-on-one fight. Almost immediately, Tyler and eventually Donovan join in. We heard that it went from one-on-one quickly to two-on-one and three-on-one. Those are bad numbers. Those are bad numbers to be in a fight. And we heard testimony, and it's corroborated by not only the videos that we have, but also the physical evidence and the photographs that we have, that this fight, this assault, it sort of progresses down the parking lot. And we were all out there the other day. We had the good fortune of being able to go out there in daylight hours, and they had it blocked off for us so that we were not interrupted or had a bunch of cars in the parking lot blocking our view or maybe inhibiting our understanding of where everything was. We had a great opportunity to walk around that parking lot and the basketball courts ourselves and see for ourselves the lay of the land. Okay? And the reason why I bring that up is because much ado was also made about the terrible potholes. The pothole defense, okay? or the sloped land defense. Okay? We were out there We walked around on it. There's a gentle slope, a very gradual slope, perhaps the minimum to allow rainwater to seep towards a common area. It's a parking lot. Parking lots are inherently flat. But we heard the testimony that in that moment, when Ethan is outnumbered, and by now he's away from his car. Imagine being in a fist fight and separating yourself from your mode of transportation. He's now over by the light pole, and we heard the reports of him getting knocked out. Mackay said he was able to see it. But more importantly, I would suggest for your consideration, he was able to hear it. He heard the knockout blow. And the defense did some follow-up questions with him on that issue. Well, probably what you mean is you saw him get punched, and then when he hit the ground, you probably heard that sound. No. That's not what it was. He heard the punch. He said that. All three of the young men, the boys that were with Ethan, saw it from start to finish. Ethan went down one time. He was knocked out. There was no fight where he's in it and he's holding his own, and then he gets knocked down, then he gets up or he's led up. That never happened. He went down one time. And another thing I wanted to clarify is the use. I've said boys and young men and that sort of thing. And there was much chatter about these guys here being called boys. In voir dire, early on, the defense referred to them as boys. There was some confusion about their age as people were testifying. These are young men. They are adult men. The kids in this story, the boys in this story, were in Ethan's car. Just for clarification, to call a grown man a boy is either insulting or disingenuous or both. These are young men. We saw that Ethan was dead at the scene there. We saw that he was knocked out, never to move or make a sound again, other than maybe some minor noise associated with coughing up blood. He never moved on his own again. He was slightly moved after the fact by his friends who were trying to load him into his own car. Loading him into the back seat of his own car. And we see in some of the photographs the blood trail. The bloody trail on the ground from where Lamarion first got to him and tried his best to move him to a more convenient spot on the car to get him in. And he and Mackay were unable to do so. They provided a couple different explanations for why they were unsuccessful. One was that they were trying to move a dead body. We saw Mackay, we saw Lamarion. I would suggest that they're nice, now young men. And they both appear somewhat muscular, fit. This was a year ago. They were unable to come together and move their friend's dead body. That wasn't simply because of the weight. It was because their efforts were being inhibited by three people. Donovan and the Stafford brothers. And we saw much testimony, we saw in the video how that was going on. I ask you to take another look at it. We know Donovan was reaching in the driver's door of Ethan's car, but Makai's in the driver's seat because he was summoned to bring Ethan's vehicle to try to load up his body. And Ephraim is in the passenger seat trying to make a 911 call. The reason why Makai was summoned, hey, bring Ethan's car down here, is because they knew it was bad. It was bad news right from the rip. Nothing good was going to happen next. They knew it was an emergency. They knew that this was a life and death situation. You don't call 911 just in case. Those are last resort type of behaviors. The other thing that's a last resort behavior is running home, possibly a mile, and hiding behind trees as you go because you are scared to death. I would submit for your consideration that not only is it significant that Ethan, was forced away from his vehicle, not only his mode of transportation, but maybe the thing in the world that's the most valuable to him. Some people are attached to their cars. Okay, some people are also attached to things like their wallet or their identification card or their cell phone. Okay? And when Ephraim and Makai and Lamarion ran away from the scene, when they left the scene, they left their phones back at the scene. I submit for your consideration, that's a significant point to focus on. The very dire circumstances that they believed they were in. Okay. The judge has instructed you about the different charges. And you'll have that big stack of papers that the judge was reading from. And when you sit in those chairs, it might start to all sound the same to you. And it's maybe tough to fully absorb it and appreciate what the things mean. So when you get back there, you'll have to take a look. And I'm sure you will do so. But these are the different charges that Deshaun is charged with. Involuntary manslaughter, aggravated assault, another count of involuntary manslaughter, and a misdemeanor assault. Okay? And in the state of Ohio, the judge is going to give you these laws, but if you commit assault or aggravated assault and it causes the death of a person, that is called involuntary manslaughter. Okay, so there's one count related to the aggravated assault, and there's another related to the misdemeanor assault count. Tyler, he has involuntary manslaughter simply relating to that misdemeanor assault that we talked about, and also the misdemeanor assault. And I put up there that Deshaun also has those charges. So they each have two counts that are the same, but then Deshaun has his own two counts. Because the evidence showed that he threw that knockout blow that caused Ethan to fall, never to recover from, never to stand up from. Before I move on, again, you'll have all these things, but I was talking about the boys leaving their phones. You have these images here. There's Lamarion's identification card and his shattered cell phone. They testified that their phones weren't shattered when they had them. It was only afterwards. And we see that in the video. We see when Tyler moves the car, he hops out and he throws one of them down and it's shattered. You'll have that evidence photo to look at. Additionally, a couple things to call your attention to. I've touched on the fact that Ethan was separated from his vehicle at some point he was compelled away from, again, his mode of transportation, his possession, and his buddies. That's a bad combo when you're in a fight and you're outnumbered. Okay? To add to it, he didn't have on shoes when the cops got there. Okay? And we have photographs of his sandals strewn about. Okay? One's up closer to the car, one's a little bit further down near his body. Basically, they came off in the course of this. It's not from stepping on a pothole. It's not because it was such a steep hill. It's because he was getting attacked and he was outnumbered. Okay. And relative to the pothole defense, we have photographs. There'll be an evidence here for you to look at. You were out there. Maybe that lot's been repaid since then in the last year and a couple months. I don't know. It's not in evidence. Nobody testified that it's been repaid. Maybe. Okay? But we do have photographs to show the condition of it. And I'd suggest to you that it's in relatively the same condition. There are filled potholes. There are not gaping potholes. This is the night of the incident. This is the night of the attack. There's no gaping potholes in the ground there. We do have Ethan's shoes. That's a pretty flat chunk of land right there. Okay. Additionally, I talked about leaving behind your possessions. Okay. And placard number 4, we had testimony that this is Ethan's wallet right here, next to the splatterball magazine that would hold the Orby gel balls. This is his wallet at placard number 4. And if we look at the photo of the overall scene, we see that placard number 4, so that's the wallet and the Orbeez magazine, are over here. So going from his car, if he wanted to put those items there, he would have had to walk past the spot where his body lays, set them down, and then walk back over here where he would ultimately be found dead. In breaking down the charges for these 2 young men, I'm going to start with this, essentially the least serious. That's assault. Okay. Knowingly causing or attempting to cause physical harm to another. That's the definition, approximately, of assault in the state of Ohio. Deshaun and Tyler are both charged with that. Knowingly causing or attempting to cause physical harm to another, in this case, obviously, Ethan Lyman. And they're both guilty of it. This wasn't an accident. They did cause or attempt to cause him injury by punching his face, hitting his face. The physical harm. We saw the photographs. We saw the brutal photographs from the scene, from the night of the incident. We saw the other brutal photographs in the autopsy PowerPoint. We saw the injuries to his lips, both lips, and a bloody nose. Look at his lip. I asked the ME on purpose, hey, maybe that's just dry blood on his bottom lip there. Maybe it's not as bad as it seems. He said, oh, no. Those are injuries. That is not dry blood. His mouth has been cleaned up. Those are cuts on the inside of his lip from being blasted back into his teeth so hard that it cut the inside of his mouth. His upper lip was a purple, puffy mess. We also saw the blood still in his nose. The doctor couldn't tell us exactly how far up that bloody nose began. He said, yeah, it could be from one punch, please use your common sense and think about whether those injuries seem like one punch to you. They do not. Likewise, I asked about the injuries to Ethan's eyebrow and forehead. And I hope it doesn't come across as though I'm yelling at you. That is not my desire. I'm hoping that you're gathering that I am passionate about this issue, and a lot rides on it, and so I want to make sure that I'm hitting all the points I want to. So please, if I'm getting animated, I apologize. But everyone knew that Ethan was knocked out on the spot. Ephraim knew it, Makai knew it, Lamarion knew it, these guys knew it, Donovan knew it. He was down for the count. There were some questions from the defense about a woozy boxer getting up after 20 seconds or something. It didn't happen here. He was down and it was over. He was dead. Everyone knew it. He never made another audible noise other than a sound related to coughing up blood and no movement. We have Deshaun's statement that he continued to hit him. I don't think he said whether it was a punch or something else. He continued to hit him. Okay? And Deshaun also explained that he got some injuries in this fight as well. Okay? And Deshaun told us through the interview that it was a fight. Okay? And something to the effect of either that he was fighting them or that we were fighting them. Somehow it was like maybe fair numbers or something. Okay? And there were maybe 4 guys total on Ethan's team. Okay? And maybe initially one would think, okay, there's 3 of us and there's 4 of them. I guess that's close. But it became very evident very quickly the other boys were not jumping in. They were scared. They bit off more than they could chew when they engaged these strangers at the basketball court. They were not expecting probably any response. And when they got a response, they were not prepared for it. We got reports that both brothers assaulted Ethan. Everybody did. Donovan did as well. 3-on-1. Everybody was hitting him. Okay? Now moving on to the next serious charge. Aggravated assault. Okay? So this is a lot like the assault one we just covered, except now we get into serious physical harm. Okay? And only Deshaun has this aggravated assault count. And that's because he threw a knockout blow. Okay? He was offended that maybe he viewed it as being the butt of a joke or something, the butt of the prank. Okay? And he was upset about that. And it appears on the video that they all run, that they sincerely believe something not good is going on. However, we know that he finds out that it's fake. Either he gathers that on his own after some time goes by and there has been no sound of a real gun. There has been no bullets hitting anything. Or at the absolute latest, when Tyler yells out, "Hey, it's fake. This kid's messing with us. It's fake." Okay. And so there may have initially been some provocation by Ethan's group, by Ephraim and Makai running up there and doing their little prank. Okay, and Ethan's part of that. He drove him there. It's his splatterball gun. He's a part of that provocation. And then when Deshaun approaches Ethan, he apparently continues to shoot Deshaun. Probably upsetting. That'd be annoying. However, what came next was just so dramatically over the top. It's just not even a close call that it's over the top and not appropriate. Everyone was able to see that Ethan was unconscious and that he had gotten knocked out and blindsided. And Deshaun continued the assault. He continued to hit him. Okay? And so serious physical harm has a few different definitions. The judge read them to you, and you'll have them. But one of them has to do with physical harm with substantial risk of death. And during voir dire, the defense asked the jury, prospective jurors, about the notion of whether a punch is dangerous, if it's deadly or not, something to that effect. And one of the jurors who was not with us, I believe, explained about seeing a person get knocked out with one punch, getting hit on the side of the head, side of the forehead, and that could actually be very dangerous or deadly. Okay, so people know that. It's understood, okay, that there is a risk of death there. Okay? And the attorney even tried to maybe negotiate with the prospective juror about it. Maybe he didn't understand correctly. He stuck to his guns. He's like, no. I believe he said he was in a fight in the 70s or something and saw it happen. But additionally, another form of serious physical harm is harm that involves some permanent incapacity. Okay? And here we have total incapacity where Ethan is knocked out. He is unconscious. Okay? And then it's like, well, okay, is that a temporary thing or is it a permanent thing? Okay? And for Ethan, it turned into a permanent thing. He was permanently, totally incapacitated. But my point there for you to consider is that even if these guys don't know initially that he's dead, that he's just knocked out, that's good enough for that definition right there. That would be a temporary total incapacity, being knocked out or being in a coma. Okay. And then also temporary serious disfigurement. We saw the injuries, the bloody injuries to Ethan's face and to his side. The mark on his side. That's disfigurement. Involuntary manslaughter for both Deshaun and Tyler. Okay? No person shall cause the death of another as a result of the offender committing or attempting to commit any misdemeanor. In this case, misdemeanor 1 assault. And the judge will supply the elements for you to consider. But their behavior caused the death of Ethan Lyman. Okay, they were committing assaults on Ethan. They were violently attacking him. It was not a fight. Fight's not the right word. They were attacking him. They were assaulting him. Okay? And the judge read an instruction related to complicity. Okay? And the testimony has shown that Deshaun threw that knockout blow. He might have done it like this. He might be right-handed. And it blindsided Ethan. And that was the knockout blow. That was the assault that then caused his death. However, Tyler was involved in that fight. Whether it was 2-on-1, 3-on-1, doesn't matter. They were both involved in it. They were aiding and abetting each other in this physical altercation. They were both in it together to fight Ethan. Okay? Or, we heard testimony, and it was in Deshaun's statement that his brother called him. Deshaun. That's calling out for help in the fight. Hey, let's get him. Now, those were not the words used, but that was the meaning of it. Okay, as I indicated, all of the testimony from Mackay, Akron, Lamarion, all of it was consistent that there was the knockout blow, but that everyone was hitting Ethan. Everyone was. Okay. And we saw the injuries. Those could not be the result of a lucky punch or unlucky punch or two unlucky punches. It's more than that. Involuntary manslaughter. No person shall cause the death of another as a result of committing a felony, in this case, aggravated assault. We already talked about aggravated assault as causing serious physical harm. Okay, if the person dies, boom, you have this charge now too. Cause death during the aggravated assault. The death was the natural and continuous consequence. It was the next thing in the sequence of events without which the death would not have occurred. We know that from Deshaun's own statements, that when he hit Ethan, Ethan went right to sleep. And we listened to that recorded interview. The audio was not perfect. However, you'll have it with you back in the jury room. Listen to it 100 times if you need to. It's in there. He said he went right to sleep. We also know that from Tyler's statement that that's what happened. And we know that the death was caused that way from statements from the medical examiner. He went into great detail about how once a person is unable to control their movements, once they are incapable of doing so, they are extremely vulnerable when falling. They cannot protect themselves or do movements to guard themselves. They're in an extremely fragile position at that point. Ethan was in that point when he fell, and when he continued to get ground and pound on the ground afterwards. We probably learned what ground and pound means. Lamarion used that phrase, and he explained what it meant. That after Ethan was on the ground, no movement, no sound, that the person attacking him continued to hit him. That is consistent with the statement that Deshaun made. He said he did that. It is not suggested here that anyone set out to kill somebody that day. As I indicated, it's a very tragic situation. I told you these guys were minding their own business. Okay, but that only gets you so far. You cannot exploit some situation that you suddenly find yourself in. You can't capitalize on that or just go crazy and use that as some vehicle for you to commit a crime. Unfortunately, the law does not allow that. And the reason why that's important, and I would suggest to you the reason why I'm pointing that out is because the judge has instructed you and will instruct you not to think about things like sentencing or sympathy. That's not your job. Your job is simply to determine the facts of what happened that day. And if you start getting into things related to sympathy, whether it's, that maybe they initially were minding their own business or something, you're not doing your job. You took a very solemn oath to be a juror and apply the law to the facts. That's your only job. You are not allowed, you are not permitted to sort of disregard or turn a blind eye towards the law as the judge gives it to you and replace it with your own gut feeling or some notion of vigilante justice or street justice, something like that. You're not allowed to do that. You can only use the law that the judge gives you. This is a very bad situation. Terrible. That doesn't do it justice. Okay? But you don't get to say, well, yeah, they did it, but it was a bad situation, so we better not hold them accountable. You are not permitted to factor that in there. Okay. Punching and hitting a person is not accidental, whether that person's unconscious or not. I would suggest to you that punching a person who's unconscious is perhaps more egregious. Okay. It caused serious physical harm. It caused Ethan's death. And we went through some very lengthy jury instructions there about self-defense. Self-defense is I did it, but I did have a legal justification, and so it was all justified. In the state of Ohio, in order for the state to overcome a claim of self-defense, the state must prove at least one of the following. Could be more, but we just have to prove one of them. That's the threshold. Okay? And so the state has to prove, it has proven that one of these four, that the defendant was at fault in creating the situation, giving rise to the affray. The evidence showed that Deshaun approached Ethan and engaged him. And then shortly thereafter, Tyler and Donovan did the same. The evidence also showed that Deshaun threw the first punch. That is the uncontroverted evidence. There was no other testimony to contradict that. The first punch was thrown by Deshaun. Done. Lamarion said it. He was certain of it. I would submit to you that you could very easily find that the defendants were at fault in this situation. Okay. Next, the defendant did not have reasonable grounds to believe that he was in immediate or imminent danger of death or great bodily harm. Nobody at the basketball court was in danger of death or great bodily harm. Okay. If they had any concerns about that initially, those were gone by the time Deshaun came over to the car. It was clear that it was a prank, that it was a joke. Ethan posed no physical threat to anybody there that day. He had his splatterball gun. He was not interested in a fist fight. He was not dressed appropriately for a fist fight. Okay, and then the defendant did not have an honest belief, even if mistaken, that he was in imminent or immediate danger of death or great bodily harm. Same kind of an idea here. Okay, and I'm going to touch on that in a couple slides here. But also the last one, and I would suggest is for your consideration is probably the most significant one, is the unreasonable force. Please really give that one some consideration when thinking about the evidence that we've seen and heard here this week. Okay, and there is another one about duty to retreat that does not apply to this situation. Okay, the defendant at fault in creating the situation. Deshaun immediately, I called it up the ante. He immediately turned this thing from a stupid prank into a fist fight. Okay? And Tyler immediately jumped in to help his brother. Okay? A couple things. It did not need to be a fist fight. That was not necessary. Okay? It definitely didn't need to be a 2-on-1 fist fight. And it really didn't need to be a 3-on-1 fight. And I mentioned calling it a fight is insulting. That's not the right word for it. A fight insinuates that there was some sort of contest. Okay? The next prong of this test here, it was not reasonable grounds to believe immediate danger of death or great bodily harm. Okay? Neither of the Stafford brothers were in danger of death or great bodily harm. Ethan was outnumbered, with no shoes on. He was separated from his buddies. He was a sitting duck. It was a 2-on-1 fight and a 3-on-1 fight. Okay? Some people might call it an assault with a toy gun. That's what he called it. He called it that. It was basically an assault with a toy gun. And that was one of the spots in the interview that it was sort of quiet. You sort of had to focus to hear him say it, but he says it. And I asked Detective Hornacek about that to follow up on it, just in case you all didn't catch it. Listen to that interview again if you need to. I believe it's at the 1 hour, 34-minute mark, as I said up there. It's on there. He said basically it was assault with a toy gun. He didn't say it was an assault with fists. He didn't say, yeah, it was a fist fight. It was mutual combat. You know, I told him I was going to beat him up. He told me he was going to beat me up, and we tried. Nope. Assault with a toy gun. No one at any point has given any indication that Ethan's buddies jumped in or attempted to jump in. It's a sad fact of this case. When we envision ourselves doing things and how we would react in a certain situation, you might envision that you would be a hero and you would charge right in and get your buddies back and you would do what you could to help them out. But unfortunately, for everyone, for mankind, a lot of people freeze up. They don't know what to do. And another reaction that some folks have is flight. Okay, we ultimately saw that as well. So initially we see the three boys, Mackay, Ephraim, and Lamarion, essentially freeze. They're like, uh-oh, this ain't good. Lamarion runs over. By all accounts, he gets the closest. He goes to where Ethan is on the ground. And he told us that he would end up touching him. But before we get to that part, he said he touched the back of one of the brothers. Okay? And he didn't know exactly which one, but it was the one doing the ground and pound. It was Deshaun. He touched him, and he said Deshaun flinched at him. And so Lamarion felt he had no choice but to back off. Ephraim stuck by the car. He didn't know what to do. He was armed with a splatterball gun. Okay? And a number of times throughout the trial, we heard questions referring to it as a weapon. It's not a weapon like you might think. If you think it's a weapon like a gun, you are sadly mistaken. That is a toy. Now, it is an object, so I suppose almost any tangible object could theoretically be a weapon, and we did hear testimony about it being used as a weapon by smashing it on Akron. There was no indication it was used as a weapon by shooting by either of the Stafford brothers or by Donovan. The only way it was used as a weapon was by getting smashed on Akron, and we see the broken pieces of it at the scene there. And I mentioned that I would suggest that Donovan and the Stafford brothers, not only did they overreact, but and they went way too far, but they were capitalizing on the situation and retaliating. It extended something beyond whatever vague or sort of initial sense of justification or self-defense. It went beyond that into retaliation. And that is the word that Lamarion used. There was some questioning about it being self-defense, and Lamarion chuckled and referred to it as retaliation. This wasn't, oh, I'm scared, oh my heavens, This was ground and pound. Speaking of retaliation, before we move on, we already touched on the wallet being separated from Ethan. We didn't hear any testimony about how it got separated from him, but it is separated from him. And his pockets were curiously turned inside out.
We get our first objection. You generally don't get objections in closing arguments, but it does come around a very pivotal issue that Ethan's pockets were found turned inside out. Now, this is not a robbery claim. There was no testimony on if Ethan had money, or we know he was there to smoke weed, sell weed. We don't know if anybody ended up with Ethan's weed. We know his cell phone was missing, never to be found. So this is going to be a point of contention by the defense that this was not a robbery, and that shouldn't be brought up as maybe a motive or potentially adding to character issues, potential character issues of the Stafford brothers. Let's see what's decided.
Okay, proceed, Judge.
You may.
Great, thank you. In looking at the evidence in what I call the debris field there in the parking lot, the different placards and markers and things, we also see where Ethan's vehicle ends up after all this is over. And it's not dramatically far from where it started, pretty close in proximity. However, in between there, it was driven by Mackay down to the light pole, and then it was there briefly, and then when Ephraim and Mackay and Lamarion ran away, Tyler hopped in and drove it back around. I believe Detective Hornacek called it near the mouth of the parking lot, or the entrance to the I Promise School. And much ado was made about the sunglass holder, the door for the sunglass compartment being ripped out of the car and being thrown in the parking lot. There's no self-defense that relates to that, folks. We talked about how it became very apparent very quickly to everyone on the court that the prank was just that. It was a toy gun. At the absolute latest, Tyler yelled and made it known to everyone. And then we talked about unreasonable force. Okay, you can use force necessary to protect yourself. Okay? That's a-okay. Okay? And one could maybe buy into the notion that a punch would be necessary to stop someone who is continuing to shoot you in the upper torso or even the face with a toy gun. Rely on your collective life experience about what force would be necessary to stop someone from shooting you with a toy gun. In this case, the reaction, the retaliation was greatly disproportionate to whatever apparent danger that Ethan immediately posed or that he initially posed. Okay? And the court will give you an instruction about the force, the amount of force. And you can contemplate, you'll be able to think about whether all this behavior, everything we saw, the whole sequence of events, if maybe it shows revenge or a criminal purpose. Okay. Retaliation. Okay. And we heard from Lamar, it's retaliation. We heard about the ground and pound on an unconscious person. Okay. What injuries did the Stafford brothers have? We don't have any report of any injuries to Tyler. Nothing. Not a thing. Deshaun does say he was injured. Okay, and he told the police his version of events. Okay? And he explained his injuries. And if you watch the video, he sort of, motions to his arm and suggests that the scab on his arm is related to an injury. Okay. Ethan, maybe Ethan did some, no. Deshaun explains, no, that was from when I slammed him. Hurt my arm, and I also hit my head. So his injuries from the fight were from when he slammed the kid. Okay. But he had some more injuries. He had injuries to his other hand, to his right hand. And he explained that those were from hitting Ethan. Those were his injuries. The ones he got when he slammed Ethan on the pavement, and the ones he got from punching Ethan. Think about if those are in any world proportionate to the injuries that we saw. He mentioned his knuckle might have been broken. That seemed to be at the question posed by the detective. He said he thought it was, but he didn't get any medical attention. Now, mind you, that's 9 days later. After Deshaun was picked up by the Fugitive Task Force. And we heard about the splat ball gun that was collected from 515 North Howard, and that was Deshaun's, that was where he stayed. That's where the gun was, that he collected as evidence. Like a junior detective or something. He collected evidence by his account. He collected it. But then he didn't do anything with it. It was only collected 9 days later at the insistence of APD. Okay, there's an instruction in there about the defense of others. It's very similar to self-defense. Same notions apply. The same arguments apply. I don't want to go crazy here and go through everything again in the same amount of detail. But the same kind of a thing, you have to have reasonable grounds to believe that the person was in immediate danger, okay? Or it has to be an honest belief. It can't be phony baloney. That's why that rule's in there, is because sometimes people will capitalize on the self-defense law and say, oh, it was self-defense. And this rule, it cuts out anyone who is fibbing about that. Anyone who just simply capitalized on an opportunity to beat up a dude when he's knocked out. Or beat up a dude who is outnumbered. That's to cut out the phony claims of self-defense or defense of another. Like, oh sweet, my buddy's in a fight over, I can just run in and I can join in too, and I can just say, oh, it was defense of another. That cuts that out. Okay, and there's also the unreasonable force prong there as well. We talked about why that fails. 2-on-1 fight, not reasonable. 3-on-1 fight, definitely not reasonable. Okay, in terms of the defendant being at fault, the initial aggressor, Ethan did not escalate it by using deadly force. He didn't do it. Okay? The defendant provoked Ethan into using whatever amount of force he was able to put up before he was knocked out and done for. Whatever amount of force, if he was able to get any punches in, whatever, that was provoked by Deshaun throwing that first punch. Okay, you do have a duty to follow the law, as I said. You must follow the court's instructions. Okay, I want you to please use your common sense. We saw the sequence of events. We saw it on video. Is the video perfect? Absolutely not. Is it okay? Yeah. Yes, it is. And we're lucky to have it. There are 2 different camera angles from the I Promise School that show the sequence of events. And that sequence of events magically matches up exactly with what Ephraim and Makai and Lamarion had to say about it. It also matches up perfectly with the debris field, the strewn about sandals, cell phones, wallets, IDs that we find, the broken Orbeez gun on the parking lot. It all matches up perfectly. There's a reason, because it does. Those things are in evidence. The crime scene, the photographs that we have. Okay, what is not in evidence? Statements by the attorneys. Okay, so if somehow one of the questions by the attorneys was that the Orbeez gun holds 20,000 pellets, that's not in evidence. You did not hear that from any witness. It's not in evidence. If somehow you gathered that there was a TikTok challenge, nope, not in evidence. Not a single witness testified that this was some challenge. It was a prank. Okay, the height and weight of Ethan was the subject of some debate. Anything other than what the ME said is not in evidence. Those are the only figures in evidence. Some notion that the confession is not real, that is not in evidence. No witness took the stand and said that's a false confession. None of that. The only things in evidence are the eyewitness accounts that show that Deshaun did it with his brother's help, and Deshaun's statement himself that he did it. This notion that because a couple of the boys mixed up the name of the first guy to come to the car is irrelevant. It is inconsequential. That is not a consequential fact. Okay. We talked about reasonable doubt and how you rely on it in your most important personal affairs. We've got the eyewitness testimony. We've got the videos that match up, that corroborate what happened. We've got all the evidence. We've got the ME, medical examiner's testimony and his reports. You'll have those. They fall perfectly in line with what we were told happened. We were told by one of the defendants. Do not throw the baby out with the bathwater and buy into some weird notion of the slanted parking lot or the pothole or the false confession. It's absurd. No one testified to any of those things. When you retire to deliberate here shortly, I'm asking you to find the Stafford brothers guilty of their indicted offenses. Thank you.
All right, thank you, Mr. Kuhn. We have been going for almost an hour and 15 minutes, so before we proceed, I am going to give everyone just 10 or 15 minutes for a comfort break. We'll take a short break now. I did want to, before we do that, say to the people in the gallery that there has been a lot of in and out. Once we get started, if you do need to leave, you will not be permitted to come back in until there is another break. There is an overflow room that you can go into if you do need to leave. It is across down this hall into the annex and down one floor onto two in the visiting judge courtroom right outside those elevators. So if you do need to leave in the middle of a closing argument, then proceed to the visiting judge courtroom until we take another break. At this time, we will take that short break.
Dan DeRose with 19 News. As we get a break after just one side of the closing arguments, you heard from the state lay out their case. So we'll cover some of this. We're going to stick with our continuing gavel-to-gavel coverage to make sure you don't miss anything here. You'll have to answer the question yourself. How did the prosecution do? Was the prosecution a little lengthy? I would say so. For a closing argument, he wanted to be thorough. As we look at Deshaun Stafford there and his brother, Tyler Stafford, they do face separate charges here. Deshaun faces the much more serious charges, as it appears he is the one who threw that knockout punch, and maybe we'll play that piece of the testimony. It is probably the best piece of evidence that the prosecution had. You had Deshaun himself talking about showing up, going to confront and wanting to fight the other individuals, the other young men that were with Ethan. And, that's when he sees his brother starting to square off with Ethan. He then admits to going over and delivering the blow that would knock Ethan out. He said, I hit him and he fell. He said, I believe he went right to sleep is what he said. And we're going to play that confession now. It's only 3 minutes. I do want to warn you, there is some language in this confession tape. It is very tough to hear, so we will describe some of it after he's finished. The audio is tough to hear and there is some language used in this as Deshaun is being questioned by the detectives. It's a tape that was referenced in the closing arguments. We heard the prosecution say that they should go back and watch this, that he spells out what it was about the fight and the toy gun. He said he was assaulted with a toy gun. That's why he took Ethan's gun from the scene. When they asked him about that in the interrogation, he said that so he could have evidence that he was assaulted with a toy. Very much, again, showing that was it self-defense if you're defending yourself against a toy gun? That's a question for you and the jury to look at. Take a listen now to just some of that interrogation video.
You and the guy.
This is Ethan. Ethan had to go. Ethan shot me in the face.
Okay, so and then you go up and you punch Ethan?
Yeah, after he shot me in my face.
Okay, and then what happened? You guys grabbed each other? Was there a tussle?
He grabbed me, he literally grabbed me, and then I slammed him.
So you slammed him onto the ground?
Yeah.
And then what happened when he fell?
He literally, we let him back up, because my brother was helping me work for, I hit him a couple times, we let him back up, and then he started following my brother because we was about to leave.
Okay, so you guys are walking away from the situation?
Yes, we literally walked away, bro.
And he came back toward you?
He was following my brother. And
your brother, Tyler?
Yeah.
Okay.
And my brother had called my name. That's when I ran over to him and I hit him and he fell on the ground.
So you punched him and he fell down the ground.
So when you say he was following you, where were you at when you turned around when your brother called you?
I'm by the car confronting the other dudes. I was about to fight them too for shooting.
By the blue car?
The blue car.
Okay.
So I'm over there confronting them. I'm about to fight them too, whatever the fuck. But Ethan's still trying to fight my brother and shit. He's squaring up with my brother.
Okay.
And so when he called me over there, I literally hit him. He went right to sleep and shit.
Okay, so when he fell.
He was right there. I literally hit him and he went right to sleep.
Correct. He said, I hit him and he went right to sleep.
What happened after that?
I hit him 2 times.
When he was on the ground?
Yeah.
Okay. Then what happened?
None of that.
I'm going to pause there real quick and take you back just a couple seconds. At 1:32:39.
Walking away from the situation?
Yeah, she literally walked away, bro.
And he came back toward you?
He was following my brother. And
your brother, Tyler?
Yeah.
Okay.
And my brother had called my name. That's when I ran over to him and I hit him and he fell on the ground.
So you punched him and he fell down the ground?
So when you say he was following you, where were you at when you turned around when your brother called you?
I'm by the car confronting the other dudes. I was about to fight them too for shooting.
By the blue car?
The blue car.
Okay.
So I'm over there confronting them. I'm about to fight them too, whatever the fuck. But Ethan's still trying to fight my brother and shit. He's squaring up with my brother.
Okay.
And so when he called me over there, I literally hit him. He went right to sleep and shit.
Okay, so when he fell, what happened after that?
I hit him 2 times.
When he was on the ground?
Yeah.
Okay. Then what happened?
None of that. The motherfucking friends, they try to come jump in and steal shit, but the other nigga, the one with the dreads, he ran away, and then the light-skinned nigga followed him and shit.
Okay. And what?
Stop it at 1:33:43. Again, unfortunately harder to hear in the courtroom. But after Ethan, when he says he punched Ethan and Ethan went right to sleep onto the ground, what did he say after that? What did he do to Ethan?
I simply asked him what happened after that, and he said he hit him 2 more times, and I clarified while he was on the ground, and he stated he did.
And is it hit or punched or just
Hit, the word I used.
hit? He says 2 more times while he's on the ground.
Correct.
And it appeared as if, or correct me if I'm wrong, that he said when he was walking away and his brother called to him and then he walked back over, did he indicate that they were actually, Ethan and Tyler were actually fighting at that point?
Yeah, the words,
squaring up or something like
see,
that?
the words he used was squaring, they were squaring up, and Tyler called his name.
So not actively fighting, but squaring up?
Squaring up, yes.
That was the interrogation, some of the interrogation video that being referenced by the prosecution, where Deshaun literally himself says that he's the one who hit him and he went right to sleep, was his statement, and then that he hit him 2 more times on the ground. The defense saying, or I'm sorry, the prosecution saying, it is very clear that he was not hit just 2 more times, that the punches, the blood in his nose, his lip cut twice, the abrasion to the side of his head, that was not just 2 more punches, that was not consistent with what the eyewitnesses, Ethan's 3 friends, said happened, that it was not just the one-on-one fight, the squaring up and then getting knocked out, that in fact it was a 3-on-1 at one point. We're going to show you that video because it's referenced so much. This part was sped up. You see the 3 family members, the 3 young men playing basketball on the court there, sped up. They'll take it to regular speed now here as Ethan pulls up. The prosecutor brought up this idea of minding your own business only gets you so far. So this argument that the 3 young men were playing basketball, minding their own business, that only gets you so far, that it doesn't give you permission to then be excessive, according to the prosecutor, and go to the level that killed Ethan. Now you see in the video, lower part of the screen, that is Deshaun. Now upper screen, running to confront Ethan. And I want you to look at how quickly, according to Deshaun, how quickly this happened. Said he's now squaring up with his brother, that it's 2-on-1. Here comes Donovan Jones. He's going to pull up shortly, but now he'll run and join in the fight. Keep a look on the upper part of your screen. He's going to run down and join the fight. And this is where, according to the Ephraim that you see at the front of the car, this is where they are watching the 3-on-1 beat down and stomping and crushing blows, albeit we heard from the medical examiner that it was the knockout punch, wherever that is in that video. And that's the part of this video that's unclear. It was 1 minute and 15 seconds long. You're going to see 3 individuals walk back. You've got Deshaun and his brother, and the third person, keep an eye on that upper screen. You see the 4th person sort of bouncing by the fence. That's Donovan. Now, Donovan runs back towards the car. This is now that Mackay has gotten in the car to take it down to try and pick up the body of Ethan, to try and get him in the car. They said we knew we needed to get him to the hospital. But you're going to see Deshaun. He's on the right side of the car. He went back up. Now he's going to come back down. And as they are trying to lift him, you see the door open to the car. This is now Mackay and Lamarian trying to lift Ethan's body into the car. And you're going to see Donovan Jones come back into the picture, and he's trying to fight them. He does not want them to get the body in the car. And in fact, according to testimony, he is saying to them, one of you has to fight me. And he's punching them and kicking them. They're going to get back in the car. There's Donovan. He's going to walk up. They try to get back in the car. They see him coming, that he says one of them has to fight. He's trying to now rip open the door. We're told he was kicking. He was trying to punch inside the car. And so all of that is going on while Ethan's body is to the front left of the car on the top of the screen. You're going to see in just a second, you'll have the Stafford brothers in the bottom part of your screen. They're getting in their SUV, and they're going to come join what we have dubbed sort of the second round of this. You have Donovan trying to fight down there. The Stafford brothers in their SUV are going to pull out and then pull back into the picture on the top of the screen, and they are going to get into the mix as well, trying to get Ephraim out of the car, trying to get out of the front seat. You see the door rip open. At this point, we're told this is Mackay taking punches from Donovan. There goes one of the Stafford brothers to the driver door. Here comes another. Now, keep an eye on the right side of the car. You're going to see the back passenger door open, but then you're going to see one of the Stafford brothers try and kick in the front passenger side window. Keep an eye on that side of the car. It's right here. From what the testimony was, they're yelling, open the door, open the door. They get the back door open. Now watch, there's 1 kick, 2, 3 kicks, 4 kicks, and there's going to be one last 5th kick trying to bust in the passenger window. You see Donovan come around the backside of the car. This is when Mackay and Lamarian, they run. You saw them come out of the driver's side. They run. You're going to see Ephraim. He takes off running there. He is the 3rd teenager that was there. Keep an eye on the right side of your screen. There go Lamarian and Mackay through the McDonald's. You're going to see in just a split second, you'll see Ephraim come running through the drive-thru, and there is Donovan Jones as he was giving chase. You might ask, and we heard this from the defense, and we can see they're back in the courtroom. We heard the defense say in cross-examination of the lead detective, it sure looks like Donovan played a bigger role than this, than just charging him with 2 counts of assault, letting him plead no contest, and getting 180 days suspended sentence. The question from the defense is, now you have this confusion. You brought up those 3 friends that showed up with Ethan. You put them on the stand. 2 of them said it was Donovan Jones that confronted Ethan. 1 of them said it was Deshaun. But the detective said, but their description, they may not know the names of each individual, but the description was consistent, that the person who confronted Ethan was a smaller build with dreadlocks and had colored on the tips of the dreadlocks. The tips were tinted or some other color, and that's where the description comes from. The detective said it was consistent with all 3 and that he wasn't sure why there was a name confusion when they took the stand. But you are going to hear that a lot right now. Coming up in the defense. You are going to hear the defense say there is such a confusion. How in the world could you ever find these 2 young men guilty beyond a reasonable doubt when even the eyewitnesses aren't sure if it was Donovan or if it was Deshaun who came around and confronted. We get the all rise. We're going to flip this off because that's the jury that's coming into the room. And now we're back up on the clock, and we will resume now the closing arguments by the defense. Keep in mind there will be 2. Deshaun has his own defense, as does Tyler, and then there will be some final instructions by the judge. And by this afternoon, by early afternoon, 3:30, this case will be given to the jury.
Okay, please be seated. All right, Mr. Sin, you may proceed.
Good afternoon. The prosecutor had an opportunity to speak to you, and he spoke to you for about an hour and 15 minutes and told you a lot of things. And he said one thing only, that the defense agrees with. This never had to happen. What a waste. What an absolute waste. 1 minute and 15 seconds. That's how quick someone can lose their life over a prank. That's how quick 2 kids can be on trial for theirs. Half of that's out in the dark in the parking lot. My name is John Sin, and on behalf of Deshaun, I will apologize if I did anything or said anything that hits you guys the wrong way. I know I can be hard to take, but don't hold anything I did or said against Deshaun. He doesn't really have a say in this. He's living a nightmare. 15 months ago, Deshaun went out to play basketball. 9 days later, he got dragged out of bed by the U.S. Marshals Task Force and chained, naked to a table, no shirt, no shoes. For the last 15 months, he's still chained to that table. He's chained right here. He's chained to the table by a system that has to hold somebody accountable. Somebody has to pay. This case is difficult and it's evolved as we've gone. But no matter what the state tells you, no matter what the state says, none of this had to happen. And this nightmare that Deshaun and his brother have been living for 15 months, it's almost over. He's been waiting. They've been waiting for you to make sense of this. Make sense of the unsensible. What happened here? What happened when a beautiful, popular, promising kid dies? It affects the family, it affects the community, it affects the high school, it affects everybody. And there's a need to hold someone responsible. And that's why, after this happened, the police came out so heavy. That's why there are press conferences. That's why you heard about all this stuff about hate crimes and stomping to death and violent attacks. Things that we now know aren't true. We heard from the medical examiner, we've seen the evidence. What you thought you knew coming in, what we all thought we knew, none of that turned out to be true. Why? Why'd they do that in the first place? Because someone needs to explain the unexplainable. Someone needs to pay for what you can't pay for. It's a hard reality that sometimes you send your kid out on the first day of summer, the last day of school, and sometimes they get full of testosterone and THC, and like boys will do, they get up to no good, and they fight, and they punch, and they get punched, and 999 times you get your kid back, and every once in a while you don't. 1 in 100. 1 in 100, your kid hits his head in just the right way. And rather than say, man, that is just a tragedy, just what a waste. What a waste of a young life. What a prank gone wrong. Rather than say that, rather than acknowledge that sometimes you just can't make sense of things, they just don't add up. Life's just not fair. Someone's got to be blamed. So you drag him in and you chain him to a table. This investigation, this case, it evolved. We all did this together. We're all in this together. To me, these nice kids are clients, to the prosecutor of the cases, the judge, and the court reporter. We got court next week. To you guys, it's your civic duty. But to these kids, this is the most important day of their life. They've been in a nightmare, and you're the most important people they're ever going to know, because you got the keys to end this. Now, I know that we're throwing a lot of stuff at you, and I know that you're hearing all this stuff like self-defense and involuntary manslaughter. You're going to get the jury instructions, guys. You're going to have those. You're going to have all of this. You're going to have that in front of you when you go back there. But when we were promised this case, it was all wrapped up. The big bow on it. It was perfect. Cops got this horrible thing happened. The community is outraged. The good kid is dead. Let's find these animals, let's go out there and grab them, and we grab them in, and 9 days later, it's all wrapped up with a bow. And we came in here, we all thought we knew what happened because, hell, his friends told the police what happened. Deshaun made statements. It's all wrapped up in a bow. 9 days later, and 9 days later, as soon as Deshaun got dragged out of bed, the investigation's over. Here's your case, wrapped up. And it sat for 15 months. And we unwrapped it together. And what did we find? Nothing. Nothing. The box fell apart. The case fell apart. 2 out of the 3 witnesses changed their story in a substantial way. We don't know what happened here in the dark. Have you ever heard that saying? What you do in the dark will be brought to the light. We've all heard that. But what does that mean? Who brings it to the light? Whose job is that? If something bad happened, if a crime was committed, whose job is it? Whose job is it to shine light into that parking lot so you can know what happened in those 30 seconds that are so crucial? This is the government. This is the police. This is the role they've chosen. This is the job they've got. They need to shine a light on this. You need to have a light shined on what happened in that dark parking lot. They're going to ask you for a conviction. And they're going to pretend like everything is normal. Like everything happened according to script. Like the fact that 2 out of the 3 witnesses can't identify the right person. I'm not trying to tell you that Deshaun didn't walk up to that car first. I'm not trying to tell you that Donovan did this. I can tell you when this first started, I would have never thought we'd be having that because I took the boys at their word and I read the police reports. Now I'm not so sure.
I object, Your Honor. Attorney Sims' sureness about the case is not a question for the jury.
Sustained.
You can't be sure. Why? Because everything changed. When I stood up here in opening statement, we talked about self-defense. We're going to talk some more about it. But the fact is, if 2 out of 3 kids can't even identify the first kid that came up to the scene, can you rely on anything they said afterwards? To just pretend like everything's normal, that that's the way it's supposed to be. They had a year to get this together. They had 15 months to prosecute these boys, to suck them into this system and keep them there. Because we need to keep them there, because someone's got to pay, and the kids don't even have their people right. Why? They're high. They're probably high. If they're not high, they're kids, and they're scared. And everybody's scared about what happened, and everybody starts lying. And you start hearing about a pounding ground, pounding ground, pounding ground. Funny the medical examiner didn't see that. Yeah, medical testimony. How is that possible? This was a stomping. Ethan was stomped to death. His head was caved in. Brain matter spilled in the parking lot. Is the medical examiner lying? Shouldn't we be happy that Ethan isn't a victim of some horrific hate crime? Shouldn't we be happy that the medical examiner says that he's got 2 punches and maybe a kick to his body and that's it? He's not beaten from head to toe and stomped to death by violent, crazy people that don't wear shirts and don't wear shoes. These 2 kids weren't looking for trouble. Trouble came looking for them. Everybody started, where's Donovan? Where's Donovan during all this? How did Donovan get out of this? How did the other boys in the car get out of this? Who started this? When they left the house that night, Deshaun was doing what older brothers do. He steps up. He looks out for his brother. He looks out for his cousin. He did it that night. He did it in the interview room when he protected Donovan. They want you to believe that in the interview room, everything he said was a confession. And frankly, we started off talking that way. But who knows at this point? Who knows if he's covering for Donovan? They had 9 days of reading about this case in the paper, and he had 90 minutes sitting tied to a chair with his shirt off, with his head down, trying to think about how he can dodge this bullet, how he can avoid getting sucked into this system, how to keep his brother out of it, how to keep Donovan out of it. So I submit to you, we don't really know what happened here. All those witnesses on their side, they're unreliable. How do you know it? What they say doesn't make sense. There's no evidence supporting a ground and pound. There's no evidence no evidence supporting any of those things. They can't even get the basics right. These kids are doing what kids do. But we got to talk about Ethan Liming and what a good kid he is, and I get that, but what was he doing that night, and what's his state of mind? No one's trying to tell you that this is a real gun. We're not trying to say that. I think it's pretty clear. For a hot minute, everybody thought it was a real gun. But let's talk about Ethan and Akron and what their night looks like. It's the last day of school. Summertime. Ethan and Ephraim are making plans, and they're nice kids, and they're doing what kids your kids with nice families do. They're going to go out. They're going to have fun. It's warm out. They're going to smoke some weed. Ethan's going to sell some weed. He's going to show off a little bit, and he tells Ephraim, get your splatter gun. Why? What's the point of that? Why get your splatter gun? Because it's going to be a fun night. And then when Lamari and Mackay come out of the house, they get hit with the splatter gun, and they're not mad because these are their friends. But Ethan's already ready to have some fun. He's ready to have some fun. They brought the splatter guns. They're going to shoot the splatter guns. And they shoot them at their friends, and now everybody's on board. And Ethan is the star of the show. He's driving the car. He's got the weed. He's going to drive you to I Promise School, and he's going to hand you the gun and tell you to get out and do it. And they did it. And all Amari and Mackay wanted to do was just stay in their house. They don't know these guys like that. Ethan and Sidney Akron, they don't know him like that. They wanted to just go in the house, but they went along with it. And they went along with it. They went along with this idea, let's shoot at some people and let's make them believe it's a drive-by. And it ain't that funny. I mean, depending on what side of West Market Street you grow up on, it's not that funny. It wasn't funny to these kids. It was mean-spirited, and it was bullying, and it was mean. Say what you want about who's bigger and who's smaller. These guys are small. I don't know why Ethan's driver's license says he's 6'1". I don't know why the police department says he's 6'1". I don't know. But I know these guys are 5'5". I know they're the smallest kids there. I know that it's 4-on-3, and I know that these kids were playing basketball. That's all they were doing. Ethan pulls in. He's in that state of mind. They've all smoked a blunt and a half. And no matter what Ephraim says, oh, I don't get high off a blunt and a half. I have a perfect memory, and it's the wrong guy. Mackay was pretty straightforward. The last kid you heard from, he seemed pretty straightforward. He seemed like to me, he came in and he said, yeah, blunt gets 4 people high. Sure it does. That's the purpose of it. So you got 4 high kids with paintball guns out to bully some other kids. And they're going to pull up, and it's going to be a big prank. And it could have been hilarious. Well, it didn't have to be deadly. It could have been right out the window and go forward. That's what they thought they were getting into. But that wasn't Ethan's choice that night, because Ethan is on his first night of summer, and he's having fun, and he's showing up for some friends, and he tells them to get out, and they get out, and they shoot these kids, and these kids run for the gate. And you can see the kids in the car didn't stay, they blocked the gate, they ran up there. So as these kids are running across the court, their exit way is getting blocked. That's a little scary. That's a little scary. No one's trying to say they thought it was a gun the whole time. But what I am trying to say is, you got a right when someone shoots you with this damn thing to go, are you serious? Are you serious, dude? Come on. Am I being pranked? Is Ashton Kutcher going to jump out on these kids and tell them they're on Punk'd MTV? No. They don't know what the hell's happening, but it's reasonable that someone's going to go up to them and say, what the hell? What the hell? And that's where Ethan could have drove away. That was a choice he made to drive away. Could have done that. That was the plan, man. What's the purpose of getting out? I think the prosecutor will tell you the purpose of getting out is to let him in on the joke. Guys, be cool, it's a joke, it's a prank. You know, we're just playing. Is that what happened? No. Sean walks up with a basketball in hand. And what he gets is shot in the face. Shot in the face. Shot in the face. One time, every time you hear this thing make a bump, how many seconds did it take for Deshaun to walk up to Ethan? How many rubber bands did he take to the face? You don't think that gives you a right to grab the damn gun? Ethan's smiling. He's smiling. And they're going to tell you, he's smiling because it's so funny to everybody. He's smiling because he's a smiler and it's so nice and everything. He's smiling because it's mean. He's smiling because he's shooting this kid in the face. What's going through his mind? It's the first night of summer. He's full of THC and testosterone, and he's a boy. And boys do what boys do. And who's going to think that on this night he's going to hit his head in just a certain way and not come home? Sometimes these things just happen, and sometimes there just aren't answers. The prosecutor stood up here doing his job and telling you that everything is normal and everything's fine. And they're going to pretend like they've shown you a light, that they've lit up what happened in that parking lot so you know. You know what happened in the dark. You know it. You have to know it, right? You heard from 3 high kids who couldn't get their story straight. That shows you what happened in the dark. And they want you to pretend that you saw it, and pretend that you're as confident as they are as to who did what in the shadows for 30 seconds. And they're going to spend a lot of time talking about Donovan kicking a window and what happened after. And you know, Ethan's gone by then. That stuff's horrible, but it played no part in this. You've got to look at what killed Ethan. A punch. Presumably a punch. We saw 2. The medical examiner did not say Ethan was beat horribly. He said he had a hit in the eye, a hit in the mouth, and something on his side, and bloody knuckles. That's it. That's not consistent. These kids said ground and pound. I don't know if anybody knows what that means. Ground and pound. Over and over. He was violently stomped. Come on. Come on. Medical examiner in on it too? Come on. That guy had no motivation to tell you what it is. This is a horrible tragedy. And we wish we had answers, but we don't. You're going to get jury instructions. And I'm going to tell you about these things because I could talk all day about reasonable doubt. And reasonable doubt, are you firmly convinced? Reasonable doubt is you have to believe they proved their case. They proved that Deshaun is the one that caused Ethan's death. They proved it. They have to. That's what you got to believe. And further, not just that, they're going to prove that Deshaun didn't act in self-defense in the shadows. That's on them. I don't know what happened there, and I'm not bothered by that because it's not my job. I'm bothered by the fact that they don't know what happened out there. And they want you to make a decision to chain these kids to this system when you don't know what happened out there. It's their job to shine light on it, and they didn't. Reasonable doubt. Reasonable doubt is you must acquit unless the state of Ohio proved to you each element of defense beyond the reasonable doubt. And reasonable doubt's where you're firmly convinced of the truth of the charge. You're so convinced that you'd rely on that decision even if it was your own life, your own affairs, your own kids sitting in that chair. You know it. You're firmly convinced that Deshaun attacked Ethan, assaulted him, took his life, and he didn't do it in self-defense, and that's been proven to you. Come on. Saying it doesn't make it so. There are jury instructions. And I talked to you in my opening statement about how you do a case like this when you've got all this pressure from family and friends and Ethan's family and Deshaun's family and the cameras. How do you do it? Do you just go with your gut or decide? That's part of it. But it's a math problem too. You got a math problem. You got to work the equation. These are jury instructions. She read them to you, the judge, and maybe you're better than me and you understood every one of them and you know exactly what was said and who. I don't. I can tell you though, you're going to go back there and you're going to do the math. And you're going to hear some things about what they had to prove in order to successfully bring these kids into the system. What do they have to do to get their conviction? We don't have to do anything. We don't have any burden whatsoever here. We don't have to do a thing because if they're going to make these accusations on behalf of the government, then they need to bring some proof. They need to shine that flashlight. And again, I submit to you, this investigation was terrible. Nice guys, nice people. You don't check a cell phone? You don't turn on a cell phone and see what was said? This investigation was closed 9 days later. They got Deshaun, they locked him in a room, they got his statement, and we're done. And we don't want to hear anything to the contrary because everybody's happy now. The chief's happy, the family's happy. We got the bad guys. We got them. Ethan's a victim here of these rotten kids who are waiting for someone to stumble onto their turf. That's the implication. Stumble onto their turf and get killed. That ain't what you heard. That ain't what you heard. What you're going to hear is the stretch that the prosecution has gone to try and get some charges to stick. You're going to get these jury instructions and they're going to talk about who's got to prove stuff and reasonable doubt. And I'm not going to spend a ton of time on them, but I'm going to talk about cause. In order to establish involuntary manslaughter, they have to show that Deshaun caused Ethan's death. Cause. Cause is an essential element of the offense. Cause is an act that in a natural and continuing sequence directly produces a death in without which it would not have occurred. Do we actually know what happened here? I get that the prosecutor thinks that we're full of BS talking about a parking lot. He may or may not be right. But the fact is, Ethan's backing up. People are saying Donovan's punched him. None of the kids, none of those witnesses from them could say Deshaun did it. The only one saying that Deshaun did it is Deshaun. And we know he's covered for Donovan. But who knows? It's their job to show it to you. Did they trip and hit his head backing up during the fight? I don't know. Probably not, but there's potholes there. Say what you want. Did see the pictures. Did someone else knock him out? Who knows? Come on, how come none of the boys saw that? What's up with that? You see everything else, but you can't tell us who saw it, who hit him? What did they see? How high were they? Where were they sitting? Cause. You have to be firmly convinced. You have to know that Deshaun threw that punch. You got to know it. And at the beginning of this case, before we unwrap that empty box, I would have said, yeah, absolutely. It's a self-defense case. Of course Deshaun did it. Who knows what happened in the dark at this point? But I submit to you, if you don't know, that's reasonable doubt. Basically, as you dig through these things, you're going to hear that Deshaun's charged with involuntary manslaughter causing death, and you're going to hear that he's in charge with it two ways, one by ag assault, one by assault. I'm going to talk about that for a minute, but cause is the first thing. You got to get through that. If this were a regular case, the state's got to prove it. They put on the evidence. If you think that Deshaun threw the punch, then he caused it. That does not mean he's guilty. Not in the state of Ohio. Not in the state of Ohio. In the state of Ohio, under Ohio law, a person is allowed to use force in self-defense or in the defense of another. You're allowed to do that. You don't have to back up from a fight. They must prove that he wasn't defending himself. Now, when you read the jury instructions, you're going to hear about self-defense. And again, not only do they got to prove that Deshaun committed this crime, and Tyler committed a crime, they got to prove that they weren't defending themselves. And I submit to you, that's going to be a very high burden. But you're also going to hear some law, and I know the jury instructions explain it, but I kind of want to hit on something with you. There's a different kind of self-defense to use deadly force than there is for regular force. And what do I mean by that? Deadly force is defined as any force that carries a substantial risk. It will approximately result in the death of a person. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur. What I'm saying is, I don't know that a punch is deadly force. You don't look at the end result. If I did my little rubber band stunt here and this glass falls over and stabs one of you and breaks on you, that doesn't make the rubber band deadly force because you died. It's about whether or not there was a known risk, whether or not it's foreseeable, whether or not that if you punch somebody, you're going to kill them. And 999 times it doesn't work that way. They don't hit their head that way. But the reason it's important is because you don't get to respond. You don't get to respond with deadly force anytime. You can't bring a gun to a knife fight. It's not as important in this case because if Deshaun used deadly force by a punch, which I submit to you, it doesn't make, that's not what it is. But if Deshaun did it, then Ethan did it too. It's all about proportional, being reasonable. You respond you can respond proportionally. The judge is going to give you a jury instruction on that. A person is allowed to use force that is reasonably necessary under the circumstances to protect himself from danger. So here's what we're getting at. Did Deshaun use deadly force? If a punch is deadly force, then I submit to you he was facing deadly force. If a punch isn't deadly force, then he wasn't facing deadly force. The reality is he met a punch with a punch. He met getting shot in the face with a dozen rubber bands with the struggle. That's reasonable. That's not bringing a knife to a fist fight. That's not what the law is talking about. These boys fought, and no matter how you look at it, the state of Ohio has not proved that this wasn't self-defense. And that's their burden. You heard, Sean's a big brother. They're minding their own business. They even say they're minding their own business. They're minding their own business. And no matter, you can drag him out shirtless, you can chain him to the table. These are nice kids, and he's a big brother, and he looks after his little brother, and when Tyler says, Sean, when Deshaun's been hit his head to the point he throws up, struggling with Ethan, and now Ethan is getting ready to go after Tyler, think about whose state of mind is whose that night. These boys are playing basketball. Again, they brought a basketball. The other kids brought this. Look at their state of mind. Ethan got out of that car to do what? To fight. To fight. It's the first night of summer. That's what boys do. It's what boys have always done. And when he went after Tyler, Tyler got put to the ground. Sean got put on the ground, or he hit his head. Then he turns on Tyler, and now this kid says, Sean comes up, and if you believe one of the witnesses, not the other three, either Sean or Donovan punches Ethan, and that's it. That's the end of the story. That's the end of the case. And the question is that self-defense? Is it defense of another? You can defend yourself and you can defend your family. That's what we're saying here. That even if they prove to you that Sean threw a punch and that punch caused Ethan to hit the pavement and that pavement cracked his head in just that right way that we don't get him back, that's self-defense, because these boys were minding their own business when trouble came to them. You're going to hear a lot about what happened after Ethan went down, and the medical examiner said he's gone. And they want to talk about punches and kicks and ground and pound. And I'm not saying that none of that happened, but I'm saying the medical evidence is what the medical evidence is. If you hit somebody, there are marks, and the medical examiner can count them out for you. And we're not talking 10 minutes. We're talking, how much time? A minute and 15? How long did it take for the kids to walk out with a gun and walk back? And then how long were they in the dark? How long was 30 seconds? 30 seconds in the dark? That's how quick you lose your life over this nonsense. That's how quick you can be sucked into a system. Nonsense. One minute, 15 seconds, and we don't know what happened. All we can do is try and put the pieces together. But you know what? This isn't a puzzle that you guys have to solve. This is a puzzle they have to solve for you. You don't get to guess what happened in the dark. You have to know what happened. Someone had a job to show it to you. You would have liked to know what was on those cell phones. Don't tell me you wouldn't like to know. You would like to know what these kids said before and after. We could have done that. These two kids aren't in charge of an investigation that was closed 9 days later. How much did we not hear about? This has been a rush to judgment. You know, that first round, that minute and 30 seconds, the first round where Ethan lost his life, everything after that is really not relevant, and that's all they want to talk about because it makes you think. It's like a paintball gun found in a car a week later. You're supposed to read something into that. Pockets pulled out, and you're supposed to suggest, oh my God, they were robbing him. They're robbers too. Why are they so desperate? Because someone's got to pay. Kids like Ethan don't just crack their head and die. And when they do, like I said, I'm not for everybody. But you can work the math problem. That's all we are asking you to do. Work the problem. Read the jury instructions. Use your common sense. And all anybody can ask of you is to speak your heart. Do the right thing. Do the right thing. No one's looking for sympathy here. No one's looking for you to ignore the law. I'm the defense attorney, and I'm begging you, follow the law. Follow the law. Because if you do that, you can come back here and you can say, this was a tragedy, a preventable tragedy. It didn't have to happen. But we've already lost one young man. We don't need to lose another two. We don't need to lose another two.
Your Honor, I would object to that characterization.
Sustained. Ladies and gentlemen, you will be instructed that the issue of punishment is not to be considered. The court will decide punishment if there is a guilty finding on any of these counts. Mr. Sin.
I know you don't want to get me drone on, so I won't. This isn't a popularity contest. This isn't about those guys on TV or the pressure on these guys or the police. It doesn't mean you're not pro-police. It just means that you were supposed to get answers. You were supposed to be shown what was in the dark. And it's darker now than it was when we started. You got nothing but questions. And questions are doubt. And if you don't know what happened in the dark, then don't let them ask you for a conviction because they didn't give you what you need to do it with a straight face. You got to live with this. They got to live with this. And if you follow those instructions, you can live with this. Because the instructions will take you to the right answer. And the right answer is these boys are not guilty. These boys acted in self-defense. Thank you.
Thank you, Mr. Sin. Mr. Gallick.
Thank you, Your Honor. May it please the court, opposing counsel, ladies and gentlemen of the jury. As you know, I'm Donald Gallick. I represent Tyler Stafford. And I have a few things to say. I mean, the bad news is you have to listen to 4 closing arguments. The good news is I'm number 3. I know this trial has been difficult on everyone. It's been probably more difficult for some than others, but it's been tough on everyone in this room to one degree or another. I want to say that the kids are not all right. And Prosecutor Kuhn brought up that someone called the boy or boys. I did not. I didn't call anyone here a boy or boys. But I have called a lot of people probably kids. And you could say, well, wait a second. Weren't they 18 or 19 when this thing happened? And Ethan Lyman, he was 17, so that's a legal distinction, I guess. To me, they're all kids. The difference between a 17-year-old, an 18-year-old, a 19-year-old, 20-year-old in our culture, I don't know what the difference is. Our culture is in a lot of trouble, okay? There was a time in this country, not 2023, but let's say 1953, you could go into a high school and kids would get in trouble for not bringing their rifle to school. Wait, what? High schools would have marksmanship classes. High schools would have shooting training. Boy Scouts used to have rifle training. What? That sounds crazy. Well, it was a long time ago. It was a different culture. Could you imagine that in 2023? Having a 17-year-old bring an actual rifle or any kind of dangerous device to a high school? You certainly couldn't even bring this into a high school today. I mean, perhaps at some point we won't allow people to have butter knives until they're 25. I don't know. But our culture is in a lot of trouble. And it was brought up that, well, you heard testimony, TikTok didn't have anything to do with this or anything like that. The 3 kids, as I'm going to call them, who were with Ethan that night, they said, oh yeah, I know about TikTok and I know about social media. They all do. Every kid in the country, probably over the age of 7, knows about social media these days. Was that an influence on what happened here? That's for you to decide. Now, I want to go over some of the witnesses that you heard. Because Prosecutor Kuhn said everything lines up. We know what happened. We heard from the witnesses. Everything lines up. Maybe things didn't quite line up like he said. Now, I believe Ephraim, his father testified. He was not there when it actually went down, but shortly thereafter. He sees his son, 9 o'clock, or I think he said 9:30. He's leaving the house. Ethan's coming to pick him up. He's got one of these guns. And you heard me ask him, was that concerning to you? No, I wasn't concerned. Your son's leaving, getting in Ethan's car with one of these splatter guns, going, you don't know where. No, I don't know where. Does your son have a curfew? No, he doesn't have a curfew. He goes wherever, does whatever. Okay, that's fine. And then you heard his son come up and take the witness stand. And he said, I had a little bit of marijuana. Okay. Did that marijuana affect you? It doesn't really affect me. Oh, doesn't? No, it doesn't really affect me. Okay. Then he said, well, actually it kind of makes me tired. Okay. Then I asked, well, what about this video where you're running up and chasing Tyler and Deshaun with the weapons? Well, I didn't have that much marijuana. If I did, maybe it would have made me tired. I mean, that was his testimony. Now the prosecutor, in his opening statement, he pointed out, did you notice how scared Mikhail and Ephraim were when they were running away from Tyler and Deshaun? The testimony that we saw was the only one chasing them was Donovan Jones. The larger person, the guy who's almost 6 feet tall, the guy who was shirtless that night, not the person who was shirtless when he was pulled out by the U.S. Marshals, that was Deshaun. Deshaun didn't have a shirt on, I think, when he was chained to the interrogation room. But on the night of June 2nd, 2022, the testimony was it was Donovan Jones who was shirtless. It was Donovan Jones who was chasing people. The hunters became the hunted, as it were. Now, when Ephraim testified, he said Ethan was throwing punches to defend himself. He said it looked like a ball of people. There were people fighting all over the place. Wasn't really sure who was who. But his testimony was clear. And I think, to go to Mr. Sims' point, if a punch is deadly force, then there's a lot of people using deadly force in a sense, including Ethan. Now, Mr. Dancy testified, and he said he didn't seem that interested in being into this night out and this prank. But he brought up that he thought they were just going to do, his words, a quick drive-by. Maybe I'll take this, and maybe I'll lean out the car. Maybe is that what we're going to do? And we'll shoot at some people, and we'll laugh, and we'll drive away. But Ethan changed the plan. That wasn't Ethan's plan. Maybe it was Mr. Dancy's plan, but that's not how it went down. Okay? He said that he saw Ethan give his gun to Micaiah and told him, get out and run up on him. Run up on him. Chase him down. Why? To panic them, to scare them, right? Apparently in 2023, we don't have enough panic in the world. We're going to scare them. Okay. And that's what happened. And then Prosecutor Kuhn said, well, they didn't expect a response. You didn't expect a response? You don't expect a response at 10 o'clock at night? You're in the dark, you run out towards a basketball court, and you start shooting them with these things? You didn't think there'd be any kind of response? That doesn't make sense. That doesn't make sense. They do respond. They run out, and the testimony that you heard from the three people who were there, the three people who were in Ethan's car that night, some testified that it was Donovan who came up. Some testified it was Deshaun who came up. Coming up, swinging, went ready for a fight. That wasn't the testimony, was it? The testimony was Donovan or him said, hey, are you serious? Like, what's going on? What's going on in our community? And you heard one of Ethan's friends say, well, he kind of took that to mean, there's a lot of violence going on around here. We're having a really difficult time these days. This is not the kind of thing that we need to have. We don't really need to, that's implied, but that's how the witness interprets it. Who knows what was really meant? The important point is that when Donovan or Deshaun came up after being shot, just want to talk. Maybe Donovan or Deshaun was looking for an apology. I don't know. But what they got is shot in the face. And then it changed, well, yeah, I said shot in the face, but maybe it was shot in the torso, or maybe it was shot in the neck. Let me see if I can change this testimony around a little bit. Shot in the face, or the neck, or the torso, or whatever we can do to help the prosecution. We'll change it around a little bit. So then at that point, it becomes a fight. And who threw the first punch? Did we get testimony on that? I mean, what does your memory say? You heard testimony that it was a mutual fight. They said, oh, you don't call it a fight. That's not right. That's offensive. Well, that was the testimony of the people who sat in this chair. I wasn't there. He wasn't there. They weren't there. The people who testified from this chair who were there said, yeah, it was a mutual fight. Ethan was throwing punches to defend himself. Ethan said there were so many punches that just looked like a ball. He didn't know who was fighting whom. But the question is, if you get punched, is it reasonable to punch back? If you get shot in the face with one of these, the second time you've been shot with this in a matter of 20 seconds, however long it was, is it reasonable to respond? Is it reasonable to walk up and say, hey, what are you doing, man? Are you serious? And then, instead of an apology, you get the gun put in your face, or your neck, or your torso, depending on what part of the witness testimony you want to believe. And you get more rubber bands, the sensation of rubber bands in your face. Is it reasonable that turns into a fist fight? Use your common sense. Use your common sense. Now, any testimony that, Ethan wasn't looking for a fight that night, is that what the testimony suggests? You heard testimony from, I think, Mr. Shady as well, saying, man, hurry up, we did our prank, let's get in the car, let's get back in the car and get out of here. Time to go. No, Ethan didn't want to do that. He wanted to stay there and continue the prank or whatever we're going to call it. Now, you've heard us say from day one, this is a self-defense case. That my client certainly didn't start anything. The testimony that you heard, Deshaun didn't start anything. Maybe Donovan Jones started something, but he's not here. Tyler Stafford was trying to either defend himself or his brother that night. And unless the prosecutors prove otherwise, it's a not guilty verdict for all of the counts. But I want to talk about one thing in specific, and that is, specifically, Tyler is accused of involuntary manslaughter. And you have the jury instructions on all this. You'll be able to see it. The medical examiner's testimony was very clear. The cause of death was the injury to the back of Ethan's head. Okay? All the other things are horrible. You shouldn't kick someone. That's horrible. That wasn't the cause of death. Okay? It's probably not good to have a bloody nose. That's not the cause of death. The suggestion that it's ground and pound, that he was down on the ground and getting punched repeatedly, the medical examiner said, well, the medical examiner wasn't there, but he goes, here's what I know. He said he didn't have a broken nose, he didn't have a broken orbital bone, he didn't have any broken bones in his face. So if that would happen, if there was someone had him on the ground, unconscious and constantly pounding him, and not even break a bone, use your common sense on that, okay? The medical examiner said once Ethan went back and hit the pavement, that injury to the back of his head damaged his brainstem, and he was probably gone within minutes or even seconds. You heard the medical examiner say, I asked him, well, what if there had been an ambulance around the corner? Probably wouldn't have made a difference. Okay? It probably wouldn't have made a difference. So that's awful, it's horrible, but that's the evidence that you have. That's the facts that went down on June 2nd. And we certainly don't like it. We're all horrified by it, but these are the facts that you're given. And we can't interpret the facts differently. We can't make up facts. We have to take the testimony of the medical examiner. No one contradicted the medical examiner. No one came in and said, well, actually, he was wrong and he did the autopsy wrong. That's your medical testimony. The injury to the back of the head is the only thing relevant on a manslaughter case, because he said that's what caused the death. Now, there was some testimony maybe that Tyler might have been swinging at Ethan. Where did Tyler hit Ethan? Don't know. Did Tyler hit him in the arm? Did Tyler hit him in the leg? There was talk of one kick. I don't think you heard testimony that Tyler did that. You heard testimony that Ethan had wounds on the top of his foot. Was that due to him kicking someone? Don't know. You have to figure that out if you find that it's relevant. But you heard me ask witness after witness, do you have any evidence that Tyler Stafford caused anyone's death on June 2nd? Was there any testimony? Was there any physical evidence that Tyler Stafford did anything to cause anyone's death? And no answer. No. Don't have anything. Then I asked Detective Hornacek here, who I think was our last witness. And I asked Detective Hornacek, I said, hey, lawyers like to repeat themselves. I keep asking the same question of every witness. Do you have any evidence that Tyler Stafford had anything to do with causing anyone's death that night? And Detective Hornacek told us, well, there was a statement originally, going back, 15 months ago, whatever, that all three jumped him. And so there you go. Wait a second. So all three jumped him, and so all three of them committed the manslaughter. Was that the testimony? That doesn't make sense. That's not what we were told in opening statement. That's not what we've been told throughout this whole trial. But it's like, well, Plan A didn't work. We can't get a manslaughter conviction on Tyler that way. We'll try this one way. Well, that didn't work. Okay, well, all three jumped him, so I guess all three of them committed the manslaughter. Well, that's not what we were told in opening statement. And now, today, you're going to hear jury instructions. I think you heard it from the judge. That it's like, okay, well, you know why Tyler is guilty of involuntary manslaughter? Well, he was complicit. He helped. He was there. He was distracting Ethan during the fight, something like that. It was complicity. No, you know what it was? Maybe it was conspiracy. Maybe there's a conspiracy in the jury instructions. Well, wait a second. Where did that come from? Do you hear any witnesses about that? Do you hear any witnesses say there was a conspiracy? Do you hear any witnesses say there's complicity, that Tyler was complicit and was helping Deshaun cause his death? No. Well, why are we talking about that today? Well, we've got to find some way to get a conviction. We've got to come up with some theory. The evidence doesn't match. The witness's testimony doesn't match. The three witnesses don't know who did what. As Mr. Sin told you, two of them said it was Donovan Jones. Well, that's disidentification. I don't know. We kept asking them, is it the taller guy? Yeah, it's the taller guy. That's Donovan Jones. Right? Yeah, you're right. The taller guy is Donovan Jones. He ain't the taller guy, and he ain't the taller guy. Donovan Jones is, yeah, that's the guy who's chasing. That's the guy that came up and knocked Ethan on the ground. Another thing you have is, we were told in an opening statement that it was one punch, and he went down to the ground, and that was it. He went down to the ground, and no more. But now you've also heard, now wait a second, Deshaun's statement, he grabbed him like a wrestler and slammed him down on the ground. Actually hurt his head, slammed him down there so bad. And then Ethan got up. And then he got hit again by either Donovan or Deshaun. And he went down a second time, and that's what killed him. Which story is it? Which story is it? Did he go down once and that was it? Or did he go down once, get up, and then someone came by and punched him and knocked him down a second time? You've heard a lot of different versions on that. The truth is they don't know. Nobody knows. Nobody knows. But the only thing that matters is that injury to the back of his head. And no one has testified that Tyler had anything to do with it. And today we're told, okay, he didn't have anything to do with it except he was complicit or he committed a conspiracy. And it's the first time we've heard that this entire trial. And explain why that's a new thing coming up today. We haven't heard it at all.
I'm sorry to object during Attorney Gallup's closing, but I don't believe that is an accurate statement of the law, Judge.
Well, I did not instruct as to conspiracy. I did not.
Conspiracy is not in the jury instructions?
Correct.
Everything I said, aiding and abetting and complicity. Maybe they will explain why that's coming up today. Thank you, Your Honor.
Ladies and gentlemen, as I have discussed a few times and everyone has made clear, it is the state's burden of proof, and because it is the state's burden of proof, they do get the opportunity to rebut the closing arguments of the defense. They do have the opportunity for the last word. So I am assuming, Ms. Schucke, you are going to present the rebuttal argument.
Thank you, Judge. Ladies and gentlemen of the jury, kind of want to bring us back to focus on your jobs here, what you have heard, because I'm not sure, I think the word was the prosecutors are, that we pretend, we present you facts through the evidence, through the witnesses. We're not giving you anything that you have not heard from that witness stand. You have to listen to the things that come from the witness stand. You can't, as the judge has said, what we say is argument. In our questions even, our questions are not facts. So if you didn't hear it coming from a witness on the witness stand, you cannot consider it. It's the witnesses and the evidence that you heard that you need to consider. Okay, so right away you heard this has nothing to do with an Orbeez TikTok challenge. You had no evidence that the Orbeez were frozen. Those are things that the attorneys state in their questions. But that's not evidence. The evidence comes from the witness stand. So I just want to refocus you back on that and that concept. So I have to sort of address little things that come up, right? I'm trying to hit things. I may not hit everything in rebuttal, but this is our opportunity for rebuttal. I want to go first to the medical examiner. You know, the medical examiner stated in a question or an answer, yes, this could have been consistent with a punch to the mouth, one punch. This could have been consistent with a punch to the head. But he didn't say it was only one punch to the head and only one punch to the temple. It could have been consistent with numerous punches. So you have to remember, look at your collective memories. But from the evidence that you heard about the fight that occurred, how many punches were thrown? You can look at the evidence to his body, to Ethan's body, to help you figure that out. But you also have the boy's testimony. And we own, we don't, as prosecutors, tell our witnesses what to say. We try to remember, tell the truth from what you can remember. We don't tell them what to say. They're trying to, these boys coming in here, in front of everybody here, and trying to tell you what they remember from about a year ago, more than a year ago, when their friend died, when Ephraim's very good friend died. And we talked a little bit about it in jury selection. What could affect somebody's memory of an event? We talked a little bit about, how long the event happened. Was it really short? Was it very long? Was it traumatic? All those things could affect someone's ability to remember. Fear could affect someone's ability to remember. Nervousness up in court could affect somebody's ability to get every single thing correct. But we do know that all three of Ethan's friends, at first, in talking to the police, indicated and had been consistent with the fact that this was a 3-on-1 fight. That is not disproven anywhere in the evidence. All three of them said that. So that's definitely consistency. And they described the main, person who came over first as the guy with the dreads with the tints on the end. And we know from the evidence that that was Deshaun Stafford that came over first. How else do we know it wasn't Donovan Jones that came over first? You have the video. And the video shows he's the tallest one. And you're going to watch this video. I know you will. He's the tallest one, and he's not the first one that walks over. The tallest man there is Donovan, and he walks over to the car, to Ethan's car, last. So we know for a fact from that evidence alone that Donovan Jones is not the one that goes over and confronts Ethan. And we also know it from Deshaun's statement to you. So we talk about self-defense. Self-defense, as the judge is giving it, is going to instruct you, or I'm sorry, has instructed you, defines a different type of force that can be used. And one thing that you don't have here is a toy gun is not deadly force. The instruction reads basically that the defendant, in this case I'm talking about Deshaun, he did not have reasonable grounds to believe he was in imminent danger of death or great bodily harm. We submit to you that he does not. He did not have, that was not reasonable. It was not reasonable to think that a toy gun is something that you have to respond to with some kind of deadly force. And let's talk about how that went down. We all, from the beginning, we've owned that this prank that these kids did is a terrible thing. And Deshaun is upset about it. He goes over to Ethan and confronts him. We're not anywhere near self-defense here at all. He is going over there to confront Ethan. And maybe you think that's okay. Maybe you think, yeah, that kid should have gotten confronted. They should have been able to confront them about doing that stupid prank and shooting at them. But Deshaun made a choice to go over there to confront him about it. And we know that he is shot in the face, or shot in the chest, wherever he's shot, and he grabs the gun and he breaks it. Because you see it in the evidence that we submitted to you, in the pictures, it's broken, it's on the ground. He grabs it from Ethan, he throws it on the ground, and it's broken. Okay, let's go. I broke your gun. Jerk, why'd you come shoot at me? I took it, I broke it. I'm gonna walk back to the court now. No, that's not what he does. Now he punches him. Now we have a one-on-one fight. And again, if you want to, it's your choice as jurors to believe that, okay, maybe you should have punched him. Okay. But that is a one-on-one fight. But it does not stay that way. It escalates. Tyler's got to run over and get in the fight. Donovan's got to run over and get in the fight. How is that now a fair fight at all? It's not. It becomes an attack. Because now there's one person trying to fend off three people who are punching at him. It's Ethan who's walking backwards away from his car because they're coming at him 3-on-1. That, I submit to you, is where the self-defense argument falls away. It's 3-on-1. The victim is backing away. He's being sort of basically forced away from his car. His kind of sort of, he can get back there. He can be a getaway car, right? Let's hop back in and get out of here. But it's 3-on-1 coming at him, and he can't get back to the car. The defendants, there's the statement that they have to be serious physical harm is what is being caused here. And I submit to you that when Deshaun Stafford and Tyler are fighting and punching at Ethan, and he falls on the ground and gets knocked out, and Deshaun gets on top of him again and is punching him on the ground, way beyond self-defense. Way beyond self-defense. It's not self-defense at that point at all. The actions of the defendants during and after Ethan is knocked out, you need to look at that. We talked about what's going on in their heads. What are they thinking? You can look at their actions during and after the incident to see what they were thinking. And what did they do? After he falls to the ground and he's punched out, knocked out, they continue to retaliate. That's the word my co-counsel used, and I think that's exactly what happened here. They were retaliating because they were shot at by the Orbeez with the Orbeez guns. They were retaliating by going after Ethan. They were retaliating by grabbing phones and smashing phones and getting in the car and driving it away like Tyler did, and getting a phone from the car and throwing that phone on the ground. That's not self-defense, that's retaliation. They were angry at what happened, they were shot with an Orbeez gun, and they retaliated. Not self-defense. The Lamarian's testimony, he told you it was a 2-on-1 fight. He said it was the brothers, meaning the Staffords. The one with the color in his hair knocked him out. There it is. Lamarian said, and he had gotten out of the car, if you remember, and gotten a little bit closer to the fight to try to help until he was kind of like taken aback when one of the Staffords was going to maybe go after him. He was closest to the fight at that point, to the attack at that point, because that's what it was at that point. And he said the one with the color in his hair knocked him out. And we had testimony from detectives in this case that that person was Deshaun Stafford. So right there, Lamarian tells you who punched Ethan when he went down to the ground. Lamarian said Ethan was just trying to defend himself. And in fact, that's exactly actually what Mr. Gallick said at one point in his closing argument. Ethan was throwing punches to defend himself. Yep. Lamarian says both of them, both brothers, start stomping him. They're all stomping and kicking, punching him while he's on the ground. And it was Lamarian's statement about the ground and pound. And we said, what is that? And basically getting on top and punching him. It's that they're still doing that. He also said, Lamarian, that at the end, one of the two kicked Ethan really hard. Extra hard were his words. That they kicked him then, as he's on the ground, bloodied, as you have seen in the pictures, and they walked away. Serious physical harm. That's how he looked when he got on top of him to start, now not the blood on his chest here, okay? Maybe not the spit up blood, but his eyes and his mouth and his face looking like that when he got on top of him and continued to punch him. Knowing that you're going to cause, that serious physical harm has happened. Taking me back to the photo of Ethan with the mark on his chest area there, on the side, his flank. Consistent, as we know, with some kind of imprint from a blunt force trauma object. And you'll get this, and it's never really great on the photographs here on the screen, but you're going to get it and you can look at it, how it actually comes to kind of like a point. Medical examiner said consistent with like a sheet print. So Lamarian says, they kicked him. After the ground and pound, they walked away and said, pick up your man. When they couldn't pick him up because he was dead and he was too heavy. They tried. Mr. Sin repeatedly said that everything happened in the dark. But we know that it happened, the actual end of it anyway, the punch that dropped Ethan and killed him happened under that light pole. It wasn't in the dark, it was under the light pole. And Lamarian was right there watching it. And Lamarian tells you Sean's the one who threw that punch. The cell phones, I mean, I guess you gotta try something. So what if you got the cell phones? It's like a red herring. You needed to know what was said before and after. Well, we could never see what was said after because all the phones were broken on the ground after. All three boys, and Ethan's was missing. But who cares what they would have said on a cell phone beforehand? Hey, let's go smoke some weed. Hey, let's go meet up. That has nothing to do with what they did. Nothing. So I'm not sure why that's even brought up. That seems to be just sort of a red herring. The Exhibit 2 that we had here kind of shows the school and shows where Ethan's body was found. And just look, as co-counsel called it, sort of the debris field of this altercation. You know, it starts up here, and there's a broken gun on the ground, right? It moves away as he's moving towards the lamp, which is here, and Ethan's getting further and further away from his friends in the car, and you've got the broken part of the gun here, you've got his wallet, you've got his shoes that have come off during the fight. This shows, again, the intent here was not just, I'm going to punch you for shooting me with an Orbeez gun. The intent was and did cause serious physical harm. 2-on-1, 3-on-1. Not a fair fight at all. There was the instruction you heard about complicity. So basically, it doesn't matter who caused that final punch. If you were involved in the attack together, we heard that Deshaun's actually done fighting or assaulting Ethan, and he's walking away when Tyler calls him back over because he and Ethan are squaring up again, Tyler and Ethan allegedly, and that Deshaun comes back over to get back in the fight as 2-on-1 again. Never a fair fight. It was never, ever a fair fight. So when you're looking at the force used, there's lots of jury instructions on the force that can be used, but part of it is a definition of unreasonable force. A person is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger. The state must prove beyond a reasonable doubt that the defendant used more force than necessary and that the force used was greatly disproportionate to the apparent danger. That's what we're submitting to you, that the force used is way over the top to qualify for self-defense. In deciding whether the force used was greatly disproportionate to the apparent danger, you may consider whether the force used shows revenge or a criminal purpose. And that's what we believe that this was. Retaliation, revenge by the defendants against Ethan. In the beginning, ladies and gentlemen, you saw and you heard repeatedly the Orbeez gun, right? This is what apparently this young man lost his life over, was a toy gun. Because they got mad, they got angry that they shot at them, and they went to fight him and retaliated because of a toy. Because of a toy gun. You'll have it in the back, and you can look at it. You'll have the Orbeez little gel balls that are filled with water. I submit to you again, not self-defense, because they went way over the top. We are all responsible for our choices. Their choice was to walk over to Ethan and engage him in a fight that then went 2-on-1, 3-on-1. And I think I said it in opening, they may not have wanted to kill this young man. No, never said that. But they are responsible for their actions, which led to his death. And at the end here, ladies and gentlemen, I just want to thank you so much for your attention. I know it's been a really long day, but the state feels that we've presented the evidence that you can use to find the defendants guilty. And we ask that you hold them accountable, because again, we all make choices, even ones that are poor. And unfortunately, their choice to engage with Ethan, to continue to engage with Ethan, to fight with him across the parking lot, 2-on-1 and 3-on-1, caused his death. Thank you.
Thank you, Ms. Schucke.
Thanks, Judge.
All right, ladies and gentlemen, at this time, I'm going to give you a few more instructions, mostly related to your deliberations and how to conduct your deliberations. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media such as cell phones, telephones, tablets, computers, the internet, any internet service or any text messaging service, any internet chat rooms or blogs, websites such as Facebook, YouTube, or Twitter, to communicate to anyone any information about this case or to conduct any research about this case until after I accept your verdict. The fact that notes taken by a juror might support his or her recollection in no way makes his or her memory more reliable than that of jurors who did not take notes. All notes are confidential matter for consideration of the jury only, and all notes will be returned to the bailiff and will be destroyed when you are discharged as a jury. In your deliberations, you must not consider the subject of punishment. Your duty is confined to the determination of whether the defendant is guilty or not guilty. In the event that you find a defendant guilty, the duty to determine punishment is placed by law upon the court. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all the disputed questions of fact, to apply the instructions of the court to your findings, and to reach your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all of the evidence and make your findings with intelligence and impartiality, without bias, sympathy, or prejudice, so that the state of Ohio and the defendants will feel that their case was fairly and impartially tried. If during the course of the trial I have done anything that you might consider an indication of the court's view, you are instructed to disregard it. When you go into the jury room, your first function will be to select one of your fellow jury members as foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than others. He or she serves the purpose of helping you conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict forms and the exhibits are returned to the court after you have reached a verdict. Your initial conduct upon entering the jury room is a matter of some importance. It is not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you become convinced that it is wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after considering the case with your fellow jurors. Do not hesitate to change your opinion if you are convinced that it's wrong. However, you should not surrender honest conviction in order to be congenial or to reach a verdict solely because of the opinion of the other jurors. The court is going to place in your possession the exhibits that have been admitted during the trial and the verdict forms. As I have already stated, the foreperson that you elect will return them to the court. If and whenever you wish to view any of the electronic exhibits, the court instructs you that they must be played on a computer by and under the control of a bailiff or other person designated by the court, rather than by a member of the jury panel. Please make your requests accordingly. If you wish to view those exhibits, my bailiff will assist you in viewing those on a computer. Until your verdict is announced in open court, you are not to discuss with anyone else the status of your deliberations or the nature of your verdict. The ultimate aim of jury instructions is to help all of you as the jury, and a written copy of the general charge should assist you in that function and avoid most, if not all, questions during deliberations. Therefore, and as I have stated, I will place in your possession copies of the court's instructions of law for your use. If during your deliberations questions arise concerning my instructions, the law, or the evidence, I may, under certain limited circumstances, furnish answers to them. Any such questions should be reduced to writing by the foreperson, indicating specifically what is requested and must not reveal the status of your deliberations. The foreperson must also sign any such questions. You should then notify my bailiff using the buzzer in the jury room, and she will retrieve your question and deliver it to the court. Now, jurors sometimes ask to see transcripts, additional documents, or evidence. Please know that you will have with you all of the evidence and documents that have been admitted as evidence for your review, and you will not be given any additional documents or other evidence, and that you will not be able to review any transcripts of the testimony. After you have retired, select a foreperson, and whenever all 12, and I will repeat, whenever all 12 of you agree upon a verdict, sign the verdict forms in ink and advise my bailiff by using the buzzer in the jury room. She will then return the jury to the courtroom for the verdict. I'm now going to review with you the verdict forms. The verdict forms are in this orange folder. They should remain there and be returned to the court in the orange folder. There are 6 verdict forms. As we have discussed, there are 4 counts that apply to Deshaun Stafford and 2 counts that apply to Tyler Stafford. So you need to consider each of those counts separately as to the charge and as to the defendant. I'll go through the first one with you in a little more detail. There is a heading at the top. It says count 1, involuntary manslaughter based upon aggravated assault. This one refers to the defendant, Deshaun Stafford. And it says, we, the jury, being duly impaneled and sworn, do find the defendant, Deshaun Stafford. Then there's a blank and an indication, a direction to insert in ink either guilty or not guilty of the offense of involuntary manslaughter as a proximate result of committing or attempting to commit aggravated assault. It goes on, we do so render our verdict upon the concurrence of 12 members of the jury. Each of us said jurors concurring in said verdict signs his or her name hereto. This, and there's a blank for the date that you reach your verdict, the day of September 2023, and then there are 12 signature lines for the 12 jurors who agree with the verdict form as it has been completed. So there's count 1, involuntary manslaughter as it relates to Deshaun Stafford. Count 2, aggravated assault as it refers to defendant Deshaun Stafford. Count 3, involuntary manslaughter based upon assault as it applies to defendant Deshaun Stafford. Count 4, assault as it applies to Deshaun Stafford. And then count 3, involuntary manslaughter based upon assault as it applies to Tyler Stafford. And count 4, assault as it applies to Tyler Stafford. When you have reached your verdicts, fill out the jury forms as if they correspond to your decisions. All members must sign the forms in ink, then signal the bailiff, and you will be returned to the courtroom to render your verdict. Counsel, any further additions or corrections to the jury instructions?
No, thank you.
Renew my objection.
Correct. Objection is renewed. All right, I do have 3 alternates. Ladies and gentlemen, you were selected to serve in the event of a misfortune to a member of the jury panel. At this time, it will not be necessary for you to serve further. However, you are not to discuss this case or tell anyone how you would have voted. You are not to investigate the case in any way. You will be released from that instruction after the jury has returned a verdict. So before you leave, I will ask that you give my bailiff your contact information for several reasons. First, if there would be an emergency, if an emergency would arise before the jury has reached a verdict, we may need to contact you and ask you to return to court. So until we have a verdict, you are still on call in case there might be an emergency. Also, my bailiff will notify you when the jury has reached a verdict so that you then will know when you are free to talk to other people if you would like to about the case. And also, since you've been here all week, you probably want to know what the ending is. So we will call you and tell you when the verdict has been reached. So when I dismiss the jury. If you would give your contact information to the bailiff, and then you may be excused for the afternoon. Ladies and gentlemen, it is just after 4 o'clock. I'm going to recess here momentarily for you to begin your deliberations. As we discussed at the beginning, we generally don't go longer than 5 o'clock, so between 4 and 5 is when we like to recess. It's also when the courthouse officially closes. It has been a long day. Your schedule at this time is now up to you. So you may take breaks, you may recess at your discretion. However, I would ask if and when you take any breaks that you just buzz my bailiff and tell us what your plan is, if you're going to take a 10-minute break or you're going to take a lunch break or whatever your plan is, so that we know where everyone is. As I said, it has been somewhat of a long day. There are jury instructions, numerous exhibits, and some important issues to deliberate. So if you would like to begin your deliberations now, I would suggest that you pick a jury foreman and then kind of collectively make a plan as to how you would like to proceed. If you would like to get started for the next hour or so, you may do that. If at this time you would like to recess and return tomorrow morning, that is acceptable as well. But as I said, just kind of let us know what your plan is. Once we recess, after a few minutes, you will get delivered to you all of the exhibits in this case, as well as numerous copies of the jury instructions so that you can refer to those during your deliberations. And one last thing, tomorrow, if we return in the morning, again, you can decide if 8:45 is too late for some of you or too early for some of you. You can decide when you would like to return tomorrow morning to begin. But you will not be in my jury room. There will be other proceedings in this courtroom tomorrow. So before you leave, my bailiff will show you where you should report tomorrow morning for those deliberations. Anything further from counsel? And once again, obviously there has been continued media coverage here, so you are once again instructed that you are not to view any media, avoid any media related to this case.
All right.
And there we have it. The case is now in the hands of the jury. The fate of Deshaun and Tyler Stafford in the hands of 10 men and women in the Summit County Courthouse. They will begin selecting a jury foreperson today, and then they can decide if they're going to recess today or start deliberations. It's entirely possible they start deliberations. I'm going to take a look here as we see the Attorney Sands put his arm around Deshaun, trying to give reassurance, possibly explaining the process.
So we'll let you know when the jury's going to come back once we know that.
Question by, looked like a question by Tyler asking when they will know if there's a verdict and that call will come in. There's a little bit of confusion. You heard the judge say she has other items in her courtroom tomorrow. This particular judge does not hold sessions on Thursday. So one question I had is, let's say the jury comes back, starts deliberating in the morning, and by noon they say they have a verdict. Will they wait until she is back in court on Friday? More than likely that's what they would do, but we can't say that for certain. So we are on jury watch in the death of Ethan Liming. This, of course, happened back in June of 2022 at the I Promise School when Ethan Liming and his 3 friends decided to use a splatterball gun on 3 young men playing basketball at the LeBron James I Promise School basketball courts. And it has led to this. We see family giving hugs to both Tyler and Deshaun, and I do believe the woman in the sweater is the woman that we've heard a lot about in this case. That was the 4th person who was on the basketball court who would have been a witness, but when she was asked by detectives if she would like to talk and tell her side of the story, she declined. They even pointed her out in the courtroom as to who she was. She is Tyler's girlfriend, was at the basketball courts that night, but she did not give a statement, and they did not feel that she could lend anything. Otherwise, they could have subpoenaed her to find out what her side of the story was. So we'll leave that right there. It is now in the hands of the jury, and all along I've said I wanted you to put yourself in that juror box. How do you see the case now? How do you see the case heading into that deliberation room? We heard from the defense say that this is all a part of the system, that Ethan Liming was a popular athlete from a good school, and that the prosecution and the police chief needed somebody to go down for this crime. That 99 times out of 100, when there is a fist fight, you get your child back, but you did not get Ethan Liming back in this case, and therefore, according to the defense, they went out and rushed to judgment. And when we saw Deshaun give his explanation in the interrogation room, according to the defense, they said that's it. That there is the confession. They did no further investigating. That's why they didn't look into cell phones. They never found Ethan's cell phone, and that was it. But according to the prosecution, that's all they needed. They needed a confession. They have one in Deshaun saying he's the one who delivered the punch that, as Deshaun said, put him to sleep. And we know it was that punch that put Ethan to the ground, that hit his head on the pavement, and that it was that injury that ultimately killed Ethan, either within seconds or just a matter of minutes after he hit that pavement. We heard a lot of talk about the kicking, the stomping, the punching, that even Deshaun admitted to investigators that he punched Ethan twice while he was already down on the ground. That is, according to the defense, that's immaterial, that Ethan was already dead or dying, so it doesn't matter who kicked him in the side, whose shoe print is partially on Ethan's chest. The punches that could have been laid after that caused the split eye, the split lips, that those punches don't matter. Well, not according to the prosecution. The prosecution says that shows revenge, that these young men were mad for getting shot with the splatterball gun, and revenge, yes, takes away the self-defense argument, especially when you start looking at how much force was used. Was it appropriate to continue to hit him or kick him if this was just self-defense? This is not now all up to the jury. We have had gavel-to-gavel coverage. We will continue to have gavel-to-gavel coverage. As soon as we see a verdict is reached, we will have coverage yet again. Will that be tomorrow? Will that be Friday? Will this stretch maybe into the weekend or next week? It is all up to the jury. If you have missed any of our coverage, you can go back to cleveland19.com. You can check out the coverage there. If you are a Roku user, you can go to the Cleveland 19 News app on Roku. Once you open up the app, you will see a menu on the right-hand side. Scroll down to the Ethan Liming trial. Every day of the trial, every witness, our gavel-to-gavel coverage is right there. Until there is a verdict, we will be wrapping this up. Stay with Cleveland 19, and this is where having the Cleveland 19 News app is beneficial. When we find out there is a verdict, we will send out a push alert that says a verdict has been reached in the I Promise School death case, and we will be live a short time after that. They generally give a half hour to an hour heads up before we get the verdict. So until then, I'm Dan DeRose with 19 News Now. Have a good evening.
News is everywhere. Download our CTV apps and